I have filed this petition in December, my lord. I filed this petition in December, my lord. That is attachment posted, my lord.
Informed all the advocates. If you write the urgency, it will be considered.
Please,
That whatever the memos in urgency were written on,
please.
so it's all for to be written on the memo.
Warrant put against petitioner, my lord.
Huh?
Warrant has been put against the petitioner. So.
That's what, if you mention it, it
Please,
will come.
please, I mentioned, my lord.
Yes.
Please.
Lord, yesterday, Lord, by submitting, Lord, a memo was moved, but it was not listed today.
Sir,
Lord,
if the memo, if the urgency is mentioned, all the matters are
urgency
listed.
yesterday was also mentioned, Lord. The tender matter is going to be lapsed, Lord. Tender accepting authority.
My Lord, one CPC fresh matter, my Lord. Matter is posted for judgment day after.
What is the urgency for
It
it?
become infructuous, my Lord.
What? We will not entertain it.
My Lord,
CPC, when is the petition filed?
yesterday,
Huh?
yesterday,
If you complied with office objections, it would have come by this time.
yesterday it was filed, my Lord. Kindly have it tomorrow, my Lord. An impleading application, a partition suit.
Oh, it will come tomorrow. No out of
Please,
the list
please.
matter. Yes.
GMCPC matter, my lords.
Give it to the court.
My lord,
officer.
it is 24 matters. I request, my lords, because they respond, even though interim order respond is not allowed to cultivate the land, my lords.
So what is to be done?
My lords, that is why I want to, it's a Lok Adalat order, which is,
The court
my
officer, I
my
won't
lords,
hear any of
next
the
week, any
mentions.
date, my lord, please. Next week, any date.
The urgency, it will be seen.
Next week, any date, please.
One matter, my lord, one matter at the end of the list.
Why?
My lord, it's a forest and privileged land, my lord.
Whatever
Where
it is. No
my
urgency
building,
for the end of
No,
the
no.
list. I'll take it up tomorrow. If it is a fresh matter.
if fresh, my lord, they are dispossessing me. I am in cultivation from last 70 years, my lord. I have my buildings. It's a privileged land and.
What did they do?
Huh?
What did they do?
No, they come to the property, they dismantle from last 2 days, my lord. From last 2 days they are coming, they dismantle the walls and all, they go away. I asked them for an order. I made a representation, give me an order at least.
I'll ask the government, the HCGP to get instructions. If what you're submitting is not correct.
No,
I'll discuss
I'm
it
ready
with
to
the-
file affidavit also to that extent, my lord.
Yes. End of the list. Give the, serve the papers on the, where is the AGA?
AGA.
Get instructions in that matter.
Yes, please.
Yes.
Tomorrow, my lord, for the
Why special treatment for you? Give it to the court officer. Don't make a mention. Yes,
Urgency, urgency.
urgency.
Put it, please.
Whatever it is, write the
Put it,
urgency on the paper.
Put it there.
Yes, next, call the list.
my lord, 213.
List number 1.
Lordship, one submission, your lordship.
Yes,
List 2, serial number 1,
he will call.
please.
Page
Yes.
wise adjournments. Page number 2, serial number 4. Page number 3, 5 to 11.
My lord, serial number 5. The counsel on record, the petitioner advocate is not keeping well.
Huh?
Necessary.
Petitioner advocate is not keeping well.
He's not keeping well.
Yes.
Have you informed? There is no, this is matter after 2 weeks at the request of counsel petitioner. Yes.
Page 4, serial number 12. Page 5, 13 to 15. Page 6, 16 to 24. Page 7, 25 to 32. Page 8, 33 to 39. Serial number 38, my lord. 38.
Respond number 3 has died. 2 weeks time is granted to take steps.
38.
Orders we will call it.
Please.
Yes. Start from admission.
Petition. Page 16, 65 to 68. Page 17, 69 to 74. Page 18, 75 to 78. Page 19.
70.
Sev-
75.
75.
The parties are likely to settle the matter. Last time also we had made a submission because of some other proceedings. They need about 3 weeks time.
I'm for the respondent.
Yes, at the request, is this matter after 3 weeks?
There's an interim order undertaking given by the respondent.
Interim order earlier granted, if any, is extended in the next state.
Please.
Yes.
Okay.
Page 19, serial number 79 to 83.
Lord, serial number 79, there was a direction for me to get instructions whether the party has settled the matter. I could not get any instructions. I requested on Monday, my lord, either I will go with the matter.
I'm for the
I
respondent.
requested on Monday, my friend.
This is what is happening from the
No,
last.
sir, no,
few
Lord, sir.
cases.
I had addressed the letter.
So if you have not, I'll say I'll record the submission of the respondent. In case if you get instructions, you can review the petition.
No, Lord, I am only requesting, Lord, Monday. It could be disposed of. If my party has satisfied with that amount, I will withdraw it. Otherwise, my lords, I will get that is only. They made a submission. In the EPMI file, party has filed application, she is not interested to prefer appeal.
This is matter finally on Monday as part, on Wednesday as part heard. No further time will be granted. Yes.
Fine.
Yes. List to refer to the mediation.
My lord, one.
List to one matter has become infructuous, my lord.
Which one?
Serial number 9, my lord. Serial number 9 has become infructuous. It may be dismissed as infructuous. I am for the petitioner.
It is submitted that the matter has become infructuous on the same.
9, second list.
Accordingly dismissed, yes.
Seal number 8, my lord. First respond that who is the contesting party, I have to take steps, my lord.
Which case?
Seal number 8, second list, my lord. Seal number 8, first respond died, my lord, who is the contesting party. 2 weeks, I informed them.
No, all are served in this.
First respond died, he is the contesting party. I informed the other side, my lord. 2 weeks time, some steps have to be taken.
It is for referring to the mediation, the matters are listed.
If the parties are, the parties are no more, first respond,
No more.
first respond is no more. Therefore, I have to take steps, my lord.
When he died,
Well, just yesterday only I came to know, in the month of August of the
admitted that the
2000.
first respondent is no more. The petition will take steps, delete from this list, this is matter after 4 weeks.
Lordship, serial number 1, your lordship, list 2. Respondent number 1 died, your lordship.
Huh?
Respondent number 1 is died, your lordship. I for respondent.
In one, it is submitted that the respondent number one is no more, and for steps, request time, list this matter, after 4 weeks. Yes, next.
Interim order. Interim order.
Interim order only granted is extended. Yes.
Serial number 2.
No, these are all going before the mediation.
Mediation, but next date of hearing is there, my lord, there.
Interim order granted is extended, leave this place this matter, refer to the mediation, yes.
Great.
Lordship, serial number 4, lordships, in list 2.
Yes,
Serial number 4, lordships, in list 2. I will take steps to R4, lordships. R4 is not served yet. Lordships, may I request to take a hand summons to the council who are appearing for behalf of the R4 in the connected matter, lordships.
why is it posted for referring to the local adalat?
Lordships,
Then council
matter may not.
Hand summons on the council appearing for the respondent and file a memo to that effect. This is matter after 2
Lordships, in
Serial
criminal
number-
RP number, lordships, may I record the RP number, lordships.
Yes.
Case
Number 2.
Not required.
Serial
Please.
number 2, my lords. I'm seeking for a short. Serial number 2, list 2.
Well, you don't want mediation.
Please, my lords.
Have you seen at least the caption why they are listed? Yes, all other matters refer to mediation.
My lord, end of the list, my lord, one matter urgency, my lord, delivery warrant issued, my lord, today.
When was the order passed?
Yesterday, my lord, yesterday filed a writ petition, my lord.
When was the delivery warrant?
Yesterday, my lord, delivery warrant issued yesterday.
Delivery warrant was issued yesterday, writ petition was also filed yesterday.
Filed yesterday, my lord.
Take it, end of the list, I'll see. When is the order passed?
End of the list.
Yes, call the list.
List number 1 for dismissal, serial number 1.
Lord, I
Sunil Desai.
seek apology, my lord. Last date I could not be there.
Yes.
Lord, the first submission is that this is the writ petition, first writ petition is arising out of a KID 53. But my lord, this is a common order in respect of KID 50, 51, 52. The other 4 writ petitions are there. If lordships can you take it to tomorrow of all the connected matters, my lord? It is a common order by the KID, labor code.
Can't be argued independently.
Both all the common, my lord,
No,
it
what
affects, my lord.
What follows in one petition will follow in the other petition.
No, this is a different set of facts without, but however, all of the persons were being continued from the KMC to demands. So there will not be any conflict, my lord. That is why I request. I will give a number, my lord, your
It's a
lordship.
matter from the caption dismissal list after 4 weeks.
No,
Yes,
from
go.
2018, they have not paid any amount. They have
Number
kept on dragging the matter. It was already dismissed for once non-prosecution, again restored. And all the parties are different in all the 4 petitions. Common order, I am not
I
disputing.
understood that. List this matter on Wednesday under the same caption.
Please,
Along with so-and-so
along
matter.
with the same, it can be done.
Yes, give the file. Next.
Serial number 2, J. Shetty.
We are for the respondent, your lordship.
And for the
Yes.
petitioner.
The suit is for injunction. Malad, based on Malad, the gift deed Malad executed by the, in fact, Malad, wherein Malad, the application for temporary injunction is sought for, that Malad, the dependent is trying to Malad, encroach upon the property belonging to the petitioner and trying to put up the concession. And Malad, the trial court Malad, though Malad held that Malad, it is a matter required to be Malad decided in a trial. So far as the issue number 1 to 3 is concerned, it's held that Malad, for the time present Malad, it could not be considered whether the prima facie case is made out or not. And but granted an order of injunction on the ground of hardship. That if suppose Malad, the plaintiff succeeds in the suit, right, if the dependent is allowed to put up the concession, he will be put to great hardship and loss. And as such, Malad, the trial court granted the order of injunction. But appellate court Malad reversed it solely on the ground that Malad, there is an earlier suit where which has been decided against the plaintiff. But in fact, the earlier suit.
Come to the appellate court's order.
But in, Lordship may kindly see the page number 37, para 27. 36 minutes, para 25. On perusal of the judgment passed in OS number 52 of 1998, it appears that the suit filed by the plaintiff herein against the dependent herein for permanent injunction was dismissed by the civil judge and JMFC court Harapanalli for the reason that there is a variation of measurements in the document produced by the plaintiff. It is an admitted fact that against such judgment and decree passed by the civil judge and JMFC court Harapanalli in OS number 52 of 1998, the plaintiff had filed an appeal in RA number 32 before the senior civil judge court Harapanalli in RA number 32 of 2006. The said appeal was also dismissed by the appellate court. Further, it is an admitted fact that as against the said judgment and decree passed in RA number 32 of 2006, no appeal has been filed by the plaintiff. Hence, it is clear that the judgment and decree passed by the civil judge JMFC Harapanalli in OS number 52 of 98 has reached its finality. The learned counsel for the dependent argued that the plaintiff earlier had filed a suit for permanent injunction against the dependent in respect of the suit scheduled property. Now she has filed the present suit against the dependent in respect of the same scheduled property, and the suit of the plaintiff is hit by principles of res judicata. It is pertinent to note here that, as stated above, earlier the plaintiff had filed the suit against the dependent herein for the permanent injunction in OS number 52 of 98, but she has filed the present suit against the dependent for declaration of her title in respect of the suit scheduled property. Hence, relief sought in the earlier suit and present suit are dependent. And in fact, the earlier suit was dismissed solely on the ground that Malad, the measurement in the plain schedule was not given, and that's why Malad is dismissed. And the principle of res judicata is not applicable to the case. The learned counsel for the plaintiff vehemently argued that though the dependent has no right, title, or interest over the suit scheduled property, she is trying to encroach upon the plaintiff's property and trying to dig a foundation adjacent to the plaintiff's property towards the southern side of the suit scheduled property. According to the plaintiff, her property shown in the plain search is ABCD, and the illegal construction of the dependent's property is shown as CDF, and proposed illegal construction of the dependent is shown as DECF in the plain tense page. Further, according to the plaintiff, the dependent has not obtained a license for the TMC Harapanalli. The dependent, without obtaining license and without bifurcating the measurement of the property, started illegal construction work. It is pertinent to note that the dependent has produced a notice issued by the TMC Harapanalli dated 9/3/2022, wherein it stated as follows. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹರಪನಹಳ್ಳಿ ಪಟ್ಟಣ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರ ವಾರ್ಡ್ ನಂಬರ್ 4ರಲ್ಲಿ ಕೊಳಚೆ ನಿರ್ಮಾಣ ಮಂಡಳಿಯಿಂದ ಮನೆ ಕಟ್ಟಡ ಕಟ್ಟುತ್ತಿರುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖಿತ ಮನವಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತೇವೆ. ಹಾಗೂ ನಿಮ್ಮ ದಾಖಲಾತಿಯನ್ನು ಪರಿಸಲಾಗಿ ನಿಮ್ಮ ಖರೀದಿ ಕಾಗದದಲ್ಲಿ ಜಾಗದ ಅಳತೆ 1150.63 ಮೊಳಗಳಷ್ಟು ಇರುತ್ತದೆ. ಮುಂದುವರೆದ ನಿಮ್ಮ ಖರೀದಿ ಕಾಗದ ಪತ್ರಕ್ಕಿಂತ ಕಡಿಮೆ ಸ್ಥಳದಲ್ಲಿ ಅಂದ್ರೆ 31.6 ಚದರ ಮೀಟರ್ ಮಾತ್ರ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟುವುದರಿಂದ ಕೊಳಚೆ ನಿರ್ಮೂಲನಾ ಮಂಡಳಿ ನಿಯಮವಂತೆ ಕಟ್ಟಡ ಕಳ್ಳರು ಈ ಕಾರ್ಯಾಲಯದಿಂದ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಇರುವುದಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. In fact, no permission has been obtained, no sanction plan has been obtained, but in spite of the one letter has been said to have been produced before the court, saying that Malad, the measurement as stated by the dependent is Malad in respect of Malad 11.5 cubic feet as well as my lord 63 cubic. But my lord, as the dependent is my lord trying to put up the construction only in lesser portion, that's why my lord, there is no objection for construction. Then my lord, then another ground, my lord, page number 35, my lord, 43. The above decisions are applicable to this case. Here in this case, at this stage, this court cannot come to the conclusion that whether dependent is constructing the building by encroaching the plaintiff's property or not. It requires full-fledged trial. As per the schedule shown in the plaint, the dependent's property comes towards the southern side of the plaint schedule property. Therefore, it is clear that both the plaintiff and dependent's properties are dependent. As per the notice issued by the TMC Parapanalli, the dependent has started construction within her property. The trial court has rightly observed that at this stage, if the construction is stopped, dependent will be put to irreparable hardship.
I've seen.
Yes. But on this ground, Malad, the trial court, Malad, allowed the appeal filed by the
The trial court, appellate court's order.
Malad, if Malad, she is allowed to Malad put up the construction. Malad, the question is, Malad, as per Malad, I have produced the document to show that Malad, I am in possession of the property and Malad requires to, it is based on the registered gift deed. Particularly, Malad, the earlier suit which has been dismissed solely on the ground that in plain schedule,
So order 2, rule 2, you can't file another suit.
Malad, it is a suit for injunction. Malad, that is permitted.
Injunction in respect of the same property, in respect of the same defendant.
Yes. Now, Malad, this is suit for declaration injunction.
Whatever.
Malad, declaration that Malad based on Malad, my title has to be established. Malad, based on Malad gift deed. Malad, gift deed has been produced. And Malad, wherein Malad, if suppose Malad is allowed to Malad put up for construction, Malad, during the pendency of the suit, Malad, I have made a prima facie case. But notwithstanding that,
He has also made a prima facie case with regard to his property.
Malad,
Now
no
the
documents.
issue is about encroachment that can only be decided by
Full-fledged trial. Yes.
So at
Till
this
then,
stage,
Malad,
no,
ultimate.
if you are unsuccessful in the suit, you can't be
No,
compensated.
ultimate Malad, aim of Malad, the granting of injunction is to maintain status quo.
Court comes to the conclusion that
No, no.
it is your property, court will direct them to remove the encroachment. So no hardship to you. Hardship is to him. So court has rightly balanced the
The
inconvenience.
ultimate Malad, so far as granting of injunction, what is required to be considered is Malad to regarding the maintaining of the status quo till the disposal of the suit. Malad, now, Malad, if it is she is allowed to Malad put up the construction, notwithstanding the not Malad obtaining the necessary license from the competent authorities. But the only it is stated that Malad they no having no objections.
Without a permission from the competent authority, if is making construction, you know what to do.
Malad,
Approach
yes,
the municipal authorities
Malad, that's what Malad I am saying. Malad, now, by virtue of a letter which is said to have been issued by the chief officer saying that Malad construction can be Malad, whatever Malad, my interest Malad is required to be
If I
protected.
may be permitted to submit, your lordship, for a moment, wherein your lordship, even the trial court has also answered that, your lordship, in page number 77 of the petition, para number 17.
Yes.
If I may be permitted to read, the learned counsel for the defendant has drawn an attention for the court to the gift deed on a careful perusal of the same. There is overwriting on the document in respect measurement of the property towards the east, west, and already in respect of the suit schedule, a property suit was dismissed on the ground of a variation measurement. As well as, your lordship, may I seek your lordship your attention, memo dated 24/6/25 that I have filed. Wherein, your lordship, I have produced both suit order copy as well as, your lordship, appellate court order. Wherein, your lordship, issue was particularly framed at page number 5 of my memo dated 24/6/25. The second issue was itself is, your lordship, whether the plaintiff proves that the interference caused by the defendant. That was answered as negative. Also, as well as against on the measurement, your lordship, based on the gift deed that was not proven, as well as it is a rewritten. Hence, your lordship, the suit has came to be dismissed. That they have challenged through regular appeal. Wherein, your lordship, that also confirmed the suit order. They have not challenged through second appeal. Now directly causing the res judicata.
All
Please.
that. Please come.
Please, sorry, Your Lordship. Please, Your Lordship. As well as Your Lordship, para number 19 of the appellate court order, page number 29 of the petition.
When I'm dismissing the writ petition, for the sake of
Please.
argument, if you want to argue, I can't help
No,
it.
Your Lordship, sir. There was some confusion. If Lordship is convinced, grateful.
My only request is, my lord, my interest is also required to be protected by making necessary.
The writ petition is fine. Questioning an order passed in MA number 4 of 2022. Which is the MA now?
My lord, MA is, my lord, two MA. My lord, one is by me against the, my lord, certain findings, my lord, in the original suit. Some of the issues has been, my lord, points, my lord, decided against me. As such, I have filed a separate MA, MA5. And MA4 is filed by the other side. My lord, it is against the grant of injunction. Both have been clubbed together, common order has been passed.
Agreed with orders passed in MA number 4 of 2022 and MA number 5 of 2022, dated 22nd June 2022. The plaintiff is before this court. The petitioner herein, who is the plaintiff, has filed the suit seeking a declaration that the plaintiff is a owner and possessor of the suit Schedule A property as mentioned in the plain sketch, and seeking an injunction restraining the defendant from interfering with the peaceful pursuit and enjoyment of the plaintiff, and also not to dig a foundation over the suit Schedule B property. And along with the suit, he has also filed I number 1 seeking injunction restraining the defendant from interfering with the peaceful pursuit and enjoyment of the plaintiff, and also not to dig foundation and not to construct the illegal building or the petition Schedule B property as mentioned in the plain sketch. It is a case of the plaintiff that one Kulmi Fakuruddin Saab was the owner and possessor of the suit Schedule properties, and he has 3 sons. One of the sons' name was Ismail Saab. The said Ismail Saab had a wife by name Utijabi. Both of them, they are blessed with a daughter by name Kulumi Ashabi, that is the plaintiff in the suit. The daughter and the father and mother had got divided their properties equally, and the same as mentioned in the plain sketch. They have executed a registered gift deed dated 26/6/1979 in his favor in respect of the suit A Schedule property. On the basis of the registered gift deed dated 26/6/1979, his name is mentioned in the demand register extract as owner and possessor of the suit Schedule property. Earlier the property was covered with a zinc shed roofed mud house, and now the said house collapsed, and at present the suit Schedule property is a vacant site bearing old door number 577 and new door number 508/577/408, measuring east-west 13.71 meters and north-south 6.85 meters, situated at 13th Ward, Pattanagere in Harapanahalli town. It is the case that earlier he has filed OS number 52 of 1998 against the very same defendant seeking injunction, that came to be dismissed on the ground of variation of measurements in the records and description of the suit Schedule properties in the plaint. Against that, RA number 36 of 2006 was filed, and the same was dismissed, confirming the judgment and decree of the trial court. It is a case of the plaintiff that he is in possession of the property even till today, and in the earlier court proceedings, the defendant has not denied the existence of the property. The defendant, whose land is situated So to the southern side of the suit property, is trying to dig this property and trying to lay a foundation adjacent to his property and trying to evict the plaintiff from the suit scheduled property. In this regard, he had also lodged a written objection before the TMC Harpanhalli on 8/2/2022 and requested his authorities to stop the illegal construction. Hence, the plaintiff has sought for injunction. It is the case of the defendant that he has purchased the property from one Ajjabi for consideration of an amount of 1,000 to register sale deed. On the basis of the sale deed, the defendant did disposition of the property. Out of the said property, the Karnataka Slum Development Board has sanctioned the house permission measuring east-west 14 feet and north-south 24.27 feet after verifying all the records. The defendant has not encroached any portion of the plaintiff's property and he has filed the suit with an intention to harass the defendant. The trial court, by order dated 5th March 2022, has granted injunction. While granting injunction, the court has observed that the court has observed that the gift deed discloses that there is overwriting on the said document in respect of the suit property towards east-west, and the same is shown as 30 feet instead of 20 feet. And also boundary of the said property mentioned towards southern side, there is open space which belongs to Masuti. As per the plain schedule towards southern side, the property of defendant is situated. Now the point for consideration is how much area the defendant has encroached the suit property, and according to pleading, her elder, the mother of the plaintiff, sold property in favor of the plaintiff. But gift deed discloses that the suit schedule A property was sold by Uteja B, wife of driver Nazir Saab, in favor of the plaintiff. So who sold the suit property in favor of the plaintiff and who are in actual possession of the suit property? How much area the defendant has constructed house by encroaching the suit property has to be decided by the court after a full-fledged trial. On perusal of the photographs, it discloses that the construction is going on. The defendant stored man and material of the suit property. At this stage, if the construction is stopped, it is the defendant who will put to irreparable loss, hardship and injury. Therefore, the documents produced by the plaintiff are not sufficient to grant injunction. Hence, court of the opinion, if the plaintiff succeeds to prove the case that the defendant has encroached suit property and constructed the house, in such circumstance, defendant has to hand over encroached area by demolishing, which is encroached area, considering all these facts. In case ad interim injunction is not granted, no hardship, any injury would be caused to the plaintiff. And the court felt that at this stage, the plaintiff failed to make out prima facie case, and as such, the balance of convenience does not lie in his favor. Then, when it comes to and accordingly, what What is this order of the trial court?
In fact, findings, my lord, against
Are
me.
against you and it grants
Ultimate order is,
injunction.
my lord. That's why I also filed the appeal.
The court has felt that there is no prima facie case, balance of convenience, irreparable loss, and all the issues are answered against the plaintiff. But in the order portion, it is IA number 1 filed by the plaintiff under order 39 rule 1 and 2 is allowed. The defendant is hereby restrained from not to dig foundation and not to construct the illegal building over petition schedule B property. Agreed thereby, both the plaintiff as well as the defendant, both have filed MA number 4 and 5. The appellate court had dismissed the appeal filed by the plaintiff and allowed the appeal filed by the defendant, that is MA number 4 of 2022. While allowing the appeal, the court has observed that at this stage, the court cannot come to the conclusion whether the defendant is constructing the building by encroaching the plaintiff's property or not. It requires a full-fledged trial. As per the schedule shown in the paint, the defendant's property comes toward the southern side of the paint scheduled property. Therefore, it is clear that both plaintiff and defendant properties are different. As per the notice issued by the TMC, the defendant has started construction within her property. The trial court has rightly observed that at this stage, if the construction is stopped, the defendant will be put to irreparable hardship, loss, and injury rather than the plaintiff. Though the certain documents are produced by the plaintiff, the documents do not disclose that the defendant is constructing the house by encroaching the plaintiff's property. And as rightly observed by the civil judge and JMFC, the plaintiff has failed to show the prima facie case and balance of convenience does not lie in his favor. The court has also observed how all the issues are held negative against the plaintiff and how an order is passed and accordingly has passed the order. When counsel appearing to the petitioner submits that by placing all the documents, he could demonstrate before the court that he has a prima facie title to the property. And if the construction is made by the defendant, it would cause a lot of hardship to the plaintiff. Having both the courts have failed to appreciate the said fact, it is submitted that if the injunction is not granted and he proceeds with the construction, the valuable rights of the petitioner will be put to a lot of hardship. This aspect has failed to, both the courts have failed to consider. It is submitted that he has established a prima facie case, balance of convenience and irreparable loss, which were not considered by the courts. Next parallel, counsel appearing for the respondent, defendant submits that the trial court, having given all findings in favor of the defendant, however, has granted injunction. The appellate court has rightly appreciated all the aspects and particularly with regard to the discrepancy in the gift, with discrepancy and overwriting and in the gift deed, and had rightly allowed the appeal filed by the appellant, filed by the defendant. It is submitted that there are no grounds to interfere with the well-considered order passed by the appellate court. Next paragraph. Having heard the counsels on either side, peruse the material on record. The suit is filed for declaration and injunction. Along with that, he has filed an IA seeking interim injunction. When an application is filed seeking in the interim injunction, the burden lies on the plaintiff to show that there is a prima facie case and a balance of convenience. And if the injunction is not granted, it would cause irreparable loss to the plaintiff. Here, in this case, plaintiff is alleging his right to the property based on a gift deed. The respondent is also alleging the right to the property basing on a registered document. It is an admitted fact that both of them are neighbors. It is a case of the plaintiff that the defendant is encroaching the property and making the construction. While granting injunction restraining the defendant from making constructions, In a case of this nature, the prima facie title of the plaintiff is not relevant, as according to both the plaintiff and the defendant, they are the owners of the properties based on certain documents. Now, the issue that has to be considered by the court is whether there is any material before the court to show that in the land belonging to the plaintiff, the defendant is making any constructions. The appellate court as well as the trial court has rightly observed that at this stage, the court cannot come to the conclusion that the defendant is making construction in the land by encroaching the land belonging to the plaintiff. They have already, the municipality has already granted permission, and according to and petition has given a complaint stating that without any permission, he is making construction. That would be addressed by the local authority basing on the complaint given by the petitioner. Now, at this stage, and in the backdrop of these facts, if an injunction is granted, both the courts have rightly observed that, in fact, it would cause hardship to the defendant and denied the injunction as sought for. However, the trial court has rightly observed that in case if the court comes to the conclusion that the defendant has encroached the property belonging to the plaintiff and made the construction, and the court will direct the defendant to remove the said unauthorized, said illegal construction which is made by encroaching the property of the plaintiff. In these circumstances, there are no grounds to grant injunction to the petitioner. Injunction in favor of the petitioner restraining the defendant. Both the courts have rightly held, though the trial court has rightly held, but the finding is contrary to the findings. However, appellate court has corrected the same and had refused to grant injunction against the defendant. In that view of the matter, this court do not find any reasons to interfere. Accordingly,
The observation regarding blood, if my eye succeeded, if I succeed,
already that is observed by the trial
that
court.
may be,
I have-
that portion may kindly be
I have
confirmed,
already recorded in this.
confirm.
Bill number 3,
Right,
I
sir.
appear for petitioner.
Malappuram Ishwaran.
My lord, I sincerely apologize, my lord, because my absence yesterday, my lord.
Yes.
My lord, the bank by name Allahabad Bank, my lord, at Hosford branch, my lord, they have proposed to sanction a loan in my name. So a third party, my lord, known to me, not the bank manager, has taken me to the bank and made me to sign all the papers, my lord. Then, my lord, like that, on the assurance that they would get 50% of the subsidy from the industrial, district industrial center, my lord, for a small scale industry and all. My lord, they have done this to also around 48 to 50%, my lord, but they have not released any amount.
When was the award passed?
My lord,
When was the award passed?
my lord, award was passed, my lord, I have produced that award, my lord, in a
It's
PLA
passed
petition.
on
It was passed on 29th January 22. It is page 48, my lord. My lord, there, my lord, they have assured that they will not proceed because there was a CBI inquiry. They themselves, the deputy general manager has registered a case against the manager.
Let's come to the award. What is the award?
My lord,
What is the award? Let us see.
award amount, my lord, is 23 lakhs 18,461.
Page number.
My lord, page 60. That is the order of the.
Were you present before the authority? Before the Lok Adalat?
My lord, though I had appeared, what the bank has assured us, because there was a CBI complaint given by the deputy general manager of the Allahabad Bank, that fraud has been played by the manager to the tune of around 624 lakhs. So all these loans, my lord, are all bogus loans. So they have filed a case.
Before going into that, what is the award and what is the implication of it? Come to the award at page number 48.
48, my lord.
It was for recovery of a total sum of rupees 20.
Yes, my lord, because my lord, the parallel proceedings, they have proceeded against the manager before the
Not
CBI
concerned.
court.
No, please
It is still
understand.
pending.
Please understand. We are not concerned with any of it. Now, whether you are a signatory to this award or not is the first question. There is no dispute about that. And now you say that something was assured. We are not concerned with what is assured. We are only concerned with what is the award, what is the fraud that is played.
The fraud was, my lord, the amount was not given to us at all.
Then why did you enter into why were you a party to this award?
My lord, because, my lord, there was a CBI inquiry. My lord, we thought that because it's going to be recovered from the manager, we did not, my lord, take action on this. Sincerely, my lord,
That can't be a ground for, recalling the award or requesting the award.
no, that amount is proposed to be recovered from him. Still, it is case is pending before CBI court.
But you have to only restrict your arguments. How it is bad? What you have thought?
My lord, submission would be because the amount is not paid to us, it is going to be recovered from the manager and other persons who have played fraud to the court. My lord, then if that is in that event, my lord, I need not pay that amount. That's all, my lord,
That is not a
equity, my lord, that is the equity because when once he.
legally tenable argument. That may be the facts we don't know, but it is not a legally tenable argument.
Allah, I have produced even that one also, the case filed before the.
Come to that we are not concerned. Please come to page 60. The petition is partly allowed. The petition is entitled to recover a sum of rupees so and so with future interest at the rate of so and so from the date of petition to realization of the amount. The respondent is to pay the award amount with interest thereon as ordered above within 2 months. If the respondent pays so and so has ordered that liberty to get executed this award so and so, according transmit the award to the jurisdictional civil judge court.
That's.
It was passed on 29/1/2022.
Please, my lord.
What are you doing till 2026?
Because, my lord, parallel proceeding was going on, I did not challenge this. I did not challenge this because CBI court is seized of the same loan amounts. Loan amounts, it is seized of the same loan amount. That's why I did not challenge because it is pending before the CBI court.
Notice.
My lord, no, further proceedings, execution proceedings are, my lord, they are trying to attach, my lord, our property. My lord, for a, my lord, only next date of hearing, my lord, at least.
Mahantesh R. Patil, please. Ramchandra Mali.
Can I seek a short pass over, my lords? Senior is on legs, my lords. He is ready with the matter. Pass over. Please, my lords.
4 pass. Seal number 5 adjourn. Seal number 6. Nil open.
Seal number 5.
Adjourn.
One date
What is the date? 1 minute. What is the date given?
Just after 2.
You are for the petitioner.
Petitioner. I am a proxy. The advocate for the petitioner is facing some problem. He requested for 2 days.
What is that?
The counsel for the petitioner, this WP, he is facing some health problem. He requests for time, 1 week time.
Already adjourned. It's already adjourned.
Please.
Seal number 6.
Yes.
Manaship, petitioner has challenged the order rejecting application filed seeking police protection.
You are the plaintiff or the defendant?
Decree holder, my lordship.
You are the decree holder.
Please, my lordship. I had filed an execution petition seeking execution of the permanent injunction decree. In that execution, my lordship, I had filed an application seeking police aid for implementation of the decree, my lordship, which has attained finality. Trial court has dismissed the application. Please. Bishop, reasoning starts from page number 19 minutes. I may be permitted to read out.
Yes.
May I commence, my lordship?
Yes.
Point number 1. According to DHR, they have opted.
89 of 1981.
Yes, my lordship.
Even appeal also is finalized in the year 1989.
Yes, my lordship. Appeal was filed in the year 1989. That came to be dismissed in the year 1995.
Yes, notice to the respondent.
Hand summons, may I seek, my lordship?
Petition is permitted to take out hand summons on the council appearing for this.
May I seek,
File a memo to that effect. Once the memo is filed, this is the matter.
may I seek for date, my lordship, if the court.
This is the matter on, then don't say when the memo is filed, it's on 16th of March.
My lordship, may I try before, take chance before this honorable? May I take chance before my lordship?
Yes.
Grateful, my lordship.
Till number 7, Sangram Kulkarni, Venkatesham Karvi, please. Purva.
My lord, the petitioner has purchased the property in cantonment area in Belgaum, my lord. My lord, the petitioner had given an application.
Come up on the last occasion.
It had come up, my lord.
I heard it.
For some time it was heard and
Council Speaker, director take notice.
Take the instruction, my lords.
You are the instruction.
Please.
Yes.
We're not
Yes.
instruction, my lords.
You
We
have-
take the instruction from the.
You have to get instruction.
Yes, yes, please.
Lord, interim order may kindly be passed, my lord, because they have rejected.
What is the prayer, let us see. Issue that requires the impugned order dated 26/11/2025. Officer so and so. What is the order?
My lord, according to this order, they have rejected the prior permission for purchasing the property, my lord. While passing that order, they have also said that the sale deed itself is void, saying that the sale deed is executed by the power of attorney holder, who is also one of the vendors.
So what is the interim order you are seeking?
My lord, operation and execution of that order, my lord.
What is the consequence?
My lord, according to that order, now they say that my sale deed itself is illegal.
That would be decided eventually by this court.
Yes.
The council appearing for the respondent number.
1 and 2, my lords.
1 to 3.
3, my lords. 1 to 3.
1 to
4 is the
3.
separate.
1 to 3 shall file his objections.
Please, my lords.
Within 3 weeks.
Please.
From today, or else their right to file the objections forfeited, will be forfeited.
No, help, 4 weeks at least 4 weeks. Please, my lords.
I think in all
Please,
the
my lords.
cases, this order should be standard.
Yes.
Otherwise, no objections will be on record.
Last occasion, this honorable passed the order, sir, in some writ petition or writ petition, please.
Yes.
Much obliged.
Next.
Bill number 8.
A date may kindly be
Just
fixed.
ready?
A date may kindly be fixed after 4 weeks, my lord.
List this matter on today's 17th. List it on 18th of March.
Please.
Yes.
Lord, I'm appearing for the response number 1. Yesterday's matter. Lord, the review petition, my lord, passed by this honorable court has been challenged before the honorable apex court. Apex court, my lord, on 6/2/2026, posted for the hearing, but it has been adjourned on, my lord, 14/4/2026.
No, my lord, so this is the yesterday's matter, my lord, where
He is
now,
relying on the labor court was also relied upon the division bench judgment. That judgment is reviewed. And now that is in favor of you, which is favorable to you, that order is passed by the division bench.
yes, my lord.
That is appealed in the Supreme Court.
Yes, but there is no stay there. Now he has initiated
No stay, my
recovery,
lord.
he has initiated recovery proceedings against me.
Then that has to be stayed.
My lord, the recovery proceedings, my lord, that has been adjourned to, my lord, next month, my lord.
So I'll say the list is matter after 4 weeks till such time the respondent shall not take any precipitative stay.
Please.
The council appearing for the petitioner submits that in the light of the order passed by the division bench in review petition in writ appeal number.
In writ appeal number 100250 of 2021, and it is order dated 24th October 2025.
25. The said issue is no, the order of the labor court has to be set aside. Land counsel appearing for the respondent submits that the said order has been assailed before the Honorable Apex Court and so far, and the same is pending consideration. Land counsel for the petitioner submits that no stay is granted and the order of the division bench is still operating. In that view of the matter, list this matter after 4 weeks. Till such time, the respondent shall not take any coercive steps.
No, my lords, notice is not ordered in this case. It's coming for the first time.
His name is there.
No, he is only for the
Other
caveator,
two
my lord, for
respondents.
respondent number
Respondents will order
one.
notice.
For others, my lord, emergent notice.
He is respondent number?
One mail.
One, my lord.
How many are others?
My lord, 2 and 3 are there, my lord.
R2 and 3 issue notice.
And it may posted along with my lord, 3 more, my lord.
In
petitions
those
have been
matters,
filed.
notice are read to be, in those matters, notice are read to be, my lord, issued. I have moved those matters. Right.
Give those matters numbers so that we'll post all of them.
My lord, once that comes, my lord, I'll get it along, posted along with this, because notice is yet to be ordered in those cases.
Connected matters.
Connected, once it is, practical difficulty, once it is connected, this will come for the PF, etc.
Connect. I'm saying whatever are the numbers given to the
Grateful,
court
my
officer,
lords.
it will come, we will order notice and
Great.
pass the same order.
Grateful, my lord.
Yes.
I'll furnish the numbers.
Yes. Yes, next.
Seal number 9. A.R. Kulkarni, R.K. Kulkarni.
My lord, I am for the petitioners. Petitioners are the defendants number 1, 2 and A and B before the trial court in FDP number 9/2012, wherein the respondent number 1 has filed an application under section 151 of the PC seeking that she should be declared the 1/7th share of allotted to one Kumari Yamanaka, who has executed the will during the pendency of the FDP. So without producing the original registered will, she has produced a certified copy without laying any foundation on it. And moreover, the trial court has passed an order on I number 5, not only allowing the application and even to amend the preliminary decree, which has been passed during the pendency of the executant of the will.
Let's see that.
I number 5. The order is at page number 34. The order runs. In the present case, counsel for petitioner has filed I number 5 under section 151 of the case for seeking the relief of allotment of 1/7 share of the deceased petitioner number 3 in the suit property in favor of the present petitioner number 2.
The
On
said
the basis,
application is not opposed by the respondents.
my lord, no opportunity has been given because page number 31 and 32 order sheet, my lord,
Yes.
dated 24/11/2025. Counsel for the plaintiff praised time for steps to appoint of court guardian to respondent number 2B, who is the present petitioner herein. Time granted as finally and last chance. Call on 112. And again on 112, the GBN advocate filed wakalat on behalf of the respondent number 2B and submits that respondent number 2B attained majority. In this regard, he has produced the Aadhaar card of respondent number 2B.
Same on the same.
So no
basis of-
opportunity has been given. Only the orders have been passed. Immediately the order has been passed without affording an opportunity. Very next date, the case has been posted.
Agreed with the order passed on I number 4 in FTB number 09 of 2012. The defendant the respondents 1, 2A and 2B in the before the trial court or before this court. Learned counsel submits that during the pendency of the FDC proceeding, based on an IA number, based on an IA that is filed IA number 5 under section 151 CPC, seeking the relief of allotment of 1/7 share of the deceased petition number 3 in favor of the petitioner number 2 before the court on the basis of the will dated 24/3/2007. The court has allowed the application. It is submitted that no opportunity is given, no inquiry is conducted. Considering the submission, there shall be stay of all further proceedings pursuant to the order on IA number 4 in FDP number 09 of 2012. Notice to the respondent, petition is permitted to take.
My lord, I have also prayed for stay of the order, my lord.
That's what
Otherwise,
I granted.
my lord, I have,
Granted stay.
my lord, I have praying to dispense the notices to respondent number 2 to 8 because they are not at all any parties to the application.
The memo is filed seeking dispensation of notice to respondent number 2 to 8.
As there is no claim.
Accordingly, the memo is taken on record and same is dispensed at the risk of appellant. So you need to take only on one.
One.
And summons on one and file a memo to that effect. Memo shall be filed by 11th of March or else the stay granted by this court stands vacated.
Please.
Is 10.
Seal number 10. Santosh Appa Sabgarengi.
Yes.
Please, my lord. One is the writ petition challenging, my lord, the ex parte award, my lord.
Ex
The
parte
pass, ex parte award.
award.
Yes, my lords. The passed by the deputy registered under section 69, my lord.
When
Plus
was
the
the award
legal
passed?
yes. Yes, my lord.
When was the award passed?
The 6/4/2022.
6/4?
2022.
20?
2022.
2.
Yes, my lord. Unless the petitioners are legal heirs, my lord. The
So against
is
the award
employees of the
passed,
society
well, the remedy is a writ petition.
without opportunity, my lords, they pass the order.
Papers are not served. Do the papers, serve the papers on earth.
Not in state, my lords.
Huh?
State not made a party. The society, my lords.
Without them, how will you question without making the registrars a party to this? Where is he? Who has passed the award?
Register, my lord. Deputy register.
Where is he?
Annexure C, my lords.
Huh?
Annexure C. Party is there.
Huh?
Party is yes.
It's not a party.
Not a party, my lord.
Not required.
Yes. A requirement, my lord.
Make him.
Please, please.
This is matter after the petitioner has not made all the parties as respondents to the petition. This seeks time. This is matter after a week.
Please.
Seal number 11. Remedy party.
My lord, for the petition. Yesterday I filed objections, my lord. The copy I have not received.
Senior is appearing through VC, my lord. Senior is appearing through VC.
Yes.
Am I audible, my lord?
Yes, yes.
I will serve the copy. Received the copy of the objections, my lord. Lord, may I have a look at
Respondents
it?
are-
And
where are your objections?
objections I have filed. Yesterday I have filed.
Let's see what are the objections.
Lord, now
What was
that
the order
the
passed
copy,
by
my
the-
lord, could your lordships?
If the respondents are accepting the documents via online portal, any difficulty for any applicant, there should be a mechanism in place to address the grievance.
Please.
Article 2 of the Constitution is not the jurisdiction where the court will sit on all these issues. And these are not all the issues that are to be decided by the court. And it's the responsibility of the respondent to take appropriate measures whenever these kind of exigencies arise. Learned AGA shall get specific instructions, objections on this by 18/2/2026. Apart from this case, the respondent shall clearly state what would be the course available to any party who is not able to get through this online portal and how the objections will be dealt with.
Yes.
What is your answer to this particular query?
That's para number 20 of my statement of
number?
objections. Para 20, my lords.
Please read.
Please. It is specifically submitted that the scheduled properties that is 1 to 5 of this involves agricultural land, non-agricultural land and national highway areas which have not been separated yet. For agriculture registration, revenue department records, only agricultural land, mutation, Aadhaar, PAN card and survey department may have required. For the non-agricultural land under the Gram Panchayat, form number 11A, rules so-and-so, development panchayat, Aadhaar, PAN card are needed. Kaveri 2.0 software requires online submission of documents with correct property records. If citizen applies through Kaveri software and documents are correct, the sub-register send for payments. After correct government payments, concerned parties will get their schedule and then they need to go to the concerned sub-register office to get their documents registered. If documents are incorrect, the registration is not allowed. The petitioner should correct their agriculture and non-agriculture lands records and submit through Kaveri 2.0 registration. is only possible with proper documents. The respondent is not responsible for correcting documents. It is up to the petitioner to fix them with concerned department. The respondent cannot register the documents without proper records. No physical registration is allowed at sub-register office without.
Yes, Mr.
Lord, these are all, my lord, it's a general statement being made. I'll file my rejoinder, my lord. And we have produced all the documents. In fact, along with the writ petition also, I produced the document.
The mechanism is.
1 week's time, my lord. I'll file rejoinder, my lord.
No, I have asked you specifically.
Yes.
If for any difficulty, if anybody is not able to upload.
Please.
Or any difficulty is there, how their grievances have to be addressed?
My lords, they have to upload through the, my lords, the computer center, or they can upload self, my lords, to going to the, my lords, the online portal. If the records are uploaded correctly, the, my lords, the software will take it.
Oh, if there is any difficulty, any problem with the software, then what to?
There is no difficulty with the software, my lords. There are thousands of registration are going place, my lords, throughout the Karnataka every day.
Page doesn't work. Sometimes it may
My
not
lords,
work.
it always works. It always works.
My lord,
It's a machine.
It's a machine.
Not working.
Yes.
After all, machine it might not
Usually.
work. That's why I asked, what is
Please.
the mechanism in place? If there are any grievances, there should be some grievance cell.
My lords, if there is an instance of.
So for example, in the same online portal, if something is not happening, we should have some grievance
My lords,
cell in that, something to, to say that, in spite of me uploading all the documents, it is not working or something. That's what I asked.
Yes.
Is the whole reason for this. What did I say? The respondent shall clearly state what would be the course available to any party
My lords,
who is not able to
yes,
get through this online portal,
My lords,
how the objections will be dealt
My
with.
lords, if it is not uploaded, my lords, if because of, my lords, there is a, my lords, server problem, he can log into the, my lords, the software, and he can again upload. Let me complete, sir. He can again, my lords, log into the, my lords, there are thousands of lakhs together.
Good thing, what I'm observing is,
Please.
in all these objections that
Yes.
are filed before the court, there is no clarity. Clarity in the sense, you are not, your officers are not making the correct point before the court. They want to write essays on something like they're reproducing everything the petitioner says. What I've asked is a very simple question.
Yes.
I wanted a simple answer.
Yes.
But this, after reading para number 20,
Yes.
I'm not understanding anything.
My lords, the mechanism is to, my lords, upload all the documents with the application online. And if it is not, application is not taken because of some technical issues, he has to again, my lords, log in after.
Again, it will not take.
my lord, may I make one submission, my lord?
That's what I wanted
Please.
to know. That is what your officer is supposed to address.
Kindly out, and next week I will clarify. And
This court has passed an order on 2/2/2026, specifically directing the respondents to clarify. Apart from this case, what would be the course available to any party who is not able to get through this online portal, how the objections will be dealt with. The objections that are filed before this court have not at all answered the query of the court, and also particularly with regard to the petitioner. And the objections that are filed are not at all clear. This court, the respondent shall file a clear objections before this court.
10 days time is required. I have to seek.
By addressing all the issues. This is matter on 26.
Please.
Please.
Obliged.
Yes, next.
Seal number 12.
What is this?
Not appear for the response, Lord.
Renewal of
Lord.
approval.
Lord,
So
on
society-
submission.
All these matters, if it takes time, I'll take it in the afternoon.
Lord, on 12 to, Lord, I filed 12 to 20, I filed an application for additional ground and additional prayer that I was not put up. Maybe, Lord, I may be put up, Lord, and day after tomorrow we'll address argument on merits, Lord. I have filed a statement of objections in all the cases.
List these matters on Thursday, next Thursday.
Kindly have this matter on Monday, my lords, for the reason that 12.2 contempt petition was filed.
Monday, if you want, we can move the other court. Monday, I'm not sitting, that's why I'm not giving any date.
Next week, any day.
That's why Thursday.
Lord,
In
there is-
respect of 12.1, my lord, the interim order earlier granted.
It is
may
not
kindly be
continued.
extended.
Wherever interim order is there, extend.
Lord, it was not continued. Interim order was not
If
continued.
it is there, then
Please.
only it will be
My
extended.
lord, one
Your
submission.
lordship, last occasion I mentioned it, my lord, anyhow, tomorrow matter is there, it is not extended. Till then, my lord, it is extended. Only last time your lordship is not.
Lord,
Can
one
kindly
submission.
be extended.
Lord, there is an order from this honorable court, my lord. I'll read one thing. The AG is directed to secure instruction as regard the inquiry under section 25 of the Karnataka Societies Act as directed in WP number so and so, being such inquiry is conducted, same is placed on record. Lord, till today, the AG has,
They will be facing the consequences of it.
please.
That is annexure Q in 12.1, my lord.
Yes, yes.
Enquiry report I submitted and stay is granted by this honorable.
Please.
Number 13.
My lords, 13, I appear for the petitioners, my lords. The challenge is to the tender notifications at page number.
Earlier it was there and only on last occasion it was not extended.
My lords, behalf of Prisma number 2, my lords.
As I've already said, I have already recorded that. Yes.
Official memorandum, my lords, be cancelling the tenders for.
Oh, it is cancelled.
Tender is cancelled.
Very well, my lords.
The red petition is filed. Seeking the following prayer. When the matter came up for hearing, land council appearing for which respondent?
Yes, Prisma number 2.
2.
Yes.
Submits that. By proceedings stated 17/2/2026. The tender, which is the subject matter of this petition, is cancelled due to administrative and technical reasons. Hence, nothing survives for consultation in this petition. Accordingly dismissed. Yes, please.
Careful.
Till number 14.
Yes.
Appear, my lord. This is a case, my lord. Seventh respondent claims to have, my lord, advanced a loan, personal loan, my lord, of 1 lakh rupees in 2007. And files, my lord, claim petition in the year 2024 after 18 long years without demand notice, along with an application seeking condonation of delay. And in
Yes, what are your instructions?
Your lordship, on 19, as their contention, your lordship, no detailed order has been passed.
No, apart from that.
Please, your
after
lordship.
16 years recovery proceedings. are
Please, your lordship, we have filed application before the, under section 70, your lordship, for condonation of the delay.
Can you
Where-
condone?
Please, your lordship, under section 70.
And now
70A, your lordship.
16 years delay is condoned.
Your lordship,
And
this is the
condone-
detailed order which has been passed by the authority, your lordship, by respondent.
Section 70, let's see.
70A, your lordship.
Let's see. What it says?
No dispute under section 70 shall be entertained unless it is referred to the registrar within 6 years from the date of the cause of action.
Has to be- Wait,
Second
you're
one, your
reading
lordship,
70?
not 70A, 70A, Cooperative Society. your lordship.
70 capital A, my lord.
70 capital A.
Yes.
Please, your lordship.
Yes, period of limitation.
Please, your lordship. No dispute under section 70 shall be entertained unless it is referred to the registrar within 6 years from the date of the cause of action.
Where is it? Provided that it is.
Your lordship, next one. Now, notwithstanding anything contained in subsection 1, the registrar may entertain a dispute referred after the period of specified in subsection 1 if he is satisfied that the person making the reference had sufficient cause for not making the reference within that period. He availed the loan of rupees 2 lakhs, your lordship. Subsequent,
What are the reasons to entertain your
Your Lordship, as we have stated in the interest of society itself, Your Lordship, not anything. Because once he has availed the loan, he has to repay it. Instead of several oral requests, he has not paid the amount, Your Lordship.
The Learned Counsel appearing on the last occasion, this court has passed an order directing the SCGP to get instructions with regard to why the proceedings are initiated after 16 years and how now the award is passed.
Not award is passed.
Only
I'm
delay
seeking-
is condoned,
one second.
Your Lordship.
Not only delay, I am seeking quashing of the entire proceedings because the entire proceeding itself are bogus. They say
Proceedings are initiated under section
70.
Under section
70.
under section 70 of Karnataka Cooperative Society.
Under section 70 of the Cooperative Societies Act. Land Council for the petition submits that under section 70, no dispute under subsection 70 shall be entertained, and as per section 70A, no dispute under section 70 shall be entertained unless it is referred to the registrar within 6 years from the date of the cause of action. However, section 70A2 empowers the registrar to entertain a dispute referred after the period specified in subsection 1. If he is satisfied that the person making the reference has sufficient cause for not making the reference within that period. Land Council appearing for the petitioner submits that the registrar cannot exercise the powers under section 70 and refer this and condone the delay of 16 long years. Learned SCGP submits that when the petitioner has availed the loan of 2 lakhs and he is supposed to pay the same and he has failed to pay, and in the interest of the society, the registrar has condoned the delay of 16 years, which he is empowered under section 17A2 of the Karnataka Cooperative Societies Act 1959. This court heard the counsels on either side and peruse section 70 and 70A of the Karnataka Cooperative Societies Act. The period of limitation that is prescribed is 60 days.
6
However,
years.
it is left to the discretion of the court, discretion of the registrar for the reasons he can entertain a dispute after the said period if he is satisfied that the person making the reference has sufficient cause. When the statute provides for a particular time and the delay and the power is vested with the authority to condone the delay and in respect of matters of recovery of money, that cannot be it cannot be if there are not delayed delay of 16 long years.
In this case, it is 18 years.
18 years, not 16, 18 years. In that view of the matter, there shall be stay of all further proceedings pursuant to the order dated, what is the date of this order?
1911, Your Lordship.
Seeking stay of entire proceedings, my lord, in both the case.
That's what I'm saying.
Order passed on 1911-25, Your Lordship.
1911,
25.
25.
Both the matters, my lord.
Any other respondents?
My lord, respondent 2 to 6 are, my lord, sureties they have shown. I am seeking dispensation.
Memo is filed seeking dispensation of notice to 2 to 6.
2 to 6. And notice has to go to, my lord, respondent 7 bank.
Notice to respondent number 7. Yes. list
Sorry, my lord, it is respondent number 1, my lord, not 7.
Stay application is also pending, still considered.
Notice to?
7.
Phone number 7 only.
HCGP appears on behalf of 7.
Please.
The notice to registry is directed to issue notice to respondent number 1. This is matter.
1 to
after 8
6.
weeks.
Connected matter also, my lord, same.
Order.
Great.
14th one. Yes, 15.
Lord, I'm appearing for the petitioner in this matter. Petitioner before your lordship is the judgment letter number 2 in an execution proceedings, my lord. Annexure A is the arbitration award.
Petitioner is a?
Judgment letter number 2 in an execution proceedings, my lord.
Yes.
Pursuant to the arbitration award as per Annexure A and A1, the respondent has initiated execution proceedings before the executing court. First Additional Senior Civil Judge Hubli, my lord. Annexure B is the execution proceedings at page number 13, my lord. Now the
2911 order.
my lord, 2911 order, my lord. My lord, pursuant to the issuance of arrest notice, I have appeared. The petitioner has appeared before the court and filed an application seeking setting aside of order of the absent.
Order, page number.
Page number 21, my lord. Page number 20, internal page number 20, my lord. Annexure C, page 20. Page 20, my lord. On 18/20/2025, my lord, the arrest notice came to be issued against the JDR number 2.
When was execution was filed in the year 2024?
2024, my lord.
When did you appear before the court?
My lord, pursuant to the issuance of arrest notice, I have appeared before the executing court.
Before that?
Before that, I remained absent, my lord.
Why?
There was settlement was going on with the respondent and in respect of
So what is wrong with the order?
Now, my lord, I have filed an application under order 9 rule 7 CPC seeking setting aside of keeping me as absent on 15/11/2025, my lord, page 21, my lord. That application came to be considered as IA number 1. And DHR, the decree holder, has not filed any objection. Pursuant to the same, the application came to be allowed. On the same day, my lord, arrest notice came to be issued against the JDR number, a petitioner, my lord. Without there being any giving opportunity to the petitioner, the arrest notice came to be issued
How
against
many
the
times the court will give you opportunity?
my lord.
How many times the court will give you opportunity?
No, my lord, no. After appearing pursuant to the arrest notice, I have not been given opportunity by the executing court, my lord.
You don't appear before the court.
Yes, my lord.
What is left to the court?
No, my lord. Even since pursuant to the arrest notice, I have appeared before the executing court.
I do not see any reasons to interfere.
But even without there being any application filed under 21 rule 37 CPC, my lord, the arrest notice came to be issued by the executing court.
First of all, why are you not appearing before the court? Why are you not paying the amount as per the award?
Lord, we are ready to settle the issues, my lord.
And don't argue on these technicalities. Why have you not appeared before the court? Why have you not paid the amount?
Yes, my lord. I will seek instructions, my lord.
Seek instructions. Notice.
Please, my lord. Interim protection.
No protection.
Please, my lord.
Till number 16. Vishwanath Bhatt.
Please, ma'am. The petitioner is running the recreation club. Petitioner is running the recreation club and registered the Karnataka Society Registration Act.
Same order.
Same.
No, I have a doubt.
Please.
It is like it's every person who is having a recreation club will come to the court and file the petition.
Yes,
The police are having no other work, and they are only around the recreation clubs. How many recreation clubs are there in this part of the? I mean this Dharwad jurisdiction. Every day 4-5 matters of recreation club, and in every matter police are interfering.
And in all the cases, no specific instances are mentioned.
They will not.
They will.
That is covered order syndrome. The present petition is filed. Sing the following prayer. There's a case of the petition that the association duly registered in the Karnataka Survey Act in conducting the games like chess, so and so. I think no separate order is required because facts, everything will be same. Copied from one writ petition to the other. So everything will be same.
17. Pratap SS.
Melada, I am for the.
Yes.
Mature release.
Pratap SS.
To take decision on the recommendation made by
Please.
the state government.
Yes.
For what? Remission?
Yes, my lords, this is only with respect of concurrence we have posted before the, my lords, the honorable, the central government. My lords, annexure is, my lords, may kindly see. The proceedings
So
of
why
the
what is the, what offense that is involved that you require?
offense, my lords, from the reading of this, my lords, annexure makes it clear.
Page number?
Page number 44.
Hmm. Hmm.
Since the offense, my lords, particularly page number 45, my lords. 12 such cases have been recommended for premature release after obtaining concurrence approval of the Ministry of Home Affairs, Government of India, because they had all been convicted under the provisions of the Central Acts. For this reason only, we have sent it to the, my lords.
Then who is
My lord,
appearing for the?
I am for the petitioner, my lord. My lord,
Who
1st
appears for the
April
union?
2020.
Who appears for the Union of India?
Venkatesh Karve, my lords.
Print the name of so and so.
It is already there.
Already there. Where is he? Passover, ask him to come.
Please.
Please.
Yes, 18.
Number 18. Agreement Mallikarjun.
Please.
This is a case, my lord, wherein petitioner car was seized, my lord. In this case, my lord.
That's what I asked.
Yes, my lord.
Section
11A, my lord.
Section 3 and 4 of the Motor Vehicle Taxation.
Motor Vehicles Act.
Motor Vehicle Taxation Act, my lords.
Section 3.
3, my lords.
Yes.
A tax at the rates of specified in Part A of the schedule shall be levied on the motor vehicle suitable for the use of roads, provided that in case of motorcycles, including motor scooter and cycles with attachment of propelling the same by mechanical power, other than those owned by the central government employees or defense personnel or employees of public sector undertaking owned by the government of India, including nationalized banks and which are brought with them at the state of Karnataka on transfer, for which lifetime tax or tax quarterly or annually, as the case may be, has been already been paid in other states or union territories, the tax shall be levied at the rate specified in Part A1 of the schedule. Lords, since the petitioner's vehicle bearing registration number, my lords, at Pondicherry,
What it, like, if the tax is now not paid,
we will seize the, my lords, the vehicle.
consequences.
Consequences, he has to pay the tax, my lords. He has make an,
You have
please.
to point out from the section or the rules.
Yes.
11A, my lord.
11A.
Yes, seizure power of the power to seize, detain and sell the vehicles. 11A.
11 MLs.
1 minute.
Without prejudice to the provisions of section 13 and 14, where any tax is due in respect of any motor vehicle has not been paid within the period specified in section 4 of the motor vehicle department below the rank and below the rank of an inspector of the motor vehicle or the police department not below the rank of inspector of police, as the state government may empower in this behalf, may subject to such rules as may prescribe, seize and detain such vehicle. For this purpose, take or cause to be taken all steps to be safe custody of the vehicle until the tax due in respect of the vehicle is paid. And
11A also.
11A also. If at all he is aggrieved by the merits, any action taken by the merits, the authority. Under section 15, appeal lies, my lords.
If the tax due in respect of the vehicle seized and detained.
Yes, ma'am.
Under subsection 1 is not paid within 30 days from the date of seizure and detention.
Yes.
The officer empowered by the state government may, after giving a notice in writing to the registered owner and the person who had the possession or control of the vehicle immediately before the seizure and detention, objections, if any, recover the tax due by sale of such vehicle in the manner prescribed.
Yes. He is aggrieved by that order, my lords. There is appeal under section 15 of the Act, my lords.
Yes, let's go to that.
Yes. Section appeal. Any person who is aggrieved by an order of the taxation authority made under this Act may, within a prescribed time and in the prescribed manner,
15A or 15?
section 15, my lords. Appeals. Any person who is aggrieved by an order of the taxation authority made under this act may within the prescribed time and in the prescribed manner appeal to the prescribed authority. No appeal shall be entertained by the appellate authority unless it is accompanied by satisfactory proof of payment of tax not disputed in the appeal. There is,
Instead, there is a further revision
the revision under section 15A.
under 15A.
Yes.
Yes.
My liability to pay the taxation arises only, my lord, if I used the vehicle beyond 12 months, my lord.
That why should the High Court consider?
As per section 46 and 47, my lord. Yes, my lord. It specifically states the section 47 state.
46 states. No, an action has been initiated by them under section 3.
3 and
No,
4.
against that.
Your
you have a
lordship may
remedy
kind,
under section
yes,
15.
yes, your lordship may kindly see the impugned order, my lord. Impugned order at page number.
Let us assume that impugned order is bad.
No, they have seized my vehicle on the ground that, my lord, I have done emission on so and so date.
That's what I'm saying.
Thereafter, my lord, notice was also issued.
Let us assume that their order is wrong. Why you are coming to the High Court when there is a mechanism available under the Act under section 11 and 15?
Yes, my lord, immediately after seizure of my vehicle, I have submitted my representation at Annexure G, bringing it to the notice that, my lord, I am not liable to pay any tax, my lord. Thereafter, my lord, as per Annexure L, my lord, they have issued notice stating that, my lord, as per the report of the motor vehicle inspector on inspection, you have not shown the original documents. That's why your vehicle has been seized and it is kept in the custody. If you have not paid the amount, then the vehicle will be.
Motor vehicle inspector, what are seizures is not the ambit of 226, and we will not interfere with all that.
My lord.
The mechanism provided. Every case can't come to the High Court.
And
because, my lord, they have.
I'm saying that, assuming that what all they have done is wrong, you have a remedy. And you cannot say that it is not an efficacious remedy. You have to go there. All for small petty offenses, everything, if everybody starts coming to the High Court, there is no purpose of the Act and the mechanism provided under the Act. What is the judgment you're relying on?
Please, in this case, my lord.
My lords, these are all disputed facts. He has to agitate before the authorities.
No, this is what is the assistance court is expecting from the
Please.
AGA and HCGP.
Please.
In this case, my lord.
Yes.
As per amendment, my lord, 2014, a clause was inserted, my lord, as per explanation 2. That was challenged and, my lord, may I take your lordship to the.
This is arising out of a constitutional validity of the Act.
In that, my lord, page number 34 of the judgment, my lord.
Why should we apply that?
Because, my lord, it was stated, my lord.
For the duty of the High Court to do all
Even may I take your.
Go to the authority and tell them that you should, in the light of the High Court judgment, you should do it. Please come. The present petition is filed. Saying the following prayer. It is a case of the petitioner that he is employee of the Bank of Baroda and a native of Pondicherry. While he was working at Pondicherry, he has purchased a second-hand car bearing number PY05/H7164 for his personal use. After purchase of the car, the name of the petitioner was registered as owner with effect from 11/11/2021. While order dated 19/5/2025, the petition was transferred from the Bank of Baroda Pondicherry branch to Kudni branch in Ballari district under inter-zonal transfer. The petitioner, after relieving from Pondicherry, reported to duty and also brought his car while traveling from Pondicherry. Petitioner using his car for his daily use to go to the bank from his home. On 5/11/2025, while he was going to the bank from his home, the fourth respondent stopped the car of the petitioner and on verification of all the documents seized, the vehicle of the car of the petitioner on the ground that the petitioner using the car registered at Pondicherry without paying the Karnataka motor vehicle tax. Immediately on 8/11/2025, he submitted a representation to the respondents to release his seized vehicle, pointing out how the seizure is illegal and requested to release the car forthwith. However, the same was rejected on the ground that the court then he was not released by the respondent. He has filed criminal miscellaneous number 572 of 2025 for interim release of the car before the third additional civil judge and JMFC Ballari. But however, the same was rejected on the ground that the court is not empowered to release the vehicle. It is the contention of the land counsel of the petitioner that as per section 3(1) of the Karnataka Motor Vehicles Taxation Act, the liability to pay the tax arises only when a vehicle is kept for use or used in the state of Karnataka for a period exceeding 12 months from the date of its entry into the state. And further, if the vehicle is once registered in the state in any state in India, it shall not be required to be registered elsewhere in India. It is submitted that the seizure of the petitioner's vehicle is contrary to the provisions of the Motor Vehicles Act. Further, he has relied on the judgment of the judgment of this court in WP number 28060 of 2015 and batch dated 10th of March 2016. He relied on which para?
My lord, page number 34, second para.
Page number 31.
34, my lord.
34.
Second para.
He relied on paragraph number, he relied on the following paragraph in the said judgment. You extract this at page number 34. Relying on this, it is submitted that the seizure of the vehicle of the petitioner is bad and there shall be an order shall be passed directing the respondent to release the vehicle. Learned AGA representing on behalf of the respondent submits that the writ petition is not maintainable. He has drawn the attention of the court to section 3 of the Karnataka Motor Vehicles Taxation Act 1957. He submits that as per section 3, they are empowered to levy the tax. And as per section, seizure is 11.
11A.
As per section 11A of the Act, the authorities have the power to seize the vehicle where the tax is not paid. If once the determination is done under section 3, the affected party has a right of appeal under section
15.
15A is revision.
15A is revision. 15 is the appeal.
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 Yes.
Has a right of appeal under section 15 of the Act to the taxation authority. And even further, if the petition is agreed by an order passed in appeal, it can go before the Commissioner of the Transport under section 15A. That is a revisional authority. It is submitted that when there is a mechanism in place in the Act, the petitioner cannot invoke the jurisdiction of this court under Article 226 of the Constitution of India. Next para, having heard the counsels on either side, there is a material on record. The petition has come before the court stating on how the seizure of the vehicle of the petitioner is bad and how the respondents are not, how he is not, how the respondents cannot collect the tax and how their action is bad. If whatever are the merits of the case, even if the petitioner is having a good case on merits, this court is not inclined to consider inclined to entertain the writ petition, as under the provisions of the Karnataka Motor Vehicles Taxation Act 1957, as per section 11, the respondents have the authority to seize the vehicle, and having determined the tax under section 3, the petitioner has a remedy under section 15 of an appeal remedy and a 15-year revisional, and there is a further revision in that view of the matter. the writ petition, and this court will not entertain a writ petition under 226, as nothing has been stated before this court to say that the remedy that is available under the act is not an effective and efficacious remedy. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the under the act.
Please.
Number 90. Ravi Hegde.
Lord, appear for petitioner. The petitioner is a company, my lord, which is engaged in manufacturing of sugars. The respondent workman was engaged as a centrifugal fitter, and he remains exempt without informing the management from 6/5/24. Lord, which leads to a issuance of notice at Annexure A, page 12.
There is an order of reinstatement.
Reinstatement with full back wages, my lord.
So you are aggrieved by which part of the order?
My lord, basically on back wages side, I am aggrieved by that. Because there is a mistake on my part also, my lord. I have engaged the services of an advocate. Because of his ill health, he could not present himself and contest the matter, which led to a, my lord, ex parte proceedings.
So back wages are from which period to which period?
My lord,
Back
from the
wages
date
from
of
which period to which period?
My lord, from the date of termination, that is 16/7/24 to this date.
What was his salary?
Salary, my lord, around 15, above 15,000, my lord, was the salary, according to the records available. And my lord, I did not, he doesn't dispute, my lord, the absence. He contends that, my lord, he was involved in a PTCL case and he was taken by the police in custody. And after bail was granted, my lord, there was a notice issued and he doesn't, my lord, reply to the notices also, and he does not make any request to the management. In view of this, my lord, the circumstances, I remained absent.
Back wages are concerned, will grant a limited stay, reinstatement will not stay.
Yes, ma'am. Yes, my lord, we will reinstate him subject to result of this petition.
The
back wages and other things.
The council the award is passed, whereby the respondent, the petition is directed to reinstate the respondent into service with continuity of service and all other consequential benefits. The petitioner is entire. It is also the court has granted, the labor court has granted full back wages from the date of termination. Then counsel has argued on the merits of the matter, and at this stage, this court is not inclined to go into the merits of the matter. As far as the back wages are concerned, the order of the labor court dated so and so is state. It's a state, and the respondents have to take the petitioner into respondent shall reinstate the respondent. However, the same is subject to the result of the writ petition notice to the respondent.
Yes,
Number 20.
Yes.
Your Lordship, serial number 20 and 21 pertain to the same impugned order, but the different petitioners. The facts to be placed before this honorable court is that, Your Lordship, both are purchasers of independent.
Let me see the prayer first. Come
Please,
to prayer.
please, Your Lordship. Your Lordship, may kindly find.
Mandamus, restore the position of the property of the. Who is the respondent?
Respondent 1 is the bank and respondent 2 is my vendor, the person from whom I have purchased properties.
Why should there be a direction to restore?
Please, Your Lordship. Now, what has happened is, I have purchased this property from respondent number 2. There are 2 flats on 3rd floor in a building which consists of ground plus 4 floors. So the petitioners in both the cases have purchased independent flats from the respondent number 2 in the year 2025 at the registered sale deed at Annexure A. Now, subsequently, it has come to the knowledge of these petitioners that the respondent number 2 had availed loan from respondent number 1 bank. And now for recovery of that amount, I have been ousted from my properties, both the petitioners in both the petitions. Now, in the sale deed, Your Lordship, there was an indemnity clause which was incorporated where the respondent number 2 was liable to take care of all the loans and liabilities on the property. Now, my names were appearing on the separate e-asti is what it is called, Your Lordship, separate property extracts of separate flats from the corporation. Now, even after that, Your Lordship, the proceedings were conducted without being I made a party, and our possession have been taken from me. Now, therefore, I am before this honorable court. So technically, if the respondent number 2 was aggrieved by this, he would have to approach the DRT. Now, since I was not made a party and I am the lawful owner of both of these properties, independent flats, and my names appear in the property extracts, I am before this honorable court. Now, understand, Your Lordship, that unless some deposit is made, orders cannot be.
Not even if you make a deposit also, I will not grant any order in this.
Now, I am only seeking this, Your Lordship.
Seek a restoration of the possession when something has been taken under the Surface Act.
Please, Your Lordship. Now, I am before this honorable court for 2 reasons. One, the jurisdictional court, which has passed the order in criminal miscellaneous at annexure B, Your Lordship.
Go, question section 14 before the RT.
Your Lordship, I am not even made a party there. That would be my difficulty.
Affected party. You can file a petition saying that I am the owner of the property. Because surface proceedings are initiated, you also accept that the property the second respondent has mortgaged the property in favor of the bank. Bank is not concerned with your inter-se disputes. There is a mortgage. Being a secured creditor, it can initiate the proceedings under Surface Act.
Please.
If you have any claim against the bank, you have any claim against the second respondent, it has to be under the Surface Act, but not before this court.
Now, for that, Your Lordship, there are 4 petitioners. I am seeking liberty of this honorable court. I'll repay the loan which is on my flats. I'll directly deposit it before either.
To understand one thing, the property is mortgaged by the second respondent. As far as the bank is concerned, there is no relation between you and the bank.
Please.
So you can't pay the money and get the property to you. Because as per a mortgage deed, the property, if at all somebody pays, they will give the property back, the documents to them, not to you. So these are all the general problems in a surface proceedings that can't be adjudicated by the High Court. Please come. The writ petition is filed, seeking the following prayer. Petition is agreed by an order passed in criminal miscellaneous petition number 236 of 2025. Where an order was passed by the magistrate under section 14 of the Surface Act. The facts of the case are, according to the petitioner, he has purchased the property from respondent number 2, that is flat number TF302, measuring super built-up area of 840 square feet, located on the 3rd floor of the building known as Shri Guru Anurag, constructed by respondent number 2, by way of a registered sale deed. The petitioner has availed the loan for the purchase of the property. The respondent number 2 has availed the loan from respondent number 1 for construction of the property, which includes the property of the petitioner. And the respondent bank has initiated the proceedings under the Surface Act. It is a grievance of the petitioner that when the property is sold to the petitioner by the second respondent, and second respondent has undertaken to indemnify the petitioner. Now, under the provisions of the Surface Act, without notice to the petitioner, without notice to the petitioner, the respondents cannot initiate the proceedings. As such, he has filed this writ petition before this court, seeking a direction to the respondents to forthwith restore the possession of the property, and also issue a mandamus to respondent number 2 to compensate the petition in case of any equitable measures taken by the petitioners. Who is respondent number 2?
My vendor, Your Lordship.
And now, in writ petition, court will ask him to compensate you.
No, Lordship. Since the prayers are against one and 2 both.
How can in a writ petition you seek all these prayers? You cannot seek it is submitted that The petitioner being the owner of the property without due process of law has been evicted from the property. Hence, is entitled for the repossession of the redelivery of the possession of the property. Next part. Having heard the learned counsel for the petitioner, peruse the material on record. The petition, the writ petition as filed and the reliefs as sought before this court are not at all maintainable. The bank, it is also an admitted fact by the petitioner that the second respondent has mortgaged the properties which are sold to the petitioner by way of, to the bank, and the bank, basing on the as the amount was not paid, as the account is declared as an NPA, had initiated the proceedings under the Surface Act and approached the magistrate under section 14 of the Surface Act, and the magistrate has passed the orders. The whatever or the interstate disputes between the petitioner and the respondent, second respondent, the first respondent being a secured creditor, as the mortgage in their favor is a first charge, they are always at liberty to initiate the proceedings. If the petitioner is aggrieved by any of the action that is taken by the bank or by an order passed under section 14, as under section 17 of the Surface Act, any person who is aggrieved by any order that is passed under section 14 can approach the RERT. As such, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Next part also same.
Only the flat numbers change, flat numbers and the measurement changes.
See, the flat numbers. Yes, next.
Obliged.
Seal number 22.
22 is also, or 20 and 21 are same. Yes, 22.
22.
My lords, the petitioner is the petitioner before the court below in the final decree proceedings, which are filed pursuant to the preliminary decree in a partition suit. So he filed an application for appointment of a court commissioner, and a ADLR was appointed. He delegates the power to a surveyor who conducts the survey, issues a notice, and submits a report. Objections are filed to the same. Now, the present petitioner requests for cross-examination of the court commissioner on the grounds mentioned in the objections. The court straightaway rejects the prayer, which was oral. Then he files an application for permission to cross-examine the commissioner. That is also rejected.
Yes, read.
Annexure K, my lords. Page 74.
80.
Page 74. Learned counsel for the petitioner files I number 222, Rule 6, Rule 10B of CPC for issuing witness summons to the court commissioner.
Page 70.
Page 74.
Oh.
Lordship. Learned counsel for the petitioner files I 222 to 26, Rule 10B of CPC for issuing witness summons to the court commissioner for cross-examination. Peruse the materials on record. On the previous date of hearing, this court has observed that there is no necessity to issue summons to the commissioner for cross-examination and posted the matter for arguments on the main petition. Hence, considering the present application does not arise.
Where is the earlier order?
On the previous page, 73. There is the objection filed.
Question this order.
Lordship.
We should have questioned this.
Yes, ma'am.
No.
I have questioned Annexure K.
Annexure?
K. That is what I read out now. Now both orders are on one page, so I have.
No. This order is passed on 5/2/2026.
Yes, ma'am.
Court has already rejected your request.
Yes.
What is the purpose of filing another application without questioning this?
Now I have questioned this also.
That I understand.
But both
Now
these
you are questioning. When the court
oral
has
request was rejected.
No, it is not oral. Court has passed an order that it is not required. So in consonance with that, the other order will be passed.
Mellors, that is wrong, Mellors, because first of all, the right to cross-examine is there.
That is a different aspect. When it has rejected it, you should have questioned it then and there without filing another
The
application.
very next day, Mellors.
The
All on 5/2, very next day this order is passed.
You are the decree holder.
Yes, Mellors.
The decree holder is before this court, questioning an order dated. What is the order date?
The present order is dated 5/2.
Huh?
5/2.
5/2/2006 is page 74 order.
Yes, Mellors.
What about 73 order?
That is on 30th January.
This is question or not question?
I have questioned it here only.
That's what I'm
Yes.
saying. Here,
Yes.
both orders you have
Yes,
questioned.
members. Two prayers, sir.
I questioned the order dated 31/2026 and 3/2/2026, whereby the petitioner's request to issue summons to the
Sorry to
commissioner.
interrupt. 5/2. It is 5/2, not 3/2, 5/2. 5th February.
Before it is 31.
30th one. And thereafter it is 5/2.
31 and
Please.
5/2
Please.
of 2026, whereby the court has rejected the request of the decree holder to issue summons to the commissioner for cross-examination and posted the matter for the main petition. It is submitted that the court has not even considered has not given any reasons why such an application is not, why he cannot be summoned. It is submitted that on the order on 31/2026 and the order dated 5/2/2026 are bereft of reasons considering the same. There shall be stay of all further proceedings. Notice to the respondents, petition is permitted to take forth and summons and file a memo to that effect by 10th of March. If the memo is not filed, stay granted by this court stands vacated.
Obliged.
Number 23. AP Hegde.
Lord, no.
23.
An order rejecting an application under Order 16, Rule 6 CPC, seeking to summon a document is challenged before your lordship. Lord, in a suit for partition,
Suit of which year?
2021.
What is the suit for?
Respond number 1 files a suit for partition. She is my sister. Files a suit for partition. Our defense is partition has long back taken place in their family in the 1991, and the mutation is also certified. Revenue records are changed. And while changing the revenue entries, this plaintiff was also notified. She has given her consent by signing a consent agreement and also has signed to the extract notice saying that she has no objection. These documents were sought to be summoned from Tahsildar office. My lord, that is rejected, saying that you move an application to Tahsildar seeking a return of the original document. Then I file an application to Tahsildar. Tahsildar gives me an endorsement saying that original cannot be given to you. If you apply, we will give you a certified copy. And the purpose for which I am seeking to summon those documents is to show to the court, to confront to the witness, PW1, that you have signed the consent agreement, you have signed the notice, you have come to the court after 30 years, suit is barred by limitation. Already there is an earlier partition.
Let's see the order.
Annexure F, my lord. In order sheet only the order is made.
Page number?
Page number 29. Orders on I number 2.
Oh, yes. Read it.
An order of this honorable court is referred in para 5 of this order. The Honorable High Court of Karnataka and WP have annexed that order also. The learned counsel for the petitioner has brought to the notice of this court that in view of the rejection of the application by the learned judge, Tahsildar has issued an endorsement denying a furnish the original copy. Since the petitioner has placed on record a photocopy to meet the ends of justice, the petitioner is entitled to place reliance on the original copy. Whether the original copy which is furnished to the Tahsildar has got evidentiary value and is admissible in the evidence is an issue to be dealt with by the learned judge. Therefore, though I am not inclined to interfere with the order under challenge, liberty is reserved to the petitioner to submit a fresh application to the jurisdiction of Tahsildar and seek return of the original document. The courts cannot issue witness summons for production.
We will see that order passed by the High Court.
Yes, at Annexure G I have produced, page 33. This is the para 5, my lord, is the reasoning.
Please read.
Learned counsel for the petitioner has brought to the notice of this court that in view of the rejection of the application by the learned judge, Tahsildar has issued an endorsement denying to furnish original copy. Since the petitioner has placed on record a photocopy to meet the ends of justice, the petitioner is entitled to place reliance on the original copy. Whether the original copy which is furnished to Tahsildar has got evidentiary value and is admissible evidence is an issue to be dealt with by the learned judge. Therefore, though I am not inclined to interfere with the order under challenge, liberty is reserved to the petitioner to submit a fresh application to jurisdiction Tahsildar and seek return of the original document. The courts cannot issue witness summons for production of revenue documents, that too in partition suits.
So, already there is a finding by the judge that.
Not in this case. Not in this case. In some other case, a judgment was, an order was passed, that is relied by the trial judge, not in our case. As precedent, this order was relied. So my application came to be dismissed relying on this order passed by this honorable court. Then I filed an application seeking return of the document to Tashildar. Annexure H is the endorsement given by me, given by Tashildar to me now at page number 37, my lord. Tashildar has said, original cannot be given to you. If you file an application.
This is the precedent for the trial court. Trial court to say that for a proposition.
High Court has said it, yes. So that's why I did not challenge it immediately.
That's why you place another judgment before this court of the Supreme Court that it can be done.
No, my lord.
Because we can't push the courts into this kind of chaos and confusion.
Yes, my lord. The fact in that case was different, totally different.
As far as the issue is summoning the revenue officials for placing it a original document before the court in a partition suit. That is squarely what is observed in this case also.
Yes, my lord. But in that case, order was given, liberty was given to file an application before Tashildar.
You also did it.
Yes, I did it.
There also.
Tashildar has not given the application.
So like,
how to secure, my lord?
Do it, but the court cannot do it.
How can I prove my defense, my lord, of earlier partition? Unless the certified copy I have got, I have already produced before the court. Certified copy I have obtained. I can't confront the certified copy. I can't send the certified copy for comparison.
No, there should be some judicial discipline. No, a coordinate bench of this court has passed an order.
Yes, I'm not saying, my lord.
One order.
Yes.
Relying on this, which applies to the facts of the case, the court has passed an order.
Yes.
Now, if you want an order from this court, you place a judgment before this court of the Supreme Court or a division bench, then I'll say, in the light of that order, this judgment is wrong.
My lord, what I'm requesting, lordship, is not to differ with this Annexure G order passed by this court. No. In view of that development, Tashildar has refused.
This court, no. If you look at this order, court says that already in that case, Tashildar has rejected.
Yes.
Yours is a better case than this, not better case. It is like even before this happened later.
Yes.
In this case, what has happened? The Tashildar, like in your case, has rejected.
Yes.
Then the court said, again, you ask him, but we cannot direct the court to call for the so-and-so to produce the documents. We can't summon him as a witness.
No, he is not witness, just a production of document. Order 16, Rule 6, my lord. Otherwise, my lord, my valid defense, I'll be rendered.
The court cannot issue witness summons production of revenue documents, that too in a partition suit. When the suit is contested on the ground that there is a relinquishment under the unregistered document.
My lord, I'm not saying to differ with this.
Liberty to the petitioner to secure the copy. That's what I'm saying. Please, you try for.
My lord,
how can your luck?
Then how can?
We'll have it on Wednesday. Then on that day we will see. You make some exercise on that. Yes, 24.
24. Still number 24. I will cannot be for.
Your Lordship, seeking a writ of mandamus, Your Lordship, to consider my representation at Annexure C, Your Lordship.
Where is
that
it?
is
To whom you have given your representation?
Representation to the respondent number 3, Your Lordship.
Respondent number 3. This is Municipal Councillor Karwar.
Karwar, Your Lordship. Annexure.
Who appears for the notices, sir? Who appears for the Municipal Council Karwar?
SVAG.
So and so is directed to take notice on behalf of the third respondent. Then counsel for the petition serve the copy of the writ petition on the council.
Great.
This is matter day after tomorrow.
Please, Your Lordship.
Yes.
Still number 25.
Let's kindly pass over.
Pass over.
Please.
Yes, pass. 26.
Mandamus, my lord. My lord, petitioner is a non-governmental organization working on community projects and women empowerment.
To whom?
Direction all to the authorities, health department authorities.
Let's see who are there.
Lord, I was given a task of running 2 mobile medical units in 2 taluks of Ballari district from 2016 up to 2020.
You take notice for all of them. You appear for all of them.
I take notice for my lords.
All, I think.
Yes, all.
Yes. So, to whom you have given the representation? To all.
To all I have given representation. And my lord, respondent number 5 and respondent number 6, as per annexure D and D, have admitted that They themselves have requested the higher authorities to make payment to me. 72 lakhs is pending since 4 years. We ran 2 mobile medical units from 2016 to 2022. Up to April 2021, payment is made.
In accordance with
Annexure D and D.
the petition is filed, seeking the following prayer. It is a case of the petitioner that the petition is a society registered of the Karnataka Society Registration Act, and a non-government organization established in the year 2005, and has been relentlessly working for the community development and even empowerment. Respondent number 6 on 8/12/2022 issued completion certificate to Petition Society for successfully completing the service of running 2 mobile medical units in Ballari district from 26/5/2016 to 34/2022. And they have managed the same from 2016 to 22. And it is a grievance of the petitioner. An amount of rupees 72 lakhs 80,910 is due to the petitioner, which is not paid by the respondent. In this regard, they have been approaching the respondents, and in fact, they have issued a legal notice on 28/8/2025 to all the 28/8/2024 to all the respondents demanding payment of rupees 72 lakhs 80,910 with 18% per annum, interest with 18% per annum. It is submitted that respondent number 6 admitted the liability of making payment of rupees 72 lakh 80,910 to the petitioner society by requesting respondent number 2 on 1/3/2025 to make the payment of rupees 72 lakh 80,910. It is submitted that when the work itself is done long back, the respondents are not paying the amount. As such, the petition is before this court seeking a mandamus. Learned AGA takes notice on behalf of the respondents 1 to 6 and submits that he will get instructions. Having heard the counsel for the petitioner, a counsel on either side, there is a material on record. Where is that admission by the respondent number?
Annexure D and E.
Page number?
Page number 23 and 21 and 23. 21 is annexure D.
Is it?
Yes. Where R6 writes to R2.
As per the proceedings placed before this court, as per annexure D and annexure E by respondent.
Annexure D is by respondent number 6 to respondent number 2. Annexure E is by respondent number 5 to respondent number 3.
Respondent number 6 and 5. The strengthens the case of the petitioner that the respondents are in due of an amount of rupees so and so, which is payable to the petitioner. When the petitioner has represented to the respondents are duty bound to respond to the same. I think this is now the second respondent is a competent authority to take decision.
Yes.
I'll ask him to do it.
Yes.
When the petitioner has completed the work, if there is any reason for the respondent not to, or in not granting the amount or finalizing the amount of the petitioner, the same would have been stated by giving a response to the said representations, which would facilitate the petitioner to avail the appropriate remedy. But the respondents cannot keep quiet without addressing the same and without paying the amount which is due to the petitioner. In that view of the matter, the writ petition is disposed of, which directing the respondent number 2, the commissioner, respondent number 2, to take appropriate action in accordance with law on the representation of the petitioner dated.
Petition, my last petition is dated 17/5/2024. My notice is dated 28/8/2024.
And what are you doing till 2026?
No, 25, they themselves started making this annexure D and D is communicated to me, saying that soon payment will be made.
The notice dated so and so and the representation dated so and so. Within a period of 4 weeks from the date of receipt of.
Lord, it can also be observed. They themselves have,
I've already said
yes,
within a period of 4 weeks from the date of receipt of the copy of law.
not only notice and representation, and also in accordance with annexure D and D. Payment to be made in annexure D and D.
Yes, please.
Seal number 27.
It's IPF for the petitioner.
Yes.
Defendant number 1 is before this honorable court. Suit is for partition and separate position. My specific defense was that I have filed the WS as well as sought for counterclaim. My defense was that the suit schedule property has been purchased by the defendant number 1, who is the petitioner before this honorable court, by investing her own income. The others were the partners for nominal sake, and they were not even, they have not invested anything. Therefore, I filed an.
You it is self-acquired property.
My lords,
Your self-acquired property.
my specific defense is that I have invested the entire amount for purchasing that property. Lords, I filed an application seeking for appointment of a court commissioner to record the evidence of one of the attesting witnesses. That application came to be rejected. Therefore, I am before this honorable court. Lords, may kindly see the order. Page number 65. May I read? The learned counsel for the plaintiff has submitted the objections to the IA number 3, heard both the counsels. The learned counsel for the defendant number 1 has submitted this interim application at IA number so and so to appoint the commissioner to record the evidence of the witnesses stated in the said application, stating that the said witness is the attesting to the registered sale deed dated 22/12/1988, standing in the name of the applicant along with the plaintiff and the deceased so and so. Hence, it is necessary for the applicant to prove the said sale deed, and hence on the other grounds praised to allow this application. My request was not for to prove the sale deed, to establish the fact that I am the person who has exclusively given the amount.
Counsel,
In the objection,
the petition is executed by the order passed in
21/1/26.
Order dated 21/1/2026 passed by the PSCJ Badalkot. It is the petitioner is defendant number 1. Your defendant number 1.
Please.
In the suit. It is a case of the defendant that for purchasing the suit scheduled property, he has contributed the entire amount. And in that regard, he wanted to examine the attesting witness to the registered sale deed dated 22/12/1988. The same was not considered by the court. And on the fact that a document is admitted and there is nothing to be proved, court has rejected the request of the petitioner. It is submitted that court has failed to understand for the purpose for which the petitioner wants the commissioner to be appointed to record the evidence of the attesting witness. Having heard the counsel for the petitioner, that is the order impugned. Considering the submission, there shall be stay of all further proceedings in this number 223 of 2021. Issue notice to the respondents. In addition, petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect by 11th of March. If the memo is not filed, the stay granted by this court stands vacated.
One request, notes. My application was objected by the plaintiff, who is the respondent number 1 before this honorable court. If the other respondents did not object or they did not file.
You can file a memo to that effect.
Please.
Who is he is the first respondent.
First respondent. In fact, after the cost title, I have given a note requesting the court that to dispense with the notice insofar as.
Yes, if that is said, we will
Please.
give the cost title.
Page 4.
Before issuing notice, in the cost title itself, it is stated that respondent number 1 alone objected for the IA number 3 and filed objections to the IA number 3. In the order also, IA number 3 invoice number order. The other respondent number 2 to 8 notice may be dispensed with. Accordingly, notice to 2 to 8 is dispensed with at the risk of appellant. Issue notice to first respondent.
Please.
And the petition is permitted to take out handsome.
Grateful.
Yes, next.
Number 28, Party Basuraj.
Appearing for the petitioner, my lord. Challenging the annexure F, my lord. Challenging the annexure F, my lord. The order passed by the execution court, my lord, for releasing of the amount, my lord.
So quashing the impugned order dated 12/4/2021. In execution petition by the principal senior civil judge.
My lord, the facts are, my lord, petition,
Order? Where is this order?
my lord, page number, my lord. Page number 76, my lord. That is on IA number 3, my lord.
Page number 76?
6, my lord.
I don't think it is 76.
76, my lord.
Order starts at 79. This is an order on IA number 3.
Yes, my lord.
At 79.
Sorry. IA number 3, my lord. May I read, my lord? The IA number 3 filed by the DHR under section 151 of CPC with a prayer to release the amount of rupees 3,10,825 deposited by the JDR number 1 in his favor. The DHR, along with the applications, he has filed an affidavit and contended that he had a filed MFA 22756 of 2009 before the Honorable High Court of Karnataka, Dharwad bench. And the said appeal has been allowed by the Lordship of the Honorable High Court of Karnataka. For recovery of the said amount, he had filed this EP. As per the judgment of the Honorable High Court of Karnataka, the JDR number 1 is liable to pay the amount and entitled to recover the said amount. And now, by the virtue of the judgment of the Honorable High Court of Karnataka, the JDR number 1 has deposited the amount and is entitled to release the amount deposited in this case. Paragraph 3. The JDR number 1 has produced,
As per the order of the High Court,
my lord.
raising the amount to you.
Yes, my lord.
The owner of the vehicle shall furnish the
Has to,
security.
the owner of the offending vehicle has to furnish the security, my lord.
He is not furnishing. it.
Yes, my lord.
So what you are supposed to seek, if
So-
that condition, you want a review of that condition, you should come before this court. How
But-
can the executing court go beyond the order?
My lord, the JDR 1 has not filed the attachment application before the execution court, my lord. And in the MPM, in the citation, my lord, Madhya Pradesh High Court has passed the order setting aside the Challa Bhartam case, my lord, and upholding the Pappu Yadav case, my lord, where it is stated that.
We are not on any other judgment. Basing on an order passed in the
Yes,
appeal,
my lord.
you are seeking execution of the order.
Yes, my lord.
Condition precedent is before giving the money, before
Yes, my lord.
disbursing the money to
Yes,
you,
my lord.
there should be he should give a security for that amount,
Yes, my lord.
which he has not given.
Yes, my lord.
If according to you, such a condition cannot be fulfilled
Yes, my
and you
lord.
cannot get it, you
Yes,
have to
my
seek clarification in the MFA.
My lord, he has appeared before the JDR number 2 has appeared before the execution court, my lord.
That's
And-
what I'm saying. You need to seek a clarification in the judgment passed in the MFA. Because executing court cannot do something contrary to the order of this court.
But he is not at all ready to furnish, my lord, and now he is not appearing before the court at all.
Understand, I need not advise you on this.
Yes,
What to do?
at least notice, my lord.
Notice to respond.
Issue note. Number 29.
Petitioner Malad seeking a writ of mandamus Malad to respond number 1 and 2. The petitioner Malad is a cooperative society.
The respondent 1 and 2 to consider the representation letter dated to whom you have given the representation. To 1 and 2. What do you
Malad,
want? What
To
is the
hold elections to the cooperative society Malad after the expiry of the previous management board
When
Malad.
the term has expired,
Malad 23 to 2025 itself Malad expired.
The representation dated 31/1/2025 at annexure H, your lordship. He is not a respondent at all, your lordship. Manya Abhiruddhi Adhikari, development officer, your lordship, he has given representation.
Malad.
And
The respondent number 1 and 2 Malad.
for 25 representation, filing a writ petition 26. Number 2,
Malad,
you
in
give a
pursuance to this-
representation to somebody, you made somebody as parties.
What had happened
Where is
Malad?
the representation? Please show it.
In
We'll go
pursuance
other
to the
things
annexure
later.
H Malad dated 31/1/2025.
Where is it? Page number.
Page 24. Malad.
To whom you are given?
Malad, though Malad it was submitted to the cooperative development officer Malad, in pursuance to this Malad, a copy of Malad was sent to the respondent number 2. In pursuance to this Malad, respondent number 2 has passed an order appointing the administrator Malad as per annexure J Malad.
No, you can't give representations to these two. And without giving representations to these two, how can you seek a mandamus saying that to consider my representation?
It is the respondent number 2 Malad, the concerned officer who has to issue Malad a notification and to
Then where
direct
is he
the
party?
respondent number.
Where is he party to this writ petition? No, I'll pass an order to consider something which is not before that authority.
Taken up
You're
on
referring
Monday.
to a representation. That representation is not given to him.
The third respondent taken up on Monday.
The petition is filing a mandamus to
Let's-
the first and second respondents.
Taken up on Monday, my lord, I will include respondent number that
Rita, you have to
cooperative
be,
development
you
office.
have to be at least careful on
Monday,
that. Such a casual manner, petitions can't be filed. This is matter on Thursday.
Seal number 30.
Please.
Just rolling.
Yes.
Writ of mandamus, my lords, at annexure D issued to respondent number 4 and
For the
annexure,
respondents,
please,
Deputy Commissioner Harvey.
which respondent you have given?
respondent number 4 and another representation to respondent number 5, my lords,
5.
please.
Deputy Commissioner Haveri
Please.
and the project director,
National Highway.
National Highways,
Authority of India.
please. The case is, my lords,
What is the representation?
representation is, my lords, to, my lords, shift the, there is an proposed toll gate, National Highway, my lords, very proximate to my land. Now that will create obstruct to my business operations. I give a representation to shift it to somewhere else.
Who appears for them?
Susai Patel appears.
So and so. Is that to take notice on behalf of 4 and 5?
No, sir, I appear for 4-1.
4, AGA takes notice, 5?
Yes.
So
My
and
lords,
so. Is
Union
that-
of India, Venkatesh Karve
Is
appears.
that to take notice? And the land council for the petition, so the copy of the petition on the council. This is matter day after
Is
tomorrow.
also seek for stay of that implementation.
How can there be a stay?
Lords, there's one more, the safety concerns also been raised in the representations.
That you have your remedy is somewhere, not here. You please serve the papers on him and we'll see on Friday.
Please, madam, but however, my lords, stay may granted
I
because it
not
will-
grant stay. How can there be a stay for that? Without hearing the other side. Something is done in the interest of general public.
there's an already functioning
You will see
toll
that,
plaza, my lords.
Whatever you say, we can't consider. The respondent should come and tell the
Please,
court.
please. However,
Day after tomorrow.
one small submission, my lords, there is already functional, is shifting to only 150 meters
Whatever it
away.
is, I will hear it on day after tomorrow. Yes, listen to
Please.
this matter, day after tomorrow.
Please,
Yes,
much
35.
35, 31.
For the petitioner, my lord. Order passed by the magistrate under section 14 of the Surface Act is under challenge, my lord.
I am for the respondent.
Yes,
My lord,
who are you?
I am the borrower, my lord.
Then why should you come to the High Court questioning an order under section 14?
My lord, questioning the recovery proceeding, my lord, I had filed an essay before the tribunal in essay 285/2025. During the subsistence of that proceedings, my lord, there was a stay saying that 10% amount should be paid as a preemptory measures. Out of the 58 lakhs, I paid 10 lakhs. Subsequently, my lord, the very scheme that the loan amount is covered, it is something called a CGST scheme, where it is collateral free scheme. Now the bank has taken collateral for this scheme, which is introduced by the central government, stating that no collateral shall be taken to these loans.
How section 14 order is connected with all this?
Well, the section,
When you already approached the DRT
Please,
by
madam.
filing an essay,
Please,
why
madam.
not you question this before the DRT?
well, there was a stay under section 17,
See of what?
stay of the proceedings.
Where is that order?
Please, madam.
Then what are you supposed to do? Are you not supposed to bring it to the notice of the DRT?
That was brought to the notice of the honorable magistrate. An objection is filed to that text.
Because you have no say before the magistrate.
Please, madam.
Borrower has no stay.
Yes,
What
madam.
you're supposed to do is you have to bring it to the notice of the DRT.
Even other,
An interim order, and when there is a contempt, if that is what is the violation of the order, whatever is the mechanism, you should approach the DRT. Why should it the piecemeal business, High Court, DRT, here and there?
well, my humble submission is that, my lord, subsequent to passing of the interim order and during the subsistence, an amount to the tune of rupees 60 lakhs was also credited to the bank account by way of that
You're already before the DRT.
Please,
In
my
the
lord.
very same application, you can raise all these issues.
Please,
Why
my
should
lord.
High Court interfere? You please tell.
My lord, humble submission is that, my lord, subsequent to that interim order, my lord, there is an credit of more than 60 lakhs. Also, even today.
That tell it to the
May I
DRT. Why
submit?
to this court?
Please, my lord.
Because please look at the judgments of the apex court consistently.
Please, my lord.
Particularly pertaining to Karnataka High Court. How we are interfering in DRT matters.
Please,
And
my
what is the role of the court? If you tell the court, that this is the amount I'm ready to pay, I give an undertaking. On those grounds, the court will interfere.
Please,
Not on technicality. All these things you have to agitate before the Retributory Tribunal, and all the more the fact that you are already before the court, before the DRT.
Please, my lord, my humble submission in that regard is that, my lord, if the bank make a representation to the trust, I'm entitled to for an reimbursement to the tune of 1.27 crores. My humble submission is that if a reasonable amount of time is granted, my lord, I'll be in a position to see that I will settle the dues, my lord.
No, seek from the DRT. You have a good case, go there.
My lord, no order could be passed when an proceedings under 17 is pending. There is a conflict of the jurisdiction, my lord.
Is the DRT remedy? Is the DRT powerless? That the High Court has to interfere for executing the order of the DRT.
My submission is that there can't be a parallel proceedings when section 17 is.
This is one of such nature.
When section 7.
This is one of such nature, parallel proceedings, what you are referring to.
No,
There can't be parallel proceedings.
Please, ma'am.
Go before the DRT. Please come.
My last submission, ma'am. In that regard, my lord, until I file a necessary application before the DRT, I may not be disturbed. Ma'am. That's my only humble submission. I'm ready to pay.
Now when the DRT in the SA has stayed all the proceedings.
Please,
Why, how come you are proceeding under 14?
Please kindly permit me to read the last line of the order, Your Honor. Page number 46, Your Honor. Point number 7. It is clarified that in case if the applicant defaults in payment as undertaken, the benefit of this order would stand vacated and the respondent bank is at liberty to proceed further
He has not paid the amount?
He has not paid. 56 lakhs he has to pay as per the interim order.
Partially incorrect, my lord.
And also, Your Honor,
I paid 10 lakhs. Subsequently, to the tune of.
One can read this order. It is not a correct submission. All the while you are trying to submit to the court
and
that I have complied with the order. In spite of that, there is a default clause in this.
Default
if you don't pay, they will.
My lord.
I agree, my lord. There is a preemptive clause, but my submission is that, my lord.
My lord.
Even today, my lord, I have received
My
the amount of rupees 2,41,000.
I have seen. No,
My lord,
No,
even.
my lord. One more submission for the knowledge of this honorable court. When we filed this criminal miscellaneous petition 180/24, then immediately when it is posted for orders, when immediately they appeared before the CJM also on 30/9/2024 and they filed their objection. Since from the 2024, they keep on dragging before the CJM, they keep on appearing before the CJM. 30/9/2024, they appeared before the CJM and filed objection. And the same CJM, even after complete in detail argument and filing the affidavit regarding to the
Where
DRT.
is the necessity of hearing the borrower?
Sir, no. I convinced the CJM, Your Honor. Then only the CJM passed an order on 12/1/2026, Your Honor. Recently passed the CJM order. That means they have got totally 17 months of time to pay the outstanding amount. They simply keep on dragging the things, Your Honor. Even though CJMST credit is there, Your Honor, even though they have to pay 91,77,507 rupees, Your Honor. Means that nearly 2 crores he has to pay. And also auction sale is also conducted. Auction successful bidder also paid 25% of the outstanding amount, Your Honor. Now we are.
Sale is already conducted.
Auction sale is conducted.
Then what happened? Why have you not taken it forward?
It is under process, Your Honor.
When was the auction done?
Auction is conducted during December and January only, Your Honor, after passing the CJM order. When we posted the vacating the physical vacating notice, then only they filed this writ petition in where the DRT SA is also pending, Your Honor.
In that regard, my lord, even during the pendency of that CMIS, my lord, on 28/11/2025, We have received 33 lakhs 18,700.
Forget about all that. Have you complied with the order passed by the DRT? You have not complied with. Bank is at liberty to proceed.
I comply.
Other material facts and other merits of the matter, this court is not concerned. If you are aggrieved by this section 14 also, your remedy is before the DRT. We will not interfere in these kind of matters, and we will not dilute the purport of, say, the Surface Act. Yes,
My
please
lord,
come.
in that regard, my lord, out of the 54 lakhs, I had paid 10 lakhs rupees.
I am not going into the merits of the matter, Mr. Counsel. You have enough time. When there is no notice to the borrower is required before the magistrate,
Please, ma'am.
you happily spent 17 months there. So that you had enough time. Now it's time to repay.
May I request,
The petition
ma'am,
is filed, seeking the following prayer.
please an order not to interfere with the.
No.
So
You are
that
not
I,
entitled, you are not at all entitled.
I
for
undertake
such
to,
relief.
I undertake to
I will
pay
not.
in full within 3 months, my lord.
The present petition is filed.
That's a residential
Seek the
property for the
following
reason.
prayer. The facts of the case are: the petitioner has availed the loan from the respondent bank. And as the petitioner has failed to repay the loan, the loan was declared, the account was declared as NPA. The respondents have initiated the proceedings under the Surface Act. Then the petitioner has approached the DRT by filing SN number 285 of 2024 and also filed IN number 2207 of 2024. An order was passed on 3rd January 2025, whereby the court has
10% of the.
allowed the stay petition and the possession notice dated 13/6/2024 issued by the bank is stayed on unconditional payment, directing the applicant to make a payment of rupees 54,98,000, being the approximate 25% of the outstanding amount of rupees 2 crore 19 lakhs 19 lakhs 95,396.81 within 2 months in 2 installment as undertaken by the counsel for the applicant petitioner. First installment of rupees 27,49,000 shall be payable on or before 2/2/2025 into the loan account with the secured creditor. Second installment of rupees 27,49,000 shall be payable on or before 1/3/2025 with the secured creditor respondent. If the applicant fails to make the payment on or before the stipulated date, the respondent be a bank is at liberty to proceed under the Act. It is also clarified that in case if the applicant defaults in payment as undertaken, the benefits of this order would stand vacated and the respondent be bank is at liberty to proceed further with the measures under the Act. The land counsel for the petitioner submits that the petitioner has paid an amount of rupees 10 lakhs and thereafter, though he has paid the money, the respondents have initiated the proceedings under the Surface Act. And an order was, and they have approached the magistrate under section 14 of the Act, and an order was passed. Questioning that order, he is before this court. It is submitted that, in fact, the petitioner is ready to pay the amount. And
72 lakhs GTMSC amount has been credited to the loan account.
where is that?
It's,
Page number?
please, my, I'm placing the memo, my lord.
What memo? It should
Credit-
contain,
no.
no, there should be a ground in the writ petition.
Subsequent to the filing of this report. Even today, I have been credited with 2.5 lakhs, even today.
Even though
Repeated that. The petitioner, you that.
On 28/8/2025. On 28/8/2025, I got credited with 39 lakhs 58,577.
On 28/11/2025, an amount of 33 lakhs.
claim amount subject to refund.
Huh?
There is clearly mentioned that this.
Yes,
critical
my lord.
First claim amount subject to refund.
18,750 is credited to your,
Loan account.
credited to the loan account.
And on 28/11/2025.
I'm referring to 28/11 only. It is submitted that if a reasonable time is granted the petitioner would be repaying the amount. Then counsel appearing for the respondent, bank submits that the petitioner having approached the DRT by filing the essay had failed to comply with the order. It is submitted that he went to an order passed by the DRT is on, what is the date? When is the order by the DRT? DRT was on 3rd January 2025.
3rd January
Submitted
2025.
that even, it is submitted that even before the magistrate also, right from 2024 till now, till for a period of 17 months, the matter was pending. Under section 14 of the Act, petitioner on one pretext or the other is trying to litigate the matter, and there are no inquiries on the part of the petitioner. It is submitted that he has failed to comply with the order passed by the DRT, and also and it is submitted that when orders are passed under section 14 of the DRT, 14 of the Surface Act, the remedy available to the petitioner is to approach the DRT under section 17. All the more reason that he has already approached the DRT and the present petition is not maintainable. Next part, having heard the counsels on either side, so and so. The petitioner has approached the DRT earlier and an order was passed. For the reasons best known to him, that order is not complied with. When the proceedings under section 14 are initiated, generally in the proceedings under section 14, notice to the borrower is not necessary. However, the petitioner is approached and those proceedings were pending for a period of 17 months. Now, after the order is passed, he comes up before the court stating that some time is granted, he would pay the amount, and also he was submitting on the merits of the matter. This court is not inclined to go into the merits of the matter. In this case, already auction notice is conducted and auction notice is issued and sale is conducted. The Honorable Apex Court time and again has deprecated the practice of the High Court in entertaining the petitions, entertaining the petitions which are arising under the Surface Act. When the separate tribunals are constituted for the effective adjudication of the disputes, the High Court, without making a point that the said case is an exceptional case which warrants the interference of the court under 226 of the Constitution of India, cannot interfere and pass orders. In this case, this court finds no bona fides, or this court finds that it is not an exceptional case which warrants interference of this court under 226. The petitioner has an effective alternative remedy before the tribunal, and this court is not inclined to interfere. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT.
Right.
Highly obliged.
Yes.
Number 32. Ramesh Shirappa Jilla. 32. Ramesh Jilla.
After.
Para 11, my lords. May I read? Para number 11.
Yes.
Page 48. Further, it is noticed that there is a real dispute between the defendant number 1 and plaintiff.
Initial suit.
Initial suit was for declaration and injunction that the sale deed is not binding upon the plaintiff, respond number 1. Later on, I have taken up a contention. I'll just narrate the facts, my lords, in short. The respond number 1 has filed a suit against myself. I am the defendant number 2 and the defendant number 1, stating that the sale deed executed by defendant number 1 in favor of defendant number 2 is not binding upon him, and the same is null and void. My contention is that the defendant number 1, who is my vendor, is the owner of the property by virtue of a gift deed which is executed by the plaintiff himself in favor of defendant number 1. Therefore, on that basis, defendant number 2 was legally the owner, and therefore she has executed a registered sale deed in my favor.
They seek the declaration that is null and void.
Yes.
If deed is null and void.
Now they want to seek that.
Let us see the affidavit filed in support of that.
Please, ma'am. Page number 37, my lords, is the application. Same is in Kannada, my lords.
What it says?
So that since he was not aware about that gift deed, and therefore he could not submit about that to the council, and therefore that
When did you file when was the written statement filed?
Written statement is filed, my lords, in 27/7/2021. 27/7/2021. I have filed my written statement.
In the written statement,
I have
not
taken
your
up
written statement, that is the other defendant.
other defendants also. Other defendant has filed on 16.
Number 2.
I am defendant number 2.
Defendant number 1 is the one in whose favor the
Gift
is
deed was,
executed.
yes, ma'am.
So when did he file?
16/9/2021.
In that he has taken this plea?
Yes, my lords.
Hmm.
A written statement
What
is
is
also.
the, let's now see the finding of the court.
Please. Page number 48, my lords. If I may read, my lords.
Yes.
Further, it is noticed that there is real dispute between the defendant number 1 and plaintiff with respect to gift deed dated 18/6/2018 and also the sale deed dated 13/11/2018. Already the plaintiff has claimed the relief of declaration relating to suit scheduled property. Then if the prior column is implicated in the suit, it will not change the nature of the suit.
Then counsel referring to the petitioner, who is the defendant number 2 before the court submits when the plaintiff has filed an application and order 6/2/17, the court without looking at the material on record and the fact that the gift deed, about the gift deed, there is a mention in the written statement way back on 16/9/2021 by defendant number 1. Why the application is filed at this stage? But what is the present stage?
It is for arguments, plaintiff's arguments.
It's over, evidence is over.
Evidence is over.
It is, now the application for amendment is filed at the stage of arguments. It is submitted that the court, without even considering the fact that the petitioner only to, or the plaintiff only to cover up the latches, has filed this application and allowed the same, considering the submission stay, notice to the respondent. The petitioner shall file, in addition to that, petitioner shall take out hand summons and file a memo to that effect by 13th of March, or else the stay granted by this court stands vacant.
Good.
Number 35, Venkatesh Somreddy.
My lords, petitioner herein is seeking a mandamus regarding police protection, my lords. My lord, she is the owner of
Mandamus for
police for providing police protection, my lords.
why?
My lord, she is the owner of a suit property measuring around 2 acres, which she has purchased through a registered sale deed, my lords. There is a suit which is pending. My lord, my vendor's daughter, she has filed a suit for partition and separate possession. She files it after I have purchased it, my lords. Admittedly, the property is a self-acquired property of my vendor. My lord, what happens is, after I have purchased the property, my name comes to be entered and I cultivated chana dal, my lords. What happens was, even I filed a suit for injunction as against the person who is trying to interfere with my possession. My lord, when the harvest has come, I have cut down the harvest and I have kept it. My lord, they tried to interfere with, they tried to come and take away my harvest, my lords. That is when I called the police. I, called police on 112, my lords. They have come down. They stated that, since this is a civil issue, please do not interfere. So respond number 4 and 5 were asked to leave the premises, my lord. My lord, subsequent to that, I filed a complaint before Directorate of Civil Rights Enforcement, my lords, under provisions of SC/ST. My lord, next day I went to collect the crops. My lord, the police threatened that they will file a FIR against me, and they did file it.
All assuming and taking into consideration all the facts, what is this relief? How can this court issue a mandamus directing them to give a police protection
My
in
lord,
respect of a civil dispute?
no, my lords, I only want to collect the crop which is already lying, my lords.
What is the role of the High Court in giving such an order?
My lord,
Go
now,
before the trial court and seek this way.
my
Please
lord,
come.
my lord, since I already filed a suit for injunction,
That cannot be. If you filed a suit, all the more reason that you should seek this prayer before the court.
My
The
lord.
present petition is filed seeking the following prayer. The case of the petitioner is that petitioner is the owner of the property bearing survey number 43/2 of Talbala Seema, Kunur Hobli and Taluk Koppal district, which was purchased by him by way of registered sale deed on 18/7/2025 from the father of the accused person. Imitation in respect of the property is also carried out, and the RTC in respect of the said property stands in the name of the petitioner. The respondent 4 and 5, claiming to be the legal heirs of the petitioner's vendor, started threatening the petitioner to hand over the scheduled land to them, and the same was denied by the petitioner. They abused the petitioner with casteist remarks, and in that regard, a complaint was raised before the respondent number 3. The petitioner has cultivated the chenna in the scheduled land, and they were ready to harvest and the said crop in the second week of January 2026. The respondent 4 and 5 have trespassed onto the petitioner's land on 28/1/2026 at about 4:30 p.m. and tried to remove the harvest. Petitioner gave a complaint to the police and an FIR was registered. Again on 28/1/2026, there is a trespass. Police officials have arrived at the spot and spotted and stopped respondent 4 and 5 from carrying out the legal acts in the land belonging to the petitioner. Petitioner on the very next day made representation to respondent number 2 regarding the illegal acts of respondent number 4 and 5 and their accomplice. Respondent number 2 has directed respondent number 3 to take legal action in that regard to give protection to the petitioner. It is stated that it is of the paramount concern that respondent number 3, who holds a position of authority and is entrusted with the duty to uphold the law and take appropriate measures, has failed to initiate any action. Hence, the petition is constrained to come before this court and file the instant writ petition. Then counsel appearing for the petition submits that in fact a suit for partition, a suit for injunction is filed, and the same is pending consideration. In view of the civil disputes, the respondent police are not interfering, and there shall be a direction to the respondent to provide direction to the respondent to register the FIR against the respondent 4 and 5 and to provide police protection to the life and liberty of the petitioner and the property. Next para, having heard the counsel to the petitioner present material non-record, the relief has sought for with the petitioner and as prayed in the writ petition cannot be granted. Admittedly, there are disputes between the petitioner and the respondent. In that regard, already petitioner has approached the court and filed a suit. If the petitioner wants any police protection, the petitioner can have the order seek a police protection from the court where the injunction is pending. Then coming to seeking a mandamus directing the respondent to register if FIR is concerned, as per the complaint dated 29/1/2026, if the petition is aggrieved by any inaction on the part of the respondent, the remedy that is available to the petitioner is to file a private complaint before the magistrate, but he cannot come before this court. Accordingly, the petition is disposed of, giving liberty to the petition to avail the appropriate remedies. Yes, next.
Takes notice for R1 to R3.
So and so takes notice, AGA takes notice for R1 to
R3.
R3. Next.
Please.
36, Suraj Malod. Walter.
The petitioner is the club, my lords, engaged in providing recreational activities, my lords. And
What
the
activities?
recreational activities.
What is happening now?
My lords, the respondent authorities without any authority or interfering in the operation of this.
The facts also not to be dictated because facts are all same in all the petitions.
Obliged.
Yes.
Seal number 37.
Lord, I appear for the respondent bank, my lord.
Page 8 is the, my lord, my prayer, 8 and 9.
What is the notice? 13 to notice.
Eviction notice is issued. After 14 my lords, under section 14, eviction notice is issued by the court commissioner. Annexure C is my undertaking affidavit.
Annexure?
C, ink page 17.
What do you say?
Lord, it's a clear case of, my lord, forum shopping. My lord, my learned colleague is there, my lord, along with the memo. Your lordship may kindly, please. My lord, page 9 of the memo may kindly be seen, my lord. My lord, they had approached the DRT, my lord, challenging section 13.4 notice, which came to be dismissed. They also challenged before the DRT, my lord, section 14 order, which also came to be dismissed. My lord, they had filed another suit, my lord, in which injunction was refused. At that instance, my lord, they have come before this honorable court.
Did all these facts were stated in this petition?
No, ma'am, no.
Why?
No, I have no proper instruction in this regard.
Then we will impose exemplary costs on your client for misrepresenting before the court and for suppression of material facts.
No, I shall file affidavit, my lord, stating all these
It is not
facts.
required. When you are coming before the court, is it not your duty? Your duty means your clients
Please.
to tell the facts and bring all the facts. Is it just for the purpose of getting an order from the court?
No, my lord, it is not
It
like
is
that.
misrepresentation and a fraud played on the court.
No, I shall file affidavit narrating all the facts.
Why? Why should you
No,
file an affidavit now?
Or there was a threat of dispossession.
So?
Yesterday morning, in urgency, it was filed. Well, I shall file, my lord, undertaking affidavit seeking apology.
Court will not come to the rescue of clients of this nature.
Lord, the writ petition
Yes, please
itself is not
My
maintainable.
lord, first prayer, my lord, first prayer I will withdraw it. First prayer of my writ petition at page 8, which the eviction notice is challenged. I will file memo to withdraw that prayer. Kindly see an annexure, my lord, and next prayer at page 9. Now, my lord, the subject matter, the property which is mortgage is 68A/12.
All this, you
My lord,
petition
no.
before the DRT, not.
No,
before this
not there. One submission. 68A/12 is mortgage. Now the residential property of petition number 2, which was, my lord, purchased by her father, that is also being taken up. My lord. My request is, if you want to proceed, you proceed with the property which is already mortgage. I'm saying, I'm making submission that which is not mortgage, that is a residential house which belongs to petitioner number 2, who is not a borrower nor a
Where
nothing.
is section 14 order?
Please,
Lord,
ma'am.
page 9, my lord, I have produced section
And what is
14.
the property in 14 order? Let us.
60, my lord, it is 68/A/12.
Where is that order?
Please.
My lord, page 9, your lordship may kindly have, my lord.
Yes.
My lord, page 10 onwards, my lord, the applicant have filed an appeal under section so and so seeking for quashing, setting aside of alleged order. That is, my lord, the judicial magistrate's order was challenged, my lord. My lord, here also they have not taken this stand. This stand is taken, my lord, newly in the suit, which is filed and in which, my lord, interim order was also refused. My lord, and eviction notice cannot be challenged in writ petition, my lord. They had taken, my lord, they had challenged 13.4, section 14. It has been dismissed. They could have very well raised this, my lord, before the DRT, my lord.
On page 15 of the writ petition.
Please come.
On page 15, your lordship, for a moment.
Yes.
My lord, this is the property which is mortgaged.
Hmm.
68A/1/12.
And where is the material to show they're going to take, they're going to take possession of some other property?
My lord, I have said it in my petition. The officials had come.
It is not necessary. Whatever is there in the order, that we will. Why will we pass an order in respect of some other property saying that they shouldn't take possession?
No, with the, what I'm saying is, what is the property which is mortgaged, you do it, my lord, you proceed further. Now the, my lord, the guys.
Where is eviction notice? Eviction notice is in
Please,
respect of which property?
please, my lord, please. It is, my lord, 60, in page 18.
Hmm.
It is 68A/12 in the subject.
My lord,
What
any
is
eviction,
about
my
that?
lord, any eviction, my lord, we'll have to follow as per the magistrate order. The commissioner is also appointed by the magistrate only, my lord. In terms of the magistrate's order, my lord, which has already been upheld in the DRT, we'll take possession, my lord. And this eviction notice was only given to them so that they are informed that we are coming, my lord. This cannot be challenged, my lord. Your lordships are well aware, my lord.
Sing the following prayer. It is submitted, the land council for the petitioner submits that the property which is mentioned in the order in criminal miscellaneous 3 of 2025 is not the property which is mortgaged. They have no difficulty in taking possession of the property which is mortgaged to the bank. It is submitted that an undertaking affidavit is filed before the court stating that if 4 months' time is granted, the entire amount will be cleared. And counsel appearing for the respondent bank has placed before the court the suit that is filed before the senior civil judge at Kumta, that's OS number 8 of 2026. And also essay number 227 of 2025, which was dismissed on 31st December 2025, which was filed questioning the order that is passed under section 14 of the Surface Act. He has also placed before the court
Another essay is at page 24.
another order in essay number 648 of 2024 dated 31st December 2025, which was dismissed, and the same was filed questioning the possession notice dated issued under section 13(4) of the Surface Act. Land counsel appearing for the respondent submits that this is nothing but a pure abuse of process of law, process of court, and in fact the petitioner having suffered several orders and having approached the DRT on several occasions, have come before this court seeking questioning the possession notice. With a possession notice, it is nothing but suppression of material facts. Further, it is submitted that even the submission with regard to the property which is mortgaged, property which is not mortgaged, even that issue cannot be gone into by this court as per the order passed in section 4, as per by the magistrate under section 14 of the Surface Act. This possession notice is issued. It is submitted that the section 14 order is already questioned before the DRT, and the DRT has dismissed it in the essay, in essay number 227 of 2025. It is submitted, and counsel for the respondent submits that the writ petition has to be dismissed as not maintainable, and also for suppression of the facts. This court, having heard the counsels on either side, peruse material and on record. Before going into the merits of the matter, this is a fit case where the case has to be dismissed. The writ petition has to be dismissed with exemplary cause, as the petitioner is indulged in forum shopping and coming before the court with suppression of material facts. The petitioner, having suffered several orders, has failed to disclose the same before this court. Land counsel for the petitioner submits that he'll come up with an affidavit. The affidavit cannot be filed after the facts are brought on record by the respondent. If there are any bona fides on the part of the petitioner, he would have stated all this in the writ petition. The whole endeavor of the petitioner appears to be to get an order from this court by suppressing all these facts. The litigants who are coming to the court with unclean hands are not entitled for any relief from this court while exercising the jurisdiction under Article 226 of the Constitution of India. That apart, the relief as sought for before this court is not maintainable as the petition has an effective alternative remedy. However, in the facts and circumstances, this court, however, considering the submission of the land counsel for the petitioner, this court is not imposing costs. The petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies.
Please.
But tell you,
I'm sorry.
this is not the way.
I'm sorry.
I would have imposed at least for 10 lakhs cost for this
I'm
behavior.
sorry, Milord. It was my mistake.
May I make one submission with respect to the alternate remedy, Milord? Milord, this eviction notice, what they have challenged here, Milord, they cannot challenge it before the DRT also. For the reason being, Milord, what can be challenged?
The writ petition is not maintainable as already the section 14 notice, the order under section 14 is already questioned and this is a consequential order.
Please.
Hence the writ petition is dismissed.
Lord, in so far as petitioner number 2, one request, whatever in the DRT, my lord, in the criminal miscellaneous petition that is the subject matter, let them proceed, my lord.
They say this is in consonance with the order of the magistrate, this is the notice.
Yes, in that, my lord, 68A/12 is the, my lord,
Where
subject.
is the order of the magistrate? You didn't even place it before the court and you want to submit that.
In the possession notice, they have mentioned it, my lord.
Forget about all that. You say, according to him, as per the order of the magistrate, this possession notice is issued. If you want to show to the court that the property that is mentioned in section 14 and this is not one and the same, then I can understand. That also you don't file. Yes, next.
Obliged.
No, complete.
Orders matters. Seal number 38. Sibhuti.
Hearing for the petitioner, madam. 2 weeks time will be granted.
2 weeks time. Next 39.
39.
List after service of notice.
My lords, I seek a date next week, my lords. I seek a date, my lords. Next week anytime.
List is matter in the month of March.
Interim order.
Next interim order, to look at it if it is there, extend 40.
Till number 40.
Sought for vacation of the interim order. Whereas this is a petition.
Could not amend the cost title, my lord. Could not amend the cost title due to Monday there was a threat and subsequently the file went to the board branch.
Petition shall amend the cost title. Is this matter on Wednesday? By the time if the cost title is not amended, the writ petition will be dismissed on the ground. 41.
Please.
41. Saurabh Hegde. S.V. Deshpande.
Good. They have served the memo of calculation, my lord, today. I will take instruction on it. My lord, my humble submission is made be posted to mediation. Now, what the crux of the matter is, my lord, this. My daughter was studying in London, and that's the reason I had availed loan from the bank, financial institution. Now, my lord, in the criminal case, that matter was settled by paying check. They say that some amount is due. They have filed some memo of calculation, my lord. That's the reason I'm requesting.
For request, it is adjourned on 8/1/2026.
No,
Why are you seeking time again?
No, I'm not seeking. Today they have served this calculation memo, my lord.
This is matter on Tuesday.
And if it can be posted to mediation, my lord, once.
Can it be?
No, Your Honor,
Yes,
because
yes.
sufficient opportunity has been given.
Yes,
It will be
42.
posted in the next week, Your Honor.
Yes, 42.
42. Seal number 42. Jay Dachinmat.
District Court fee has paid. Deficit court fee has paid, needful is done.
Now, what about the process to R4?
R4 is, it is already paid.
Already paid. It is submitted that the needful is done. This after service of notice. This 43.
Seal number 43.
This is the matter which
Ishad
was
what?
listed 2 times. I'm told, my lord, senior counsel is arguing in the other court. May I request, my lord, pass over, my lords?
Pass out today, it is not possible.
Tomorrow, my lords?
Tomorrow also not possible. Is this matter in the month of March?
No, my lords, there is an urgency. In fact, it was argued on the last occasion. If my lords permit, I will submit, my lord, on that. My lord. The contesting respondents, they are served, my lords. This is in respect of, my lord, challenge of the election before the, my lord, deputy registrar. Deputy registrar, my lord, during the process of election passes an interim order without assigning any reasons, withholding the, my lord, election of the office bearers. My lord, if the office bearers are not constituted, my lord, the society will be saddled with an administrator. In fact, senior had argued this matter on the last occasion. My lords may kindly recollect. The translated copy of the impugned order is also filed. My lord, writ petitions were filed before this honorable court seeking right to vote. They had also filed, my lord, we had also filed, they are allowed. Then, my lord, they are permitted to vote, elections are held, my lord, all of them cast their vote. But now they have preferred an election petition before the authority, Deputy Registrar of Cooperative Societies. One of the grounds is that, my lord, about 9 persons who had filed the writ petition had died. In fact, my lord, the CEO of the society has issued an endorsement stating that, my lord, none of them have voted, my lord, since their voters list was not at all there in the. But now the Deputy Registrar, in the midst of the, my lord, process of election, because, my lord, election process starts, my lord, once the calendar of events is issued, and, my lord, concludes once, my lord, the office bearers are elected. Now the general election is held. Office bearer election was, my lord, to be held on 2nd. At that time, my lord, he has granted an interim order. My lord, as per the canon of judgments, my lord, that is not permissible. During the course of election, my lord, no authority or even, my lord, the Honorable Apex Court has said the courts also should not intervene. The order may kindly be seen, my lord, I have last time.
Tomorrow.
Yes, 44.
Please.
Seal number 44. VV Somapur, SCG.
My lord, notice was not ordered to respond number 12 to 16, my lord. The notice may kindly be issued to them as well.
To whom it has to be issued?
To respondent number 12 to 16.
12 to 6, notice 12 to 16. Yes, it's 45.
45.
I have served on the respondent by way of hand summons, my lord. Notice is awaited. It's a case of, my lord, injunction against construction of my house. The only relief I am seeking from this honorable court is that I shall file an affidavit stating that I will not claim equity in the event, my lord. That for that he has to be present. Next week, any date, my lords, may I request?
After service of notice, list on Wednesday.
Please.
Yes, 46.
46. Pratap SS.
My lord, respondent number 45 also government, my lord.
Huh?
Chief Superintendent. Respondent number 45 also government, my lord. SCGP may be directed to
You appear?
Uh,
Who are 4 and 5?
Chief Superintendent Central Prison.
Yes, R4 and R5. AGA takes notice. Yes, 47.
Seal number 47. Ramesh Jirule. Ramesh Jirule.
No representation. List after 2 weeks. Yes, 48.
48. Abhinay S. Gurraj.
Same. List after 4 weeks.
4 weeks. Seal number 49.
Please. Lords, as per the direction of this honorable court, I have filed an affidavit, my lords, to deposit the amount, my lords. In the first installment, my lords.
Have you served him?
Sir,
Appear for the
please.
bank?
Please.
Total for rupees 27,000.
Huh?
27 lakhs 57,267. The execution is filed here. During pendency.
As per the joint memo.
I admit my liability to the decretal amount to the critical order due to sudden death of my mother and mine. I hereby undertake a
Not
promise to
23.
pay total amount of to the decree holder in two installment within a period of 8 weeks.
No, madam, it's 27 lakhs.
My lords,
Not 23.
as per they are seeking decree amount, my lords, but we have filed the joint memo before the trial court, my lord, within a short period of 4 months. But due to death of mother, he is unable to pay the amount, my lords.
But
So
that will carry interest.
please, my lords, there is that interest waive off, my lords. Only 23 lakhs 80,000 is
Why will this court waive off interest?
already in the joint memo. They have specifically
Actually-
mentioned 23 lakhs 80,000, my lords.
No. That
Actual
can't be done.
My lords,
transaction is
I'll
for 20
undertake
lakhs,
if
madam.
first installment if I fail, my lords,
First of all, the first issue is with regard to the amount. Whatever is the decree, whatever is the amount you should pay. Why will this court, when the court is granting you 4 weeks time, 8 weeks time, or why will the court waive off the interest?
As per the joint memo, further,
No,
I have
it is
filed,
waived
even I have filed the extension of time, before the trial court. That IA is not considered, please,
Actually, payment is.
Then you pursue the IA. After that, you come back.
There is no order on IA, IA number 2, I have filed memo, I have
That
second
you can't
prayer
do,
is,
Mr. Counsel.
even I have second prayer, to consider my IA, even my IA is not considered,
10 years.
Only 1 month, 1.5 month, only 1.5 month. If I fail, then go for.
You're not understanding what to do. This is
Only-
matter after 3 weeks.
Till then,
Don't stay. Yes, you
only 1.5 month I am asking, If I fail,
can't, please understand, I can't waive off the interest. Why should we?
already the interest has been way off,
Yes.
only 1.5
have
month I
paid
am
20
seeking.
lakhs, madam. The court is declared for
Only
12
1
lakhs. We have
I am
totally
seeking
put up
1.5
8 lakhs.
month, If I fail, in the first installment,
He is not ready to pay your. He is having capacity.
only
to
1.5
pay.
month.
Only dragging the.
If I fail,
He has filed Article 21 Rule 97.
This is matter in the month of March.
Please
Yes,
wait.
next 50.
please.
Heading on is number 50.
My lords, my
Till
apologies,
then,
my lords.
my lords,
I
till then, my
appear
lords.
in item
March
48, my
itself
lords.
is, because I'm not interested to consider it. And why will I grant stay?
Please, please.
Yes.
My lords, 2 weeks time, my lords.
For?
Because of some health conditions, petitioner is.
The amount may kindly be released.
He wants to withdraw the money. Huh?
My lords,
He wants to withdraw the money. Petition shall satisfy the court as to how the petition is maintainable.
It is arising out of.
Huh?
It is arising out of execution proceeding before the consumer court, wherein.
Against that, they filed the writ petition.
Yes, wherein property was put in auction. I am the auction purchaser of one of the property. He is the depositor. But now, my lords, my interest is also hanging now.
I think we have to rewrite the rules for Dharwad High Court. Wow, what is everything is maintainable, right from the inspector to the constable, anywhere, everything, writ petition is maintainable. Every execution is amenable to 227. And from 2023, this matter is pending. And the issue that is raised is about the maintainability. And you don't even answer, 3 years it will be pending.
after the proxy counsel.
What has happened? Regularly, they are depositing before this honorable court. They are satisfying the decree before this honorable court regular intervals. That is going on. My lords,
When will your senior come?
2 weeks, my lords.
2 weeks? No. This is matter on Wednesday.
Amount may kindly.
With the,
Wednesday.
with the court's permission,
I will hear and I'll pass orders.
Please, my lord.
with the
Amount may
court's
kindly
kind
be-
permission, can I make a mention in serial number 48,
Tuesday.
please?
40?
48, I'm sorry, my audio was not working. My apologies. I was trying to point out something in 48. This is the matter from yesterday to today. The court has kept when I was pressing for interim reliefs.
Yes, in this matter.
Serial
you
number
said,
48. Yes, I am pressing for a status quo order because identical matters similar.
Respondent number 2 is the government undertaking.
You said that yesterday when
Yes,
this
yesterday I
matter
have
came
said,
up.
my lords.
You said AAG wants to.
AAG
appear in
wants
that.
to, my lords. In fact, he wants to file, my lords, some objections. In fact, it is a, my lords.
Objections he will file after the first stage. After that is he is seeking for an interim order.
Yes, ma'am.
For
My
that
lords,
you have to argue.
once kindly see the prayer, my lords.
Yes. Yes, 48.
Please.
Please, ma'am. Lord, please be kind enough to take the cost title first.
Prayer number 4. Prayer number 4, inquiry number 50.
Page number 15.
Yes, ma'am. Prayer number 4.
Yes.
Issue a writ of mandamus, any other appropriate writ, order or direction directing respondent 1 and 2 to duty perform its statutory duty as a regulatory body and state nodal agency and to ensure strict compliance with the government orders issued by the respondent number 1. More especially protecting the sanctity of the petition.
That in similar matters already status quo is granted.
That's correct.
Is it so? Is it so?
That
In respect of the very same,
Yes, ma'am.
very same rule.
No, my lord, it is not the same insofar as the same petitioner, but for different projects. What happens is for each project we get a separate government order. Now the respondent number 5 is a private entity. They have a government order, but they need another approval under section 164. They have not yet obtained it. Without that, they're trying to do work on the site. That is my grievance. In identical matters, this court has
And
granted
also
status quo orders.
petitions, without the proper approval under section 164. The respondents are laying the transmission line in the petitioner's land. It is submitted that in the, where is that order? In similar writ petitions. The court has granted status quo in respect of the location mentioned in.
I'm sorry, it's not the same location in respect of similar matters.
In respect of the, what is this location?
But this is,
Where do you mention about, which is the land?
yes, I'll point out. Please see the government order that's at Annexure C.
That way we did not look at the government order. We have to look at your prayer.
That's correct. Now, I've pointed out, please see page 51, WTG coordinates at Kotumagachi village, Gadag district.
In respect of WTG coordinates in Kotumagachi village, Gadag district for its 159.39 megawatt wind power. Just village, Gadag district. So and so takes notice. To take notice for whom?
For R1 only.
Court has ordered notice on the last date, I think, Malad, I've.
On the order?
Yes.
Yes, next.
Very grateful to the court.
My lords, I appear on behalf of respondent number 2, my lords. I seek 2 weeks time to file wakalat on behalf of respondent number 2, my lords.
Yes.
Credit.
51.
So grateful to the court. So grateful.
Number 50. Sharan Basava.
Please. Let's say
I'm obliged,
seek time, 1 week time to file the necessary application. Let's say the respondent counsel on the earlier occasion had filed an LR impleading application to bring the LRs of the deceased respondent. This honorable court, my lords, advised to file an appropriate application or proper provision.
This is matter of 2 weeks. The request of non-counsel petition 52.
Still number 52.
51 and 52, both
52.
same.
53.
2 weeks.
Please.
Still number 53. Prashant S. Vasmani. Girish Yadwad.
Appearing for the appellate. Last occasion, my lords, had short time because the impugned order is in Kannada. May I just pass on?
Take that.
Appellant, my lords, is the defendant 2 and 3 in a suit for partition. Lords, the suit for partition filed by the contestant. I am the appellant. Lords, the defendant number 2 and 3 in the suit. This is a suit for partition. Lords, in the suit, my lords, the share that they have claimed is 1/4. They filed an application under 39 Rule 1 and 2. Restraining a property has been acquired and, my lords, the compensation amount is lying with the SLA. Now, they filed an application under 39 Rule 1 and 2 stating that I should be restrained from receiving that compensation amount. Since the share that they are claiming is only 1/4. But the court ought to have, my lords, restrained. If, my lords, that application is maintainable, then it ought to have restrained only the 1/4 share.
How many are the parties?
Not only one share, because they are the husband, my sister.
Plaintiffs are by how many?
4 sharers.
Huh?
According to him, 4 sharers, Murad.
Lord,
1/4 share is claimed.
Plaintiff is 1 or 2?
2 and 3 are, my lords. Plaintiff is only 1. Plaintiffs are jointly claiming 1/4.
3 in number.
3 in number. They are, my lords, my sister's husband, deceased sister's husband and children. So they are claiming only 1/4 share. And that is what, my lords, is the prayer in the plaint. Now, the application they filed is to restrain me from receiving that amount.
What do you say?
Please, Murad. But at the most, Murad, he could be permitted to withdraw his 1/4 share because, Murad,
That's what he wants.
he says, Murad, he wants to withdraw 3/4 share because there are other 2 sharers in the suit.
Who are they?
Father and mother.
Mother is one of the appellants.
She's with me.
Father,
What the trial court observes is,
father, in fact, the suit was filed at the behest of the father. Father, my lords, had filed a suit earlier.
Come to the plaint.
Please. Lords, page 26 is the plaint.
20?
26 is the plaint.
relevant, my lords, the prayer para, my lords will find it at page 29. There, my lords,
Plaintiff partition separate portion. Plaintiff be jointly awarded 1/4 share in the suit land.
please. Therefore, my lords, what the trial court ought to have done is that they have restrained me from receiving the 1/4 share. Now, my lords, the trial court has passed an order restraining me from receiving the entire compensation amount, my lords. That is, it has to restrict itself to only, my lords, the order to only 1/4 share, because now this father, my lords, who has instigated this suit, he had earlier filed a suit claiming that it is not the answer. In fact, there is a dispute that whether this is an ancestral property or not. We have denied.
They are seeking 1/4 share.
They are seeking
You are
1/4.
entitled for 1/4.
They are entitled, my lords, only if the succeed in the
The
suit.
plaintiff.
I am the plaintiff, my lord. If I
they-
succeed, I'll be entitled to 1/4, and father and mother will be entitled to
How
1/4.
are you concerned about them?
No, no, I'm not, my lord. What I'm,
Take care of it. You are the one.
I'm the
who has
plaintiff, my lord.
filed-
Yes,
who has
yes.
filed the petition.
I filed the application.
So whatever your 1/4 share is, that is protected, that
That-
will
that
be
should be-
protected. If other persons are affected by it, they will come forward. He is appearing for the,
Defend number 1, father, my lords.
yes.
1/4 share is restrict ಮಾಡ್ತೀವಿ ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
Father's claim over this property has already been, my lords, decided by this honorable court. He has taken 30 lakhs money as way of compensation, and he has admitted that he has no right over this property. Now, after, my lords, the settlement in that RFA, lords, he sets up, my lords, his grandchildren to file this suit.
Is not correct. Submission made by the Milord.
No, without going
Please.
into that submission, plaintiff has, you have no objection, you have not, have you filed your objections to that, or in whatever is your
No.
stand? You have not filed. No, as far as the plaintiff's 1/4 share is concerned, let him protect, let that be protected.
That be protected.
Remaining, let the defendant, we'll modify that order to that extent.
Please,
Where is the order?
lords, the
Translated
translated
copy
copy,
is
my
filed
lords,
by
have passed down.
Agreed with the order passed on, I number 4. It's number 273 of 2022, date 29th August 2024. The defendant number,
2 and 3.
defendant number 2 and 3 are before this court. The respondent herein, first respondent herein, is it?
First respondent, my lords, is defendant number 1.
No, my lord, we are the plaintiff. Defendants 1 to,
Respondent number,
but 1 to 4. We are the plaintiffs.
respondent number 1 to 4 are the plaintiffs in the suit. They filed the suit seeking partition and seeking allotment of, seeking partition separate position and sought for allotment of 1/4 share in the sue scheduled property. Now the present IA is filed by the plaintiff to grant temporary injunction against defendant number 3, restraining them from receiving, withdrawing the compensation amount for the suit property.
May I seek my lord's
The-
leave? I seek my lord's leave, my
Yes,
lord.
yes. Suit property, and by order impugned, the court has allowed the application, by restraining the defendant number 3 from receiving the revised compensation amount for the suit property until further orders. Learned counsel appearing for the petitioner, defendant number 3, submits that when the petition is claiming share of 1/4 in the sue scheduled properties, and if at all the prayer, if it, and the court, you ought not to have filed an IA number 4, restraining the defendant number 3 from receiving the entire amount. It is submitted that the plaintiff is not entitled for any amount, even if, for argument's sake, if he is entitled for any amount, that is only 1/4 share, 1/4 of the said compensation amount, but there ought not have been any injunction restraining defendant number 3 from receiving the compensation. Learned counsel appearing for the plaintiff submits that the court had rightly passed an order restraining the defendant from receiving the compensation amount for the suit property. It is submitted that, as submitted by the counsel for the petitioner, they are not entitled to withdraw 3/4 amount. Learned counsel appearing for the defendant
Respondent number
number.
5, my lord.
Huh?
Respondent number 5, defendant number 1, my lord.
The land counsel appearing for defendant number 1 does not dispute the fact that they have not filed any objections to the said IA filed by the plaintiff, and they have not taken any stand with regard to the same. Next para, having heard so and so. The suit is for partition, and the plaintiff has sought for 1/4 share in the suit scheduled properties. Now the property, now the present application is filed restraining the defendant from receiving the compensation, as that is pertaining to the joint family properties. As rightly argued by the land counsel of the petitioner, even assuming that the entire property, that it is from the joint family properties, when the plaintiff is seeking only 1/4 share, the injunction restraining the defendant from receiving the compensation amount for the suit property until further to suit property is without any basis. As he is seeking 1/4 share, he could have protected his, you could have filed an application protecting his interest as far as the 1/4 share of the compensation is concerned. Accordingly, this court is passing the following order. The order dated so and so, passed by so and so, is modified in the respondent, defendant, the petitioner, defendant number 3, shall not, he can receive the 3/4 of the compensation, and 1/4 of the compensation shall be to the
Subject to the result of the suit, because we have.
shall be subject to the result of the suit. And where it will be lying?
Let
Deposit it.
Deposit, please. Nationalized
That shall be
bank.
deposited in the,
May I make one submission, my lord? In respect of, my lord, their share, my lord, 2 shares to be allotted to the, my lord, appellant share in, my lord. Half portion of the, my lord, award amount to be granted to them, my lord, not 3/4, my lord, my humble submission.
That's what I was asking. When you have come you have entered into the court, but you didn't submit on that.
But, my lord,
They have not objected. He's appearing for the father. Father, my lord, has already, my lord, there is.
No, this petition is filed. That's what I'm saying.
Please,
Petition is filed by the plaintiff. He seeks 1/4 share.
Please,
He
my lord.
wanted the entire amount to be, then when in that application, what you are supposed to say, at least have you raised saying that I am also one of the co-sharer. This is my share of the property. So no, it shouldn't be. That's why I've asked you.
No,
You didn't even respond.
He's stopped from doing that. He's stopped from doing that because of.
The petitioner petitioner is entitled to withdraw 50% of the amount, and the remaining 50% of the amount shall be kept in the fixed deposit, and which is subject to the result of the suit.
Please.
Yes.
Number 54.
Lord, this matter, my lord, last occasion your lordships permitted me to file a rejoinder to the objection to the application in implement of the secretary, my lord. The matter pertains to, my lord, overlapping of 2 cooperative societies. The issue involved is whether a cooperative society has got a locus standi to challenge the formation of another cooperative society. The matter, my lord, has been.
We'll take it on Wednesday at 2:30, because I have to take up the 2:30 matter at 3:45 now.
Please.
Yes. This matter on Wednesday, 2:30. I'll list it at 3:45, so that I'll complete the list. And yes, then, yes, 55.
My lord, I am for the 55.
Your matter is not yet called, please wait.
Yes.
Respondent.
55.
Grievance of petitioner is laying, my lord, high tension 110 watt.
Huh?
Laying the electricity line, heavy line, passing through the lands of petitioner. The grievance is adjacent to the land of petitioners, government land is available. It can be utilized instead of, my lord, passing through the lands of petitioners. Once the high tension wire is passing through, we are losing, my lord, the valuable rights of the properties,
But
and we are
unfortunately,
unable. No.
You can't raise such objection.
My lord, the earlier writ petition, my lord, kindly I request page number 37. This is third round of writ petitions. First round itself, the court observes like this, my lord. page number 37, your lord. Paragraph 5. As rightly contended by the learned counsel for the petitioners, a perusal of the impugned endorsements dated 16/12/2022 will indicate that the sole only ground on which the objections of petitioners were rejected is that procedure for obtaining permission from the various departments would consume a lot of time, and consequently an alternative route across the petitioners' lands and other private lands was identified by the response for the purpose of drawing the electric lines or erecting towers. In my considered opinion, apart from the fact that aforesaid reasons assigned by the response, which is also statutory body,
Now, on these
which could-
kind of grounds,
Please.
if they stop laying the electricity lines, which are in the larger interest, and even under the act, you have no right to object for the laying of the
No, if there is-
laying
no.
of the lines.
No,
You
if
can request seek for
the
compensation.
only request is, since there is availability of the other government property, government land is
How long this will
adjacent.
go on? Now, this is one round of litigation is already over. How long this will go on like this?
No, they are not unable, their only reason is it will consume time. Taking permission from government department will
Might
consume
also
time.
be correct.
They are
You
also
getting
will-
your compensation. What is the difficulty?
No, the land will lose the, my lord, capacity of converting into NA and all that. Never it is permitted. And it is adjacent to the
We
city.
can't stall the public.
No. If there is if there is no alternative way, if there is no other land, then it is justified, I can't resist. When there is available 4 acres of land, another to more than 20 acres of land is available,
Who appears?
they can deviate, my lord, the
Appears for corporation. Subsequently, my lord, another petition, annexure N, page 45, by the same petitioner. It was observed, page 45 at annexure N. That's para number 8. In detail, my lords, it was observed, and liberty was reserved to approach the miller's authority. Now, Miller he has approached the authority. Authority has given an endorsement. Now, he can't, my lords, overcome these findings. And even, my lords, for a moment, my lords may kindly appreciate.
What is the present endorsement given?
The endorsement is liberty to approach my lord under section 16.
Under section?
16,
That is for compensation.
please. And insofar as my lord, the claim of the petitioner is concerned, it is covered by lordship judgment by the lordship Justice Shishanan. I have produced along with my objections. That's very larger interest of public is involved. This kind of Miller's objection can't be Miller's considered. I have quoted Miller's para number also in the objection. It is
That is
very covered by
settled, that is settled law. That is settled law.
Please. And even Miller's for a Miller's moment, if we admit whatever the grievance is concerned, it is not so that Miller's, we can't Miller's interfere with the Miller's forest land. That is Miller's, there is rule. If an alternative land is not available, the forest Miller's authorities will give a
File your
permission.
objections also.
I filed objections. In detail, Miller's objections are filed.
Take a
And
chance. This is month, this is the month, in the
Now,
month
Miller,
of March.
one-
I'm not granting interim order.
No.
No, there is
interim order.
Not granting
there is
interim
interim order.
Huh?
There is already interim.
Then we have to hear it. List this matter. as
Limited
part-
period it may be.
List this matter as part heard. If you want.
No, it is not in parted also.
No,
It's
no.
vacating state.
No. It is like this. If you want the court to extend the interim order, it will be heard as part heard on Wednesday. If you don't want the interim order to be extended, it will be heard in the month of March.
They will lay out, they will start laying down.
On
Till
Wednesday.
at least till next date,
Thursday as part heard. Thursday as part heard.
next week.
Yes,
Part
please.
Interim order. Till number 56.
For R1, my lord. There is a delay of 4,644 days, my lord. And you give a short accommodation, my lord, to file
I have
objection.
I have filed a better affidavit along with all the documents.
To file objections to I number 1 of 2025. Does this matter after 2 weeks? Yes, 57.
Number 57.
Kind interim order extend.
Extended. Yes.
Kar Ahmed.
Your Worship, the respondents have filed IA for vacation of stay. Your Worship, in this case, senior counsel from Bangalore is appearing. I have forwarded the copy of vacating stay. We'll file.
I think you made this same submission on the last.
No, Your Worship, see, on the last date, senior counsel appeared. Your
This
Worship,
matter on 18/2 interim order granted earlier is extended till the next date of that.
yes, Your Worship. On the last date, senior counsel appeared, but Your Worship was not inclined to hear the matter. And
Yes.
My lord,
This is a respondent number one is 82 years woman. She has been thrown out by the petitioners. And writ petition not maintainable because this is arising out of a criminal petition in domestic violence case. Law is very clear. Section 28 of Domestic Act is very clear. All proceedings are conducted under the CRPC.
Ask him to come tomorrow.
Any date after 23, Your Lordship. Any date after 23.
You can't ask for it should be convenient to the court also. After 23rd, there are so many matters.
Any date, Your Lordship, after 23.
Oblige.
Tomorrow.
Please.
Yes, next.
Seal number 58. Iskiri Gangadhar.
For petitioner, the respondent number 5 has filed IA for deletion.
Number 5,
My lordship.
filing certain documents.
I will file a statement of objection to the IA filed by the respondent number 5.
My lordship.
IA 1 of 2026 for deletion of parties. Whom to be deleted?
Respondent number 5.
Huh?
Respondent number 5, my lord.
You filed.
Please, respondent number 5 has filed, but
To delete herself.
delete herself.
Already the name of my party has been deleted by the trial court in EP, my lord. But the respondent number 1, 2, 3 had not taken any steps, my lord.
No, when was fifth respondent is deleted, fourth respondent?
My lords, I have given a memo, my lords, in that page number 5, my lords.
Page number?
5, my lords.
Yes.
Dated 19/11/2021, my lords.
Hmm.
Memo filed by the advocate for DHR is with the copy of the order that so and so writ petition, my lords. The relevant portion is earlier memo was filed to delete the name of JDR number 2, my lords. That is respondent number 5. JDR 3. Respondent number 5 herein, my lords. There is no claim against JDR number 3. Hence, in view of the memo, name of the JDR number 3 is permitted to delete it.
Last now served the memo. We will verify and will submit it.
My lordship, one submission, my lordship. In this case, my lordship, there is no claim sought against the respondent number 5. And I request this honorable court to peruse order dated 14/11/2025. There is a conditional stay order. Condition was that 9,25,000 should be paid within 2 weeks from that day, my lordship. Till today, that is not complied.
Shall verify whether they deposited or not. Shall verify and tell.
If the interim, if the amount is not deposited, it is submitted by the land council for the respondent that the petition does not comply with the order dated 14/11/2025. Land council for the petitioner submits that. He will verify the same. This order is passed on 14/11/2025. If the petition has not deposited the amount by this time, the order dated so and so. As per the order, if the amount is not deposited within 2 weeks, the interim order has to be vacated. And it stands vacated.
Another, my lordship, may I request 1 week time may be granted for them, my lordship.
Yes, for what?
Depositing the amount.
Okay.
Sorry, my lordship, I could not hear it. Thank you so much. Grateful, my lordship.
Seal number 59. We hear him. Please. Prakash Basmane.
Lord, pursuant to the Lordship's direction, there was a direction to the state to furnish documents with regarding to the supply of food items to the hostels. Now, my lord, simple, I am permitted to withdraw in view of the pressure that have been given. That petitioner be permitted to withdraw. Lordships have passed a detailed order on the last occasion. So,
What is, why you want to withdraw?
Lord, they have pressurized me to withdraw.
Who?
State.
No. What I said, the land council for the petition submits that for the month of December 2025,
Yes.
the petition has supplied the material. The
Yes.
same is denied with the learned AGA and the council appearing for the respondent number 6. The land council appearing for the respondent submits that after the order, the respondent 6 has supplied the material. Learned AGA shall place the relevant record pertaining to the supply of material for the month of December 2025 and January 2026 by the next date of hearing. Give that.
Yes.
If it is made clear that if any false submission is made before this court by any of the parties, this court will impose exemplary costs and appropriate orders will be passed. Take that. Have you given him the
Yes,
copy?
I'll
Give it to him. Yes, what is this? Please point out.
Let's kindly see memo with which I have produced along with the documents minutes. First page of the mail.
Hmm.
As per the order date of this honorable court, the relevant records pertaining to intents issued by supply of material for the month of July 2025 are produced in this memo. It is submitted that the
Which document?
minutes
in
first on memo I am
this?
first memo first page of mail.
30/11/2025.
Yes.
Ah.
Minutes first memo which first page of my.
As
Yeah.
per the order of the court, the relevant records pertaining to the indents issued and supply are produced herewith. Yes.
Yes.
So
It is submitted.
which shows that for the month of December and January, the sixth respondent has supplied.
The month of January.
Where do you get it?
So far as month of January is concerned, my lord, no indent was issued and no supply was made since interim order is operating.
December we have supplied.
After issuance of work order, my lord, indents were issued, I supplied the materials.
When did you supply?
In the month of December, my lord. On 29th, they issued an indent and thereafter I supplied the materials. Thereafter interim order passed and January.
So your submission is, according to him, he has supplied for the month of December 2025 and January 2026.
Yes.
That is denied by the both of you, saying that you have supplied for the month of December and January. That is his submission also.
Yes, ma'am.
So where is it for the month of December and January he supplied?
These are the
Bills which we have produced, my lord.
indents, my lords, which they have supplied, issued. Indents they have produced along with all the relevant.
That's what you tell the number,
index
page
one.
number.
Yes, my lord. The page number for the for Ankola Taluk, my lord, this is the page number 3 and 4. These are the indents, my lord. Insofar as this concern, my lord, I already supplied. Insofar as the documents which are indents are issued, insofar as these indents are concerned, my lord, already supplied all the materials, my lord. And supply is completed and the bills also is raised, my lord. Insofar as January is concerned, my lord.
Pertaining to December and January.
Yes, December, my lord.
December.
Not January.
Then what happened to January?
January interim order is, my lord, since they have not issued any indent to me.
Then who is supplying?
Insofar as December is.
January, who supplied?
January, no one supplied.
No one supplied. It is
So
still.
without, nothing is required in the month of January.
It is required, my lords, but no one supplied. Because of the stay, neither the petitioner is not at all, my lords, a successful bidder. He did not supply. And the successful bidder also not supplied because of the interim order.
So you please tell the court how you have supplied for the month of December 2025.
Please, I have produced the documents to show that along with the rejoinder, that on 1/12/2025, I have produced the invoice and the indent orders which have been issued along with the rejoinder. That rejoinder has been accepted by the respondent state as well as the private property. This interim order was granted after hearing both the cavator as well as the state. Interim order is not blindly granted. It is after hearing both the sides.
What exactly
Now-
is happening? I'm not able to understand.
And one more
There is
submission.
no- Please wait.
Please.
Why the submissions before this court are made very casually?
Yes.
He says he supplied in the month of December.
I have-
Both of you say that the supplies were made by him in the month of December. Which one is correct?
My lords, the supply was made in the month of December.
Who is the concern for this?
Concern is, my lords,
Which respondent?
respondent number 6.
Our
Supplier.
The respondent number 6.
My lord, he is the private party.
How is he concerned?
Must
Who is
officer.
authority?
Please.
My lord, it is the respondent number 2.
The respondent number 2 shall file an affidavit before this court for the month of December and for the month of January, who supplied the material. According to the petitioner, he has supplied, and according to the learned AGA and learned counsel appearing for the sixth respondent has supplied for the month of December. The affidavit shall be placed on record by 25th, or else the concern shall appear before the court.
With kind permission. Or pursuant to this, my lord, today the contempt was listed before the honorable court. Now, today the contempt petition was listed before the division bench. In view of that, my lord, pressure having been done, I have withdrawn the contempt petition in the morning.
I am not concerned with any of the proceedings. I am
Please, please.
concerned with the
Yes, yes,
transparency
yes,
and the conduct of the parties.
Please,
And the High Court is not, you can't take it for granted, any of it.
please.
Yes.
Lord, I-
The 60,
Seal number 60.
Please.
notice 61.
61. Saurabh Birje.
Arguing counsel is unwell, my lords, may be taken up next week.
Post after 2 weeks. 62.
Interim order may kindly be extended.
Interim order all granted is extended.
Please.
62.
GI
My lord,
Gitchin Mutt.
On behalf of
Can we
respondent
62?
number 5, I filed the Wakalatnama.
Huh?
Respondent number 5.
But he is
In which
submitting for
case?
serial number 61 minutes, not 62.
Yes.
Next 62.
62.
62 minutes, I am for the petitioner. With regard to that passport matter, my lords, no, my lords, they have specifically stated that, my lords, both there are CC.
Both
In
are?
both the case, it was adjourned on the last occasion for the reason that one criminal case, my lords, is at crime stage, and another is in the, my lords, there is a CC stage. Now, my lords, both they have filed charge sheet and both in CC.
Then go before.
Go before the respective courts.
Have you given that information?
My lords, they have given.
Already the order is dictated. Now it is
Yes,
only to be added.
Only to be added.
Accordingly, the division bench of this court has passed the order directing land counsel appearing for the petition submits that in both the cases, the charge sheets are filed before the respective courts. Next, having heard so and so, in the light of the fact that, in the light of the division bench judgment passed by this court, passed by the Kalburgi bench, and also, the charge sheet is already filed. The remedy available to the petitioner is to go before the very same court and seek for, and also file an appropriate application before the court. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Yes,
May I
next.
make one more request, my lords? Since he has to attend, my lords, the conference, the trial court may
The
be
trial
directed.
court, considering the fact that he is a doctor,
A doctor, my lords. He is a
doctor
pediatrician.
to attend some conference, the trial court shall expeditiously consider the petition. Yes.
Grateful.
Seal number 63.
My lords, appear for the respondents in the matter, my lords. I have electronically filed the wakala that's not been put up. I request your lordship to kindly grant 2 weeks time to file statement of objections, my lords.
Yes, what is the writ petition?
The issue is, my lord, it is a very short issue, my lord, that they have deducted the liquidated damages without adjudication. My lord, at the settled position of law is, my lord, when there is an admitted documents or the facts that the delay is on behalf of the principal contract employer.
Issue a writ of mandamus in the nature of a writ directing respondents to consider the letter dated 8/1/2021 issued by the petitioner to the executive engineer.
I am pressing the prior number 3, my lord, which is more important.
Request of the petitioner.
Prior number 3, issue a writ of mandamus or any of the appropriate writ or order in the nature of writ directing the respondent to refund the penalty amount.
Why will we decide this aspect before this?
No, it is because, my lord, the penalty what they had imposed is contrary to the terms of the contract. The contract says that, my lord, they have to deduct only if there is no delay on behalf of the.
Let respondents file their objections.
Please, my lord.
Grateful, my lords. My lords, Sumana Naganan name may be shown, my lords, in the cause list.
For which respondent?
For all the respondents.
For all
BS
the
Kamti name may be
respondents,
deleted, madam.
Naganan takes notice.
Including the respondent number 5, my lord, where the notice has been dispensed.
The respondent shall file their objections within 3 weeks from today, or else the right to file the objection will be forfeited.
Name of BS Kamti may be deleted, madam. Name of BS
Delete,
Kamti.
The name of Mr. B.S. Kamte in the
Please.
name of so and so. Yes, next.
Please.
Grateful, my lords.
Yes,
Seal number 64. Prashant.
Yes.
My lord, senior counsel is, my lord, engaged in this matter, my lord. Kindly,
Not there, what to do?
kindly pass for, my lord.
For any urgency?
Please, my lord.
Tomorrow? Yes. Now, I'll call the matters where there is urgency, please mention, or other matters will be adjourned. 65?
65.
I am for the appellant, my lord.
Yes.
For the
Yes.
appellant.
Any stay petition is there?
Anand.
Stay is already granted, my lord. This is ECM.
Yes, admit.
Admit, is not may admit because of
Hearing TCR.
First petitioner is aged lady, my lord. If our matter is admitted, my lord, they are challenging only quantum, my lord. Should not be admitted, my lord.
This is matter after 2 weeks. List is, of TCR is already there. List after 2 weeks. Yes, 66.
Note 66 notes, they have filed affidavit. It is with regard to construction notes. They have filed.
Filed the affidavit?
On last occasion, he has filed affidavit. I sought time to seek instructions. In terms of that affidavit, notes, appeal may be disposed of.
Writ petition, the MFA is disposed of in terms of the undertaking.
One more request, notes. In the meanwhile, let him not put up further construction, any other construction, notes.
My proposed construction till RA is now at the judgment stage, my lord. Whatever it will be decided.
In terms of it disposed of.
Please.
Yes, I'll dictate the order later.
Please, ma'am.
67.
My lord, it is order against the interim maintenance.
My lord,
The
party
proceedings have been stayed by the.
Tomorrow. Yes,
My
68.
lord,
I have filed the wakalat today itself. In this case, I have
Party
filed
has-
wakalat today itself.
Fine.
You've taken on Monday or Tuesday.
There is a stay.
Stay, my lord.
All matters can't be taken on Monday and Tuesday. Thursday.
my
is-
lord, I am filing memo for retirement, my lord, from this case.
If not Thursday, it can be taken up on Friday. And next week, so many matters are coming up. This is a matter on Saturday. 68.
Interim order may kindly be.
Interim order is extended till then. 68. 68.
In this matter, my lords, the execution proceedings are stayed, my lords. My lords, the petitioner, my lords, the
My lord, tomorrow.
suit for
Yes, tomorrow. Yes, next.
Thank you.
Interim order is
69.
extended till then. 69.
69.
For respondent.
And for the petitioner, sir, my lord.
Sunanda,
Compromise decree challenge.
Compromise with decree challenged in this case, your lordship.
Yes. When do you want? After 2 weeks?
Please,
After 2 weeks, 70.
interim order may kindly be extended. ma'am.
Interim order is granted in this.
Please, ma'am.
Interim order extended till then. 70.
Let's,
For 70.
impleading application is allowed when the matter was posted for judgment. It's on a very short point, and on 20th, the matter is there in the trial court.
Yes, this matter day after tomorrow.
Please.
71. 71.
71. Very good. Manjunath Huga.
The wife petition for my lord, the enhancement of interim maintenance.
Yes, any interim order in this?
No, my lord.
Yes, let's this matter after 2 weeks. 72.
2 weeks. Till number 72. Nagaraj Jappanur. GA.
After
The
2 weeks.
serial number 72, my lord, I filed wakalat for respond number 4 today.
So and so, submitter has filed wakalats for respondent number 2. Yes,
Respond number 4, my lord.
Respondent number 4.
I undertake to file wakalat for respond number 3 also.
He undertakes to file wakalats for respondent number 3. Yes, 73.
Shivraj Kumar. Till number 73. Anandar Kolli. KR Kamble. Sangram S. Kulkarni.
Copies of impugn judgment are in the Kannada language, kind. The impugn judgment.
Then why the memo is moved if the implement judgment is in Kannada? Why it should come in the list and then it should be out of list? This is matter after 4 weeks.
4 weeks.
Yes, 74.
Another 4 weeks.
74.
74. Saurabh Bagde.
But this was with respect to rowdy sheeter. My lord had directed them to get the records because I submitted that only there were 3 cases. That check bounce case, one, and other one is during COVID, I was not wearing mask. For that second case, and the third case is which is pending, my lord. And for that they have added me in the rowdy sheeter. My lord had specifically asked them to get the records.
Yes.
That's the order passed is minutes. Day after tomorrow, sir. Some records are missing.
What is the order, let's see?
Lord,
Where is the?
no, page number 12, annexure D, my lord. That is in Kannada, but only the relevant portion I'll.
Then an AGA shall file the objections by 18 to 2, not the order. If the objections are not filed by the time, the concern shall appear before the court. Who is the concern?
That's the
Why he
respondent.
did not appear? Have you informed this to
I
the?
informed,
Where is it? Where is the AG? Ask him to come.
please.
Ask him to come. Who is the concern?
His concern is what's. What's this?
So this is a respect your officers have towards the court.
Minutes we have informed, records have not come available. Minutes, 2 days accommodation, minutes.
Not, I said, if the order, if you are not filed the objections, the consent shall appear. Why he is not before the court?
Please. And have to tomorrow minutes, I will say.
Then I will issue warrants
Kindly have
for his
to
appearance.
tomorrow minutes. kindly.
Where is AAG? Ask him to come. I don't tolerate this kind of attitude from the state. Yes. Ask him to come.
Please.
76.
70 partisans, number 76. Naran Viyaji, AGA, AP Hegde.
But after lapse of 27 years, the petitioners cooperative society amendment came to be set aside.
I
by
am
the-
not hearing the matter. What is the immediate relief you are seeking?
But yes, but in the connected writ petition, there is an interim order not to count the votes. The election was held on 28th of September. Administrator is appointed.
Matter on Wednesday. Yes, 77.
Please.
Bill number 77.
Because of the
Commissioner, Your
interim order,
Lordship,
my lords,
I
entire
seek-
stay is short one for consideration, my lords. Because of the interim order, my suit came to be.
Tomorrow. Yes,
Please.
78.
Tomorrow, 19. Bill number 78, VV Somapur.
My lord, I undertake to appear for the respondent in this matter, my lord.
So and so submit such as instructions to file wakalat on behalf of the respondents. Is this matter in the month of March? Yes,
My lord, next week, my lord.
next week. Everybody want, it can be after a week, it doesn't matter. This in the first week of March. Yes,
Partner matters. Further hearing.
no, other matters we'll see. How many are the pass off?
My lord, on submission, serial number 80, my lord. I undertake to file wakalat for respondent number 2, my lord.
You filed.
Please.
Anyway, it's going to be adjourned. Where is the password matter?
Password. Password matter, serial number 4, list number 1. Mantesh R. Patil, Ramchandra Ma.
Why is it passed over?
I was held up in the other court in the morning.
Is the counsel for the petition?
Shivraj P. Mudhod. Rajshekhar Burji.
May I place, my lord, on record my formal statement in the common, my lord, all the. I am placing my statement, my lord, in all the three matters, my lord, a common statement.
What is this matter?
The connected petition matter, I am for petitioner. The connected matter mode, I am petitioner mode, challenging the compromise petition mode. Annexure mode A. The petitioner is not a party to the compromise mode. My grandmother filed a suit for declaration. Lord, that suit came to be decreed. Lord, defendant.
When was the suit declared?
Lord, suit decreed on 22nd November 2007.
2000?
7. Lord.
Hmm.
So after that, no defendant one filed regular appeal. Lord, I am not a party to the RA proceedings. Lord. Behind the back of me, not the defendant and plaintiff. Not they have got compromise decree. Not. I am having my share in the ancillary property. That's why I challenge not compromise petition not before this court. Compromise petition is not disposed of before the Lok Adalat. Not may I request not page number 80, the genealogy. Not one not Ambutai not filed suit for declaration not against not.
Suit is for declaration.
Please no. Suit came declaring that not she is the absolute owner of the property not. No, the genealogy may I request not page number 80. This is genealogy.
Yes. Page number 18 of
Page
what?
80.
Huh?
WP 113891.
389. 4.1.
4.2.
Let this go after in the month of March.
Lord,
Yes.
may I request what happened, Lord? The respondent is the in possession of the property, enjoying the Lord.
The objection filed with the respondent is taken out.
Any
Yes.
date may fix.
List on 9th of March.
9th of March.
Yes, next.
Password matter, serial number Seal number 17.
My lord, I am for the
Officers.
petitioner.
Venkatesham Karvi. MB Kanvi.
Yes, please, madam.
My lord, annexatory page number 44, my lord. That the state government recommended the petitioner and the other 11 convict prisoners for
Yes.
the concurrence of the central government.
Sorry, madam, we don't have any. Sorry, we don't have any instruction from concerned department, madam. That is a.
You couldn't have instructions.
No, my lord. We informed to this department also through mail.
This is matter on Friday, next Friday.
27.
Please, grateful, madam.
Yes.
Seal number 25, password matter.
Lordship, at page number 32, impugned order, I have challenged the impugned order. So wherein respondent number 3 levied 12% is forest development tax. Same is declared as unconstitutional in so rate number 4.3 at the Bangalore bench, 43937.
Was,
Page number 30.
is it that 12% tax or what?
Yes, yes,
Huh?
12%. 32, page number 32. Please. Kindly.
Yes, next.
Please.
This further hearing and final hearing matters, let it remain in the list tomorrow also. Yes. Call the 230 matter. End of the list matter, where is it?
End of the list matter. Preliminary hearing. Dr. Prakash. Seal number 1.
In this case, my lord, it is an execution petition.
For the caveat terms.
One more, give me the caveat.
You file caveat.
I filed caveat. My lord. I'm the
Sir?
copy is served my lord, in the afternoon, but I'm ready, my lord. So I'm for the decree holder.
In this case, my lord,
When is the order passed? When is the order passed?
5th of February 2026. And
Colleague was
thereafter,
saying that yesterday it was passed.
yesterday
Yesterday it
they
was
have
passed
filed an
and
application.
yesterday it is.
Yesterday, day after yesterday, they have filed application for break open lock and police sale. That is the urgency that I have.
Yes. Then what were they doing from 5th till now?
So the certified copies were made available very late, and that is why I was,
Where is the order?
order is on annexure M, my lord. Page number 90. In this case, my lord, I had filed an application under section 47. So before coming to this application, may I make a submission that earlier there were 6 sisters and 2 brothers. So 2 sisters filed a suit for partition claiming 1/8 right each against the brothers and the other sisters. That suit came to be decreed. So each person was granted 1/8 share each. And thereafter, a final decree proceedings was passed. And a decree was also drawn. Then 2 of the sisters, they filed execution petition before the honorable court. That is in 2012. And in that particular suit, 5 sisters got compromised along with the other JDRs, that is the 2 brothers. So they gave up their right in favor of the brothers. So the brothers, along with the sisters who had given up the right, they become 7/8 sharers in that particular property in question. So what remains was 1/8 sharer to the present decree holder, who has now set the court for executing in respect of 1/8 share. In that particular petition, I filed an application under section 47, requesting the court that since there is a change in circumstances that I have become 7/8 shareholder in the property in question, as such, in the monetary consideration, the share may be allotted as per section 3 of the Partition Act. This was the request which was made as per the application. Apart from that, the portion which has been allotted in the FDP forms in the mid portion, which is inconvenient for usage of the other 7/8 sharer. And this was one of the ground which was put forth in the application on hand. So the other side resisted in respect of that particular application. And thereafter, evidences were also led. And the present order has been passed in respect of a delivery of, by issuing a delivery warrant before this honorable court. And this is the.
Please, ma'am. The application under section 47 is filed on the premise that there was a compromise between the other decree holders and judgment debtors. The executing court, having considered that when the matter was posted for delivery of possession, this application came to be filed. My lord, has noted, my lord, the entire conduct of the judgment debtors, my lord, if I am permitted to take through the, my lord, order. It's a lengthy order, I will not disturb at this hour. But, my lord, at the time of delivery of possession, my lord, 2009 decree, my lord, they say that only because, my lord, few of the other co-sharers, my lord, compromised, my lord, executing court notes that, my lord, my right accrued under the decree cannot be, my lord, thrown away.
So what they say is in respect of some other decree, the rights of the parties have to be adjudicated.
No,
in
there is,
this
yes,
suit.
that's the confusion, my lord, trying to be created. I'll clarify
I
it.
want it to be adjudicated in this suit.
No, my
In
lord,
this final decree proceedings arising out of a different decree.
not at all, my lords. I'll just clarify. There is only one preliminary decree which has attained finality in the year 2009 itself. 2010, my lord, there was an FDP which was filed by the original plaintiffs. I was defendant number 5 in the suit. I was allotted 1/8 share, being one sister. That is, my lord, not at all disputed. Nowhere it has attained finality. In the final decree proceedings, a decree was also drawn. Thereafter, my lord, the plaintiffs, my lord, parted with them and, my lord, entered into a compromise. Now, the premise for filing this application is only that
The plaintiff has entered compromise with whom?
with the other defendants. There were totally 8 shares, my lord. Now, what the judgment debtors who are facing the execution claim that
What is the result or consequence of that compromise?
result or compromise consequence is that, my lord, he is entitled for 7/8 share. It appears that, my lord, the plaintiffs were given some money, they have accepted and they have, my lord, parted their share in favor of, my lord, the other defendants who are now the present applicants, judgment debtors. So my share is remained undisturbed. That's what the executing court certainly notes. That, my lord, time and again, my lord, I was ready for each and every stage. That wherever you want to give the share, my lord, they took on time and time, my lord. The executing court, in fact, in very detail has observed the conduct of the judgment debtors. That in not, my lord, giving my share, they are not at all letting me to enjoy the fruit of the decree. 2009 decree, I am fighting since then. And this cannot be a ground, my lord, for the section 47 application to nullify, my lord, decree. That's what precisely, my lord, it's a settled position of law.
Are they trying to say that the decree is not executed?
Exactly, my lord, that is the application. In fact, I did not, my lord, submit before my lords regarding the settled position of law, that the executing court cannot go behind the decree that is attained finality in 2009 itself. The only premise is, since we have compromised, the decree has become unexecutable.
Same party who is
Same party. Now the executing court says that cannot be a ground to say that, my lord, decree has become unexecutable. That's why that application rejected, and rightly so in my humble submission.
In respect of the changed circumstances that I have become 7/8 share and she is 1/8 share, I have also filed FDP 11/2022, which is also pending as on today before the Honorable, in order to freshly determine as to whether they are entitled by meets and bounds or as per monetary consideration as per section 3 or not. So this consideration is still pending in FDP 11/2022. When there is a pendency in respect of FDP 11/2022, till then this particular order has been filed. If I succeed in 11.
by filing a petition under section 47, what you want to say that
I want to say that
decree can't be executed.
my lord, let me be very clear that I'm not denying their share. I'm the last person to deny. My only submission is that since it forms in a mid portion, I am ready to compensate.
Where did you say so? Let us see your section 47.
My application may kindly be
See?
Yes, my application may kindly be taken. It is at, if I'm correct, page number 56, my lord.
56.
56. I'll be reading the affidavit that is 57 page. I'll be reading that particular portion. It is respectfully submitted that after passing of the final decree proceedings in FDP number so and so, Jayasri Pramila filed execution 63/2016, and in the said proceedings, the said decree holders so and so Jayasri Pramila and other judgment debtors Shashikala and Leela compromise the said matter with this judgment debtor 1A to 1D, and accordingly the judgment debtor 1A to 1D and 2 have now become the owners of 7/8 share in respect of the entire property. Needless to be mentioned that the present decree holder Srimati Gulabi alias Lakshmi is just 1/8 share in the said property. It is submitted that the suit property is consisting of a composite of building having both commercial as well as residential old and new building, and old building is made up of wood, mud and bricks. As such, division of 1/8 share due to the changed circumstances cannot be achieved, and the decree has become inexecutable. It is further submitted that as per the map.
Yes. There is one more.
No.
Yes, ma'am. I understood.
The thing is, whatever is the
No,
share
that's
of
not, my lord,
the
very,
property,
yes.
no, as per that's what is the application.
That's exactly, my lord, what I'm trying to submit. It's not completely, my lord, as it is being portrayed. In fact, there is another clinching aspect which is in my favor that the executing court has taken note of is, my lord, he was examined as PW1 pursuant to filing of this application. He has categorically admitted that the final decree wherein, my lord, the commissioner was appointed and a portion, my lord, earmarked as EFIJ was allotted to my share. He first admits that it is allotted to my share. That has been acted upon and my name is entered in the revenue records in respect of that property. Already, my lord, that has been acted upon to some extent. Now, delivery of possession when it was pending, my lord, and even now I am told that before the executing court, after suffering this order, it is in fact posted today. They have filed another application through the tenants, again obstructing, my lord, my possession. This is my instruction, not this is my instruction. This is how, my lord, time and again, and even that filing of FDP is also, my lord, creating another hurdle, my lord, in, my lord, securing the decree. If my learned friend had filed, my lord, the translated copies, I would have taken, my lord, through the evidence. But this is what he categorically admits, that a specific portion has been earmarked for me. That has not been, my lord, earlier challenged. That FDP order, my lord, is not challenged by him. Now in 2010, my lord, the earlier decree is passed. In FDP of 2010, the date, my lord, that was disposed of, I'll just, my lord. That is, my lord, 17/7/2012.
My lord, this 17/7/2012 was the FDP order. And thereafter, they filed execution, that the first set of plaintiffs and other plaintiff, they filed on
No,
2009
decree, when will it attain finality?
My lord, my cause of action comes only after the compromise that has taken place in the execution petition.
When was the compromise taken
Then
place?
compromise was on 21/2/2018.
When is
And
2018?
7 years.
They filed
We're in
execution.
2026.
Your Honor, immediately they filed execution on 26/6/2018. And I filed application on 9/9/2025.
We'll hear it on some other day.
Please.
But since the delivery warrant, if it is issued, then I'll be totally, this particular writ will become infructuous, and equally the contentions that are still pending in FDP 11/2022 will also become infructuous. So in my submission.
This is heights of litigation. How after the decree is granted and what kind of.
My lord.
In fact, my lord, the executing court
denying
has.
the share of the other.
No, that's what exactly the executing court observes. Time and again they say they don't deny my share, but they don't let me, my lord, enjoy that share.
My lord, let me complete my submission. My lord, I'm not trying to deny 1/8 share. What I am requesting the court is that whatever value, let it be fixed by the court. I am ready to pay that 1/8 share.
That may not be permissible in execution, my lord, proceedings. If he wanted that, my lord, he would have challenged the final decree. But that's not permissible in executing court.
Submission is that in respect of, because she is not resident of.
The property which is allotted to you, who is residing in that?
Now, portion of that, my lord, they are residing. The other portion is vacant. And some portions, my lord, as admitted by them, they are held by the tenants. Now, my portion, it is in my name already.
She is residing.
That's what I'm submitting.
She is not residing in.
In the share.
I want to reside therein. I don't have a house.
I'm asking that share allotted to you.
Yes,
What is their difficulty? Who is residing there?
Tenant.
Tenant.
As per them.
Some portions, my lord, there are tenants. There is
As per.
some portion, my lord, there are tenants. It's a property which is very much divisible. That's what, my lord, my precise submission is. The executing court.
When the tenants are able to live there,
Exactly, my lord. That's
my lord.
May I just, my lord, if that may be the submission, but I did not want to trouble. But the order is seen.
Let him complete. My lord, what has happened is that in respect of the ground portion, the tenant is there since more than 30-35 years. That is not my issue. On the upper portion, it has been already fell. So there is no property which is there on the upper. It is because it is made up of wood and brick.
No, who is the owner of the property will not be granted. The tenant who is living for 30 years, his interest will be protected.
No, I am not trying to even protect the tenant also, my lord. I am not even trying to protect the tenant. I am the least person to do that. My only anxiety is my request. Time again I'm making my request. The portion, let me request your honor, the FDP map which has been made. Just one look will show why I am trying to make this particular submission. May I request? Because it falls in mid portion of the property in question, neither this side, neither that side. If it comes in mid portion, I am being a 7/8 shareholder, I'll be unable to enjoy that particular. That is what section 3 of the Partition Act comes into play. It says that in respect of.
This aspect is being stated from 2018.
My lord, since this particular.
And when is it going to, the position, when will it be given to him? You are enjoying the property, you are in occupation, your tenant will be in
My lord,
occupation.
day one, I have been requesting that I am ready to part away in respect of the market value, in respect of the property in question. And that is the reason why I have filed that application on hand. It is not that I am trying to deny. I never said that she doesn't
No,
have.
because you're in property and you're enjoying it, that cannot be a ground to deprive somebody who is entitled
My
for
lord,
it.
my lord, my only anxiety is that if mid portion is given, neither this side nor that side, I'll not be able to even properly utilize and develop the property in question. In those circumstances.
Is
will
it
be
the
very-
way, how it is demarcated?
It is hardly 800 square feet, my lord. It is not that something, it is 800, which is falling on this side and that
First of
side.
all, my lords, as I submitted, this cannot be a question of dispute under section 47 itself. Without challenging, even after the compromise, if that was the case, my lord, they should have challenged the earlier 2012 decree. That is not done. The preliminary decree is not challenged. My lord, section 47 cannot be made use of, my lord, to scuttle my rights, my lord, accrued in 2009. But that's why, my lord, at the cost of repetition, if my lord should permit 5 minutes, my lord, we can read, my lord, the order of the executing court. It has taken note of all these things. But this has been the submission time and again before the executing court that no, I'm not denying, I'm ready to give. But my lord, since 2016, when I instituted, my lord, the execution petition, my lord, 10 years.
Is it feasible that you take one part?
In fact, my lord, that also was before the executing court. That is also noted on 3 or 4 more occasions, my lord, I said, you give any property to me, wherever you want to.
She requested that she wanted a house in Davangere.
Let me
We were
complete.
ready to accommodate that.
No,
She
the
requested-
executing court notes that, my lord, they said, but each time they deprived me.
That.
That's
Even
why
she
finally
wanted
the
to
executing.
What is that you will give it to him now?
In the open court itself, we had offered 55 lakhs in respect of 800
Not
square feet.
55 lakhs, he wants property. Which part of it? Now he says half of it, if it is done, something will happen. So
It has to be redetermined as per the, again, we have to appoint a court commissioner.
No, that will go on, my lord. That's exactly what they're trying to do. The very filing of FDP as I submitted, my lord, is one more attempt to, my lord, to create hurdle in my executing this decree.
Yes.
Almost 30 years will be completed in 2029, my lord.
same-
This is the, my lord,
Same ground.
the
is also
executing court
made
taking note of the.
You can't dictate terms to him that I will pay money, you go off.
And the reason is, my lord, compromise. That may kindly be noted.
My lord-
Reason,
my
their
lord,
compromise cannot be, my lord.
I am making this submission only based on section 3 of the Partition Act. My submissions only on that particular aspect, because since it will diminish the value, equally it will become the non-proper workability in respect of the value of the property in question. That is why I made a request that we are ready to compensate in terms of 1/8 share, whatever the monetary consideration is determined by the court. This is what is my submission even before the trial court also. And that is what I have led my evidence also on that.
My lords are aware, my lord, section 47 does not permit all these things. It's not at all permissible under section 47. This can't be the point of dispute in section 47
My lord,
application.
My brother is, this particular 11/22 in respect of the same subject matter is still pending before the same court, and it runs with the same dates also. It is not that it is on a different dates also. I am ready to, Your Honor, if this particular thing is determined, definitely everything will come out from this particular judgment.
I'm not convinced with that. I'm not convinced that a decree, which was a preliminary decree, which is passed in the year 2009, till 2026, the party is not able to, you are enjoying. You have been in possession of the property right from that time.
My lord, she came into picture only in 2018 after paying the court fee. Till then, she was silent. She was defendant in the original suit also. She was never a plaintiff in the original suit.
It's a partition suit, my lord.
It was a partition. I understand, sir, but it is only in 2018 she paid the court fee, and then she requested for determining her share, and she got that particular share in the same the present execution petition.
When
itself.
earlier that was allotted to her, what did you do? Did you question that order?
Not at all.
That order has never been challenged.
Never been challenged.
I have not challenged. Even FDP also, let me make a fair submission. You have not even challenged FDP
But we
2010
can't-
also. But my request would be, since FDP 11/22 is pending, that will really determine the question. I am ready to go ahead with day to day if it is posted for any trial on that particular aspect of the matter also. But if mid portion is left out, then in those circumstances, again, it will become inconvenient for all the parties before the court.
Why did you, if you're, this situation was very much there,
I had
when an
put
order
forth-
was, when an order was passed in the
My
FDP,
lord,
allotting a particular
three
share.
court commissioners has been appointed in the same.
Why you have not questioned the order in the FDP? Without questioning it, having.
My lord,
kept
at that
quiet.
moment of time, no compromise had happened before the other.
When was the
That,
share allotted
that
to her?
compromise was happened on 21/2/2018. FDP was concluded on 17/7/2012. After 6 years, it was compromised. And that is what is the cause of action.
I'm not inclined to pass any order.
My lord, in this particular possession warrant is also issued, and application for break open and
We
police
can't
raid is
stop,
also
we can't stop,
put
we can't stop
forth by way of an
we can't stall these
application.
proceedings. We can't deprive somebody from enjoying
I am
their
not
property.
depriving, my lord, that is why I am trying to make my submission. I am not depriving her right by way of monetary consideration.
Then that's what I asked. Which part of it you're going to give? For that you say
I'll
again,
make a submission.
somebody has to be.
I'll make a submissions by consulting my client. I'll make a submissions on that. Let it be posted on Monday.
No Monday. Why should we stop when there is an order? Now they're going to take
I'll
position. Why should we
positively
stop?
make my submissions on Monday, my lord. I'll not take you an adjournment.
Monday, the court is not sitting. So you can make a submission tomorrow, I'll post it tomorrow. Tomorrow, till such time not to take any coercive step.
Please.
This matter tomorrow, till such time.
Well, that would more operate as more.
The respondent shall
Let him make submissions because I have to also take instruction on that.
Only tomorrow.
No, I understand, madam.
I am only asking about what is, not about other things.
No, it was earlier, Morad, that was the stage, Morad. On 3 occasions,
What he says.
I requested.
See,
only for a moment, Morad, if I may take my lords only. Page number 104.
this more, yes, next month.
Let there not be any interim order, Morad, to that effect, Morad. Let him submit tomorrow.
Till tomorrow.
Till
Let him
tomorrow,
submit.
I'll not be extending it. What will happen from today to tomorrow? Yes.
Still number 2, Saurabh Hegde.
My instructions
The
are that,
petition-
my lords.
Huh?
Let him.
Yes, what are your instructions?
My instructions are that, my lords, as per section, my lords, kindly see, as per the annexure. Yeah. It is there in the land in survey number 81/A. Whereas, my lords, the better land which has produced at annexure A is, my lords, pertaining to, my lords, survey number 81/2. 81/2. Once kindly peruse annexure A. What he prescribes as a Sarkari betta is 81/2. What he has proposed, he has filed an application to the PDO Gram Panchayat. Is pertaining to in the third para, my lords, 81/A, page number 17.
81 bar?
81/A. It is in Kannada, it is A. This property, according to the, my lords, the respondent situated differently at the different space, different place, my lords. And another instruction is that, my lords,
You mean to say that he has encroached some other property?
some other property, and
That's why they're taking steps to evict.
yes, my lords. My lords, the better land is 81/2 as per annexure A in page number 10.
But encroachment is in 81 oblique?
81/A. That he has to explain. And moreover, he has not produced any photos to show that the earlier bidding was a dilapidated condition and he has taken a permission. And nowhere in the documents which he has produced says issued by the Gram Panchayat, it has not been stated in which survey number this land, this
Yes.
dilapidated house
I'll
is.
make my submission.
Just I will complete, sir.
Yes.
Situated. And another thing is, my lords, kindly see, my lords, his grounds in page number 5. May I take, my lords? Last chapter 10, section 131E, privileges open to the gardeners in the protected forest assigned to them as bettas. Definition: for the purpose of these rules, the term gardeners means the persons in actual possession of the spice garden, whether as a owner or tenant, and garden means the spice garden. Now, this is important. Second one, the gardeners may exercise in the protected forest assigned as betta to the garden or group of gardens for which they are the gardeners. There must be an order of assignment. May I read again, my lords? The gardeners may exercise in the protected forest assigned as a betta to the garden or to the group of gardens to which they are the gardeners the following privileges. These privileges will only come when he produces the order that there is an assignment of betta.
I will show, my lord, where privileges is given. Kindly allow me for 2 minutes. This is the act that he is reading, my lord. Complete act. Yes. Lord, before going to that, kindly come to page number 10, annexure A. He is asking me where the privilege is given. my lord, in the last column, my lord, if my lord sees, last column. In that, my lord will see 39, along with some other numbers, 14, 39, 41. Hope my lord gets that. Yes. My lord, it says, hakkugalu in the sense rights, my lord, privileged rights. Now he denies that I have privilege over the property.
Which property?
My lord, I am not denying, I am saying only that he has not produced any
No, I
document.
will
to
show,
that-
I'll show.
Which property?
My lord,
Respect of which
81,
property?
kindly see, annexure C, page number 12.
Page number?
12, annexure C.
Hmm.
My lord, here in the middle,
Hmm.
it says 81/1A. And kindly see in here only last, this is government record, not mine, my lord. Here only in the last box,
Yes.
my house number is also given 27/1. This is not my record. I have not created this. And kindly come to my lord, the verification, annexure E, that is the verification given by the government official. It is in Kannada, my lord, but I will read.
Where did they mention about the survey number?
Yes, 26/2. My lord, they say 26/2, Mrita Gurupal Anant Bhatt, that is my father, ಹೆಸರಿನ ಪಂಚಾಯತಿನ ಬೇಡಿಕೆ ವೈವೇ ಪ್ರಕಾರ ಹೀಪನಹಳ್ಳಿ ಗ್ರಾಮ ಕ್ರಮ ಸಂಖ್ಯೆ so and so, page number 39 ರಲ್ಲಿ ಆಸ್ತಿ ಸಂಖ್ಯೆ so and so. It says 26/2, which is my house number. They clearly say that I have a property there. This is the verification not given by me.
Now, according to you, in which land of yours the respondents are interfering? Which survey number? Is it 26/2 or 81/A?
27/1, 26 is my house number. That is not my property number. My property is situated in 81
bar A, bar A. 81 bar A.
In 81.
Not in 81/2.
No, what happens is, my lord, it's what he says is in page number 10, RTC with respect to 81/2, I have not, 81/A, I have not produced. He says RTC, he relies on RTC and says that I have produced 2, not 1. A, I have not produced, but 2 I have produced, he says. Let us assume for a moment that I have not relied on this document at all. Their own document says I have a house there. They have given me the number. I have produced the tax paid receipts. It is in existence from like 70 years. My father was residing there. And my lord, with respect to act, what he said, kindly see the act, my lord. The privileges that is given. Subclause 3 says they may erect buildings and
Privileges in respect of which survey number? That is the whole confusion.
80, my lord, 81/A.
Where is that?
My lord, page number 12. Page number 12 is their own record.
Page number 12 is my lord's the form issued by the Gram Panchayat. Where it
Page
has
number
been
12, my lord, kindly see this box. Here,
Is it correct?
My lord, survey number 81/A, 81/A. And whereas annexure A is 81/2.
I'm not relying on annexure A. It was probably some my mistake. I must have produced annexure A, but I'm not relying upon that. This is the government document. This and the verification that they have given. That is not my document.
So what are your instructions? What is happening in 81/A?
It's 81/A, but according to him, my lords, his own document says that his house is situated there, my lords. He, my lords, as per his application annexure F, he has sought for the permission from the PDO Gram Panchayat for renovation of or reconstruction of the house. Whereas he relies, my lords, what are the documents which he has produced? What is the information?
No, I'm not relying on annexure A. I mean, from my mistake, I must have produced that.
Please come to your prayer. Please come to the prayer.
Yes, ma'am.
What are you asking?
No, I'm asking, Lord, mandamus, because.
You are referring to 26/2.
Yes. Yes, 20, only with respect to my house
Then
property.
why are you both arguing on 86?
No, 86 is the survey number, what is.
What is contained?
In survey number, there is a house. House number is this. Survey number is 86. That is what.
Number is?
Survey number, he is denying that survey number, annexure
It is
A.
your document, I am not denying.
So, did you say so in your?
To say so.
In your.
No, I'm only with respect to house number. I don't want anything on survey number.
House number is in a survey number. In that survey number, there should have been occupancy, whatever rights must have been given to you, isn't it?
My lord, once house number is given, my lord, house number is given, I'll be only relying on house number or house property number.
Kindly see the, my lord,
My prayer,
is
I'm
facts.
not relying on any survey numbers. They also admit that I have house in survey number 26/2 because they themselves say, they themselves verify. I
What are
restrict.
you doing now?
Now what happens every time, this is a privileged land from 70 years. What happens, my lord? If crops are cut, some things are done, my lord. Every year we construct some of the walls and we use it for agriculture purpose. Every year this is done from last 70 years. They have verified that. Now the new officer comes, he says for obvious reasons, no. I'm producing the call records also, my lord.
To show the photographs, to show that they are interfering, they are demolishing.
No, my lord, photographs, I have call records. Now what happens is, my lord, they call me, they threaten with dire consequences. See, if you do this, we will do that.
What you are doing?
No.
What they are stopping you from doing?
No, existing house, we are reconstructing it, that's it.
For reconstruction, you don't require.
No,
any
no,
permission.
that is what the act says, my lord. It's a privilege. It says I can erect buildings. There is no, after that I have to take permission from Gram Panchayat, which is already in existence. Gram Panchayat has already issued that it's a privileged land, and they have even mentioned the survey numbers. Now my submission is, my lord, I'm not relying on that survey number, only with respect to house property. Now every year from 70 years we are doing this.
My lords,
They do not get jurisdiction, first of all.
Pleading starts with, my lords, that description. My lords, kindly seeing page number 3. His pleading starts with the, my lord, survey number 81. Survey number 81 situated in Ippadivilla, so and so and so. It is a beta land, and he is using for, according to him, he is using for that.
Correct. Come to paragraph number 3. Paragraph number 3, I have clearly mentioned.
He says, my lords, it is a beta
Kindly see
land.
paragraph number 3.
It is a beta land in that he is making erection in that land. And now he says that it is not, he is not erecting in that land.
My lord, kindly see paragraph number 3. I am only mentioning 26/2.
The different stand is, he has taken, my lords, 81/2, what he states in the, my lords, his petition. And in the next column, he says, now he argues that, saying that he is not taking the, my lord, that contention, he is, there is, the beta land is situated 81/2.
My lord, kindly see my paragraph number 3 of my pleading. I have clearly stated, I am only concerned about 26/2. That is my, where my house is there. Kindly come to, my lord, paragraph number 3.
Please get specific instructions.
Please, kindly
what
have
the
the next week, my lords.
doing
I'll file a.
with regard to this 86.2.
Please.
This house number 86.2
26.
belongs to the petitioner or not? If it belongs, what is that they're doing
Please.
with that?
I'll take instruction.
Exactly. That must.
Please this matter tomorrow,
Lord,
till such time.
Tomorrow it is.
Day after tomorrow.
Lord, on Monday, my lord.
Then I'll not grant any interest.
Or Saturday is okay, my lord. Not.
This is matter on Saturday. Till such time, the respondent shall not interfere with the person of the petitioner. The AGA shall get specific instructions.
Take notice for, my lords, R1 to R4. Take notice for R1 to
To AGA takes notice for R1 to R4.
R4.
Since he is denying that survey number, my lord, I may be permitted to produce the.
Whatever you want to
Yes.
do. Yes.
Great.
Let's call these matters.
230. Number 84. 30 minutes. 84.
Yes.
Nisham Kulkarni.
This last matter, I filed wakalat, my lord, NOC wakalat, in place of Mr. Tata Bangi for R4 to R40. It's not put up. It's not put up, my lord, my name may be shown.
Yes.
On my behalf, my lord, senior counsel appears in last matter. On my behalf, senior counsel is.
Yes.
So any of the objection filed, madam, nothing remains in this petitions. Because we have challenged the order, plus the committee constituted by district judge. based on the scheme in framed in 1920. Plus, by virtue of this act, plus now it is notified temple under section 23, 22. Therefore, 23 and 24, the 22 and 23 follows. Though Supreme Court has not vacated the stay order as far as 25 is concerned, but other parts of the statute remains intact. Therefore, when it is notified temple, automatically government has to constitute a committee, not the district judge. This is the crux of the matter. Now, based on the scheme framed by framed in 1906, in OS number 5 of 1906, the district judge exercise jurisdiction.
Your argument is once this act has come into force.
Yes, sir.
No, whatever the scheme, by virtue of the scheme suit, whatever the scheme that is formulated will not be enforced.
Will not be enforced automatically, because section 23 speaks about that. 23 of the Karnataka Hindu Religious Institution Charitable Endowments Act.
Yes, 23.
Ours is 84.1, Malas. I 84.1 is mine.
Let us see.
Where 23 may can say. Controlling authority, the moment act came into force, the 24 controlling authority, the commissioner shall be the chief controlling authority in respect of all matters connected with the notified institutions, and he shall perform such duties and exercise such powers of the superintendent and control of the state government by rules imposed, or as the case may be, confer on him in respect of all or any class of notified institution. Deputy Commissioner shall, subject to such terms and conditions as may be prescribed, be the immediate controlling authority in respect of notified institutions within his jurisdiction. This is by virtue of act, it is automatic. The moment act came into force.
There must be some other provision in the act. With regard to the earlier arrangements and all, there will be a provision.
25 Malas is the constitution of the committee.
That is there.
Yes, bro.
With regard to notwithstanding anything, where is that clause, provision?
78 Malas.
70?
70. 1 second. 78 Malas.
Let us read
Those are Malas saving clause, repeal and saving clause. If any difficulties are there, section 77 Malas, the state government has to.
Yes.
Therefore, this is notified under 23 admittedly by the government. Therefore, immediately when the act came into force, they have taken control of the institutions. Now, ultimately, Supreme Court said there is a stay order as far as the striking down the act is concerned. Therefore, all provisions are in operation except 25 now. Therefore, district judge has no authority to constitute a committee. It is only government has got powers to constitute a committee.
Oh, section 25 pertains to appointment of trustees.
Plus a constitution of a committee, committee of management.
Constitutional?
Committee of management.
That's what.
Yes.
No, if that is stayed by the Supreme Court, then what is there in place now?
By virtue of section 24, governments get jurisdiction to the deputy commissioner who is the authority to constitute, to manage the institution.
Deputy commissioner will manage all the institutions.
He has to appoint a committee, my lords, because of section.
Appoint the committees in the light of 24 being state. That provision being state by the Supreme Court, cannot do it. So what should happen? Whatever is.
Now it is, now there is, my lords,
Virtue of that, whatever is there before this act, that should prevail now. Something should be, because the ball should be rolling.
no, my lords, what happened? The moment act came into force, all the notified institution, government has taken it over. Plus, the writ petition filed by the, my lords, petitioners were dismissed earlier. Ultimately, my lords, it was quashed by the division bench. Till then, my lords, it was in operation.
No, that's what I'm saying. As of now, even according to you, the entire provisions, the entire act is struck down by this court, which is by the division bench. The apex court at state, as far as 25 is concerned, it is not state. So that means 25 is ineffective.
Ineffective.
So by virtue of that, they cannot appoint any committees for management of the temple. So when they cannot do it, how the temples will be managed?
But 24, there is some difficulty. But however, my lords, when the government has taken it over and notified temple, they automatically the scheme constituted.
So what will happen is the deputy, now whoever is deputy commissioner, assistant commissioner, whoever is the authority for a particular temple, he will monitor the not day-to-day affairs.
Plus, here, not deputy commissioner. Here, my lords, 22 functions are advisory committee is there. They have to constitute a, my lords, committee. Kindly see, my lords, section 22 also.
Section
22. The Dharwad committee has to, my lords, has to manage the
functions of advisory committee.
Functions of advisory committee. There is advisory committee.
Advisory committee consists of whom?
Consists of, my lords, section 20. Here, minister in charge of endowments, who shall be the chairman ex officio, the commissioner who shall be a member of secretary ex officio, and such a number of non-official members.
Dharmika Parishad.
Pardon?
21 is Dharmika Parishad.
20 minutes. 20. Constitutional Advisory Committee.
Rajya Dharmika Parishad.
Yes, ma'am.
No, that is different. Dharmika Parishad is empowered to resolve. Temple is a public, the purpose of it is different.
The term of office of non-official members shall be so and so. Here, my lords,
the purpose of Dharmik Parishad is altogether different.
the functions are also, my lords, enumerated in 22. It shall be a function of advisory committee to tender advice to the committee of management in case of disputes relating to observance of religious practices.
That's what.
Any other matter?
Dharmika Parishad's the role is that they will advise wherever in respect of religious issues and other things. If there is anything to be clarified, they will clarify.
Now there is a vacuum of conflicting decisions of the Supreme Court. On one hand, the Supreme Court has stated the order. All provisions are in operation now.
All provisions are in
Operation.
Wherever nothing is in operation,
A
then
tiger without a teeth.
we have to go back, fall back on how it is before the act has come into force. That is this scheme suit. That order is passed in the scheme suit.
A scheme suit. 5 of 1906, it has 1906. And even section 25, all right, even presuming that district judge has authority to constitute a committee, he has to follow section 25.
What is section 25? What he has to follow?
Yes, ma'am.
No, but no, you are coming back to the same. What is to be followed which is not there in existence? Where is 25? 25 is nowhere.
25 is nowhere.
So, whatever is the scheme suit, whatever is the scheme that is formulated by the court, that will fall.
That automatically merges with the provisions of this act. There is lack of, there is some difficulty in managing the institutions. Having regard to the other provisions of law, if
But
25
I have seen in some other matters, The trust board, they have called for the notification, appointment of trustees.
Appointment, a district judge has called it.
No. Independently, they have issued the notification. In his case.
Manoj, I'm
In your
sorry
case
to,
also district judge?
District judge, no, sir. Very district judge, same temple.
Same temple.
Yes, yes.
Yes, Mr. Senior Counsel, you are appearing for whom?
I'm sorry,
sir,
I'm
if
sorry to
lordship permit,
interrupt. I
I'll-
don't
I'll
want to
take the
interrupt my learned friend. Just wanted to place one aspect on record. The challenge to these Malod's provisions, as my learned friend pointed out, is pending before the Honorable Supreme Court. Those two civil appeals have been heard, and my instructions are judgment is reserved in them on 11th February. So if to put an end to it, Malod's, if your lordships awaits that, perhaps that may be better.
No, that is one aspect, the pending
Yes.
decision of the Honorable Apex Court. What do you
Yes.
say about then what should be done now?
No, I'll tell your
No,
lordships.
we-
My lords,
we
the
cannot-
answer is in my learned friend's affidavit, in the state's affidavit. Please have the affidavit. Please have the affidavit, and then please have section 25B4, 25 capital B. Please have the affidavit filed by the state at para 9.
Whose affidavit?
The state's affidavit.
State has filed the
Yeah,
affidavit.
yes, statement of- statement they have
In
filed.
WP number 104279. That is
Yes,
in
give that.
84.2.
84.2.
My lords, have that affidavit?
Yes, 1 minute.
84.2. 4279.
84.2.
Statement of objection, not affidavit, statement of objection.
Sorry, statement of objections.
When was it filed?
This was filed, it's dated 4th January 26, but appears to be on 4th February.
4-1.
Oh, yes. Let's see.
Yes, please have para 9, page 3.
Paragraph?
9 at page 3 of this
Yes.
counter. I'll just read this out, Mulad. It is submitted that the proceedings conducted by the Principal District and Sessions Judge Dharwad in exercise of powers under scheme in OS number 5 of 1906 are not maintainable in view of the coming into force of the Act. The scheme settled is contrary to the provisions of the Act and is therefore void. Further, it is submitted. Now, this, your lordships may mark this. Further, it is submitted that the Deputy Commissioner is vested with powers under 25 capital B4 of the Act to modify schemes settled by courts and the remedy for any person. So, the state's case also is that, let me assume that it is notified and there is a power of that with the Deputy Commissioner to modify a scheme. But that doesn't, until that modification happens, the scheme does not go away. The scheme continues. In terms of the scheme, today there is a temple committee which is working. Administrator is there, and the administrator has notified and appointed a temple committee. Now, therefore, my lords, other than the fact that the challenge to this act is pending and very close to a judgment because judgment is reserved, in addition to that, it, as your lordships, the question your lordships asked right at the beginning was very pertinent. Once there is a scheme already in existence, even assuming that the act is a valid enactment, even then it will not affect existing schemes unless modified by the Deputy Commissioner under 25 capital B. Which is why under section 78, the repeal clause does not refer to section 92 or schemes under section 92. It repeals several other enactments, but does not repeal section 92 schemes, section 92 CPC schemes, and in fact saves the same by virtue of section 6 of the Karnataka General Clauses Act. We'll file our, I don't think our counter in fact is on record, we can file it, but according to me, my lords, existing schemes, the act will have no application at all unless the scheme is modified by the Deputy Commissioner under 25 capital B.
Kindly be taken into consideration. Understandably, for section 25, its effect has been stayed inasmuch as the earlier stay order granted by the Apex Court of the division bench judgment of this honorable court has been modified only to state that the provisions contained under section 25 is only stayed. If at all, the Requirement was to stay all
25
the operations under
No.
Act.
25 is what?
Only constitution. But my lord,
We are only on that.
once my lord, there is the notification under section 23. The entire earlier my lord, authorities who had got the power to constitute, it goes off. Now, unless my lord, if at all my lord, the Honorable Apex Court had stayed all the provisions of the Act, the entire judgment of this Honorable Court to pass by the division bench.
So the
Then,
other
my lord, it was
provisions,
correct
no,
to
other
assume.
provisions of the Endowment Act speaks about notification of a temple.
Yes, yes.
Who are the authorities? What are the classification of the temples?
So in respect
Who
of
is the
those
competent authority?
Exactly. So in respect of those temples which have already been notified, there is no stay order. That means the Honorable Apex Court wanted the state governments to take control of the temples.
No, there is no stay order.
Exactly,
Then
my
what
lord.
will happen is, even for those notified temples also, when you have to appoint the trustees as per section 25, there is a bar.
That's
true. Whether that
You
would
cannot
not
appoint.
whether that would not straight away give power to the earlier authority, whose authority is now taken away
It
by the
would,
community.
because otherwise how will they run? How will they run? In view of section 25 being, the repealed act, the act.
So, my lord, the earlier constituted committee was permitted to continue by the district judge himself. Those are all aspects, my lord, which are to be brought before the Honorable Court. The very district judge who was, my lord, appointed as
He shall be functioning as per the, as contained in the scheme suit and how it has to happen.
Once, my
I
lord,
know, they have issued the notification now.
yes, my lord.
No,
That
yes,
was
they've
contrary
issued
to
the notification, somebody is questioning it, saying that so and so doesn't possess a qualification. That we will hear, that aspect we can hear.
No, in fact, in this writ petition also, not that is what is questioned. The very authority of the district judge to constitute a committee, once after coming into force of the act.
No,
and there is no interim order.
that we cannot decide. As far as where is the other council is appearing, in that what he says is, one of the conditions for appointment of the trustee is that he should have endowed something by way of land or cash, then only he is entitled to be appointed. And according to them, the person who is appointed is not.
That is a consequential act.
That can be decided. That
Who are
petition
the
can be
persons to
decided.
be, my lord, having the qualified.
No,
power?
if you invite an order on this, then the court has to say in the meantime, when section 25 is stayed with the Honorable Apex Court, the scheme suit will prevail. For the administration. Otherwise, all activities will come to a standstill. One officer.
That is the interim order which is in effect
That would
today.
have been very appropriate if the Honorable Apex Court had, my lord, stayed the entire order. Why it chose to stay only the implication of section 25 is, my lord, new constitution should not be taking place. So that means, my lord, neither the district judge nor, my lord, the state government can constitute. But all other operations under the act, they are, my lord, very much valid and operating. That's precisely my submission is, my lord. Earlier, in the first order, when, my lord, all these petitions were filed before the Honorable Apex Court, the entire judgment of the Honorable Court was stayed.
There are big temples. They can't be managed by an officer alone. And there are so many issues.
So
where
it was
the
not that
trust board is
there was no
required.
committee in place. There was a committee already in place earlier. It was not that, my lord, there was no committee at
So
all.
that 2007, this stay was granted.
Yes.
You mean to say that from 2007 till 2026,
the very
one committee will only function?
No, in fact, I'm sorry, my learned friend should point this out to your lordships. Your lordship said the administrator called for applications for forming a new committee. That new committee has been formed today after several years and after much delay. And after the interim order, which rather a modification of the interim order attained finality till the Supreme Court, then the administrator formed a new committee which is today functioning. So these aspects, my learned friend should place before your lordship.
March.
My matter.
Your matter tomorrow. His matter tomorrow. We'll decide your matter tomorrow.
Extremely grateful.
Sir. No, sir. ಹಂಗ ಇದನ್ನ ನಾ ಮೆನ್ಷನ್ ಇದು RTC ಹಾಕಿ ನಾಳೆ ಸರಿ ಇದ್ದು ತಗೊಂಡ್ಬಿಡ್ತೀನಿ ಆಯ್ತು ನಿಂದ ಅಷ್ಟೇ
ಹೌದು ಸರ್ ಈ ಸೌರಭ್ ಇನ್ನೊಂದು ಇತ್ತಲ್ರಿ ರೌಡಿ ಶೀಟ್
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಕೇಳಿ ಅದೇ
ಅದ serial number 3 ನೋಡಿ ಮೊದಲೇ ಕರೆದಾರ ಬೆಳಿಗ್ಗೆ
ಏನಂತ ಈ ಪೊಲೀಸ್ ಆಫೀಸರ್
ಮೆಡಿಯೇಷನ್